Hello friends, and thank you for visiting the SCDM website and watching this video presentation on government franchises, Form 12.012, brought to you by Sovereignty Education and Defense Ministry at http://sedm.org. And here is a picture of what we're going to talk about. The franchise is what we call a legal cage, and it is set with bait like any trap. It is a trap because the bait is what attracts you into the franchise, and it is offered by the government, and in exchange for taking the bait and being trapped in the trap, you surrender your mobility, your discretion, your choices, your property, and your rights. God predicted this sort of corruption when he said in Jeremiah 5:26 through 31, "For among my, that is God's people, are found wicked, that is covetous public servant men. They lie in wait as one who sets snares. They set a trap. They catch men. As a cage is full of birds, so their houses are full of deceit. Therefore they have become great and grown rich. They have grown fat. They are sleek. Yes, they surpass the deeds of the wicked. They do not plead the cause of the fatherless, or the innocent widows, or the non-taxpayer. Yet they prosper, and the right of the needy they do not defend. Shall I not punish them for these things, says the Lord? Shall I not avenge myself on such a corrupt nation as this? An astonishing and horrible thing has been committed in the land. The prophets, that is the economic forecasters, prophesy falsely, and the priests, that is the judges in franchise courts that worship government as a pagan deity, rule by their own power, and my people love to have it so. But what will you do in the end?" Note the language here. As a cage is full of birds, so their houses are full of deceit. So they can only fill that cage full of birds if they engage in deliberate deception of the people they're trying to trap. And this presentation will talk about all of that sort of deception. If you want to know all the deceit your covetous public servants are telling you, then please watch Foundations of Freedom, Video 4, Willful Government Deception and Propaganda, Form 12.021. And we go into exhaustive details about the deceit that is found in the misrepresentation of the law. That is the method for recruiting people to enter into the trap. And all of that deceit is designed to circumvent the very purpose for the establishment of government, which is to protect exclusively private property and private rights. And the very first thing you do in protecting private property or private rights is to prevent either from being converted into public property or public rights or subject to government regulation of any kind under the civil laws without at least the express written consent of the owner and full disclosure of all the terms, and also the ability to not volunteer and not be injured by a failure to volunteer. If you want a copy of this presentation after viewing the course, you can download it from Liberty University, item 4.1, or our forms page as form 12.012. This presentation comes with a disclaimer, and that disclaimer is that the information we're going to present is educational in nature. We make no promises or guarantees about the effectiveness or accuracy of anything presented. The application of this information to your specific legal circumstances is entirely and exclusively your choice and responsibility. Everything presented is based on extensive legal research and review by our thousands of readers and viewers. The information presented is copyrighted and licensed and subject to our disclaimer and copyright restrictions found on our website. Reading or using the materials makes you subject to our member agreement at the following link. And if you find anything inaccurate in this presentation, our member agreement, Form 01.001, makes it a duty of all members to promptly bring the error to our immediate attention with supporting evidence so that we may continually improve our materials. Your evidence in turn must be completely consistent with our presentation below, entitled Reasonable Belief About Income Tax Liability, Form 05.007. And here is an outline of what we're going to talk about. We'll talk about why this course is important, rights versus privileges, what keeps private rights separate from public rights, what is a franchise, roles and relationships as franchises, franchise contracts and the civil law, franchises are created by loaning property, where may franchises lawfully be enforced, parties eligible to participate in franchises, the effects of participation in franchises, rules for lawfully converting private property into public property, and public versus private franchises, how franchises undermine the Constitution, criminal provisions within franchise agreements, how you consent to franchises, how government unlawfully compels participation, how franchises affect your standing in court, what the Bible and the Founding Fathers say about franchises, legislative franchise courts, such as traffic court and family court, and tax court for that matter, avoiding government franchises and licenses, attacking franchises, legal remedies, conclusions, digging deeper, getting connected, resources, sovereignty, education, and defense ministry, a background on us, SEDM, educational curricula, and finally, questions. So let's start the presentation. Why this course is important. Absolutely every American's life is adversely impacted by government franchises. Nearly every aspect of what most Americans object to about government is implemented by the criminal abuse of civil franchises. Even most attorneys don't fully understand franchises or how to oppose their illegal enforcement, and you must learn how franchises operate to be free, because if you don't, you are doomed to a life of government slavery. Franchises are not a new subject. The concept of franchises are not new. Franchises began originally with the national fast food chains and have since expanded into many other commercial areas. Examples: McDonald's, Jack in the Box, Ben & Jerry's, and so on. And here are just a few of the corporate icons of various different types of franchises for your information. The notion of government as a private corporate business franchise that competes with private industry for revenues in delivering, quote, insurance, unquote, or, quote, social insurance, unquote, or health care, etc., is not something that most Americans have ever even thought about. We will therefore relate and compare private franchising with government franchising so that people are keenly aware of the legal constraints that governments must operate under. This will allow them to protect themselves from monopolistic government abuse and adhesion contracts. So let's talk about rights versus privileges, because understanding the distinctions is important in distinguishing, in this case, private rights, which is what we call rights here, and public rights, which is what we call privileges here. So rights, that is natural rights or private rights, come from and are created only by God. They attach to the land you stand on, like the Constitution itself, and not your statutory or civil status, such as taxpayer, driver, spouse, etc. And here's an example from the Supreme Court in 1922, Balzac versus Puerto Rico. And at that particular point in time, former President Taft was the Chief Justice of the Supreme Court. And here's what he said in that particular case. And by the way, he was the author of the 16th Amendment as well, or at least the proposed 16th Amendment. It is locality that is determinative of the application of the Constitution in such matters as judicial procedure, and not the status of the people who live in it. So, very important point here. Rights attached to land, privileges or public rights attached to status of people on the land, such as citizen, resident, taxpayer, driver, blah, blah, blah. Rights, that is private rights, are unalienable. And the Declaration of Independence explains why. We hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. So the important thing here is that these rights that they're talking about are private rights, also called simply rights. They are not public rights. They are not created by the government. They are not granted by the government. They're granted by the Creator. And the Creator of a thing is the owner of a thing, and anyone in possession of that thing that is owned by others is a servant of the person who created that thing. That's the theory behind most laws within American jurisprudence. The other important thing here is that the phrase pursuit of happiness has been legally defined by the U.S. Supreme Court as synonymous with the right to own private property. Not public property, but private property. You have a right to own, to control all those who use or benefit from your private property. And once again, there are two types of property, private property and public property. Private rights cannot be taken away by government unless their exercise has injured or taken away the equal rights, private rights, of a fellow sovereign. An eye for an eye and a tooth for a tooth. Matthew 5:38. And private rights are vindicated in Article 3 constitutional courts, in the judicial and not franchise courts in the executive branch. Now let's compare and contrast private rights, or simply rights, with public rights, which we call privileges here. Public rights, or privileges, come from and are created by government. Governments can only tax what it creates, and it didn't create human beings. It also didn't create natural law or biblical law. It didn't create the earth. It didn't create anything on the earth other than its own franchises and privileges. And its fake fiat currency system, for that matter. And as we said earlier, government can only regulate what it created. And if it didn't create you, it can't regulate you. So it has to create an office and fool you into volunteering for the office. Privileges, or public rights, may lawfully be acquired or procured through the consent of those not protected by the Constitution and who therefore do not have unalienable rights. The only place such an alienation can lawfully occur is on federal territory not protected by the Constitution. So every franchise they're going to offer you always presumes a domicile on federal territory. And that domicile is either the domicile of the office that is being offered, or the status, that's what we call offices, statuses, or the domicile of the officer who is exercising the office. Those are the two types of domicile we'll talk about. They attach to one's civil status and the public office the status attaches to, such as citizen, resident, taxpayer, individual, employee, a public office in the government per 5 U.S.C. 2105, spouse, marriage license franchise, or driver, driver's license franchise, or notary public, who are all public officers in the state government. So all of these statuses, we call them civil statuses, are a product of the civil law, which in turn only applies to agents and officers of the government, acting in their official capacity. Why? Because the Supreme Court has declared that the U.S. government, and any government for that matter, has no authority to regulate or burden private or exclusively private rights. And public rights or privileges are vindicated or protected only in Article 1 or Article 4 franchise courts in the executive rather than the judicial branch. So, for instance, traffic court, family court, tax court are all Article 1 or Article 4, that is Constitution, U.S. Constitution, Article 1 or Article 4, franchise courts that are in the executive branch. And because they're in the executive branch, technically they're not really courts. They're just the equivalent of administrative binding arbitration boards for disputes inside the government among public officers of the government. They cannot be used by private parties or people exercising private rights. And public rights create an unequal relationship between the franchised or / government and the franchisee / human being. Hence, they destroy equal protection and result in paganism and religion towards government or civil rulers. And they are commonly called benefits in modern parlance, and they are legislatively granted through franchises, and the government is the grantor, and since the government is public, then they are public rights. And they can be taken away at any time subject to the terms of the franchise contract or agreement. And they are paid for through excise taxes upon activities, and those activities are always connected with the thing or the benefit that's being rendered. For instance, when you register your car, you're paying a fee for the privilege of receiving the benefits and protections of the vehicle code upon your vehicle. For an example, see 26 U.S.C. 7701A26, which defines a, quote, trade or business, unquote, as, quote, the functions of a public office, close quote. So the income tax is an example of an excise tax upon an activity, and that activity is the functions of a public office within the national and not state government. All property voluntarily connected with the office is the subject of that tax. And while that property is used in the conduct of said office, the ownership of that property is not absolute, but shared. Black's Law Dictionary calls the sharing of title or ownership of property as qualified ownership. So the ownership of any property used in the conduct of the activity is qualified ownership that is shared with the government, rather than absolute ownership, which is not shared with anyone but the original owner. So what keeps private rights separate from public rights? Rights are unalienable. That is, private rights are unalienable, which means that a right cannot be lawfully sold, bargained away, or transferred to a real government through any commercial process, including franchises. In other words, you cannot lawfully consent to give them away. This is important. And here is the definition, the legal definition of unalienable from Black's Law Dictionary, 4th edition, page 1693. Unalienable, inalienable, incapable of being aliened, that is, sold and transferred. And another important word you see in this definition is aliened. And what really happens here is when you alienate title or ownership of property that started out as absolute ownership and you make it qualified ownership, then you've alienated a portion of the interest in the property. And so that's why they use this word aliened, because you alienate a portion of the interest in the property when you do that. Whenever you donate private property to a public use, whether you pay it as a tax or whether you register a vehicle, you are alienating title or a portion of the title or ownership of the property. Rights are property as legally defined. That's another important thing. No government actor can lawfully take away private property from you without your express consent. This would violate the Fifth Amendment Takings Clause. That's what the amendment's for. And that amendment, like the entire Bill of Rights, only protects private rights. It does not protect public rights. Public rights are owned by the government, at least partially owned by the government. And so ownership of any right that is public is by definition qualified rather than absolute. Consent to give up private property cannot be implied or presumed, but must be provided in the form that you and not the government defines, because the customer or master is always right, and you as a citizen, resident, or inhabitant are the customer of the government, and the government or servant is simply a protection contractor and a private business that delivers to the customer only what he or she demands in writing. These are very important concepts. Article 4, franchise courts in the executive branch, in the case of private property, must dismiss all cases against other than public officers because they lack jurisdiction. This includes the U.S. Tax Court. And they are criminally conspiring to impersonate a public officer if they agree to hear a case involving a non-franchisee. For example, tax court cannot hear a case against a non-taxpayer. See the tax court scam, Form 05.039. And you must voluntarily take an oath and be lawfully elected or appointed into a public office in order to change from a private human being into a public officer. A public officer is the person who fills the office that the government created. In a sense, he is a volunteer, but he has to be lawfully appointed or elected to be treated as if he is a public officer. Otherwise, he's committing a crime. You cannot lawfully or unilaterally elect yourself as a private human being into a public office by simply filling out a franchise form, such as a tax form, license application, etc. See 18 U.S.C. 210 through 211. And it is a criminal conflict of interest for a public officer or benefit recipient to serve as a jurist or voter in which the subject at issue is the subsidizing or paying for their benefits by either tax breaks or the payment of taxes. No one who serves as a jurist or a voter can have a financial conflict of interest over the matters that they're administering. It's simply not allowed. And that means that a jurist who is collecting a Social Security check and who is ruling on an issue in a criminal non-payment of Social Security taxes by anybody, it has a criminal conflict of interest. And the same thing would apply to anybody who is receiving the proceeds from the tax, whether it's a public employee, a judge even, and so on. It is a crime to bribe private human beings with public benefits in order to entice them to elect themselves into public offices using tax forms, license application forms, etc. This is a product of the corruption laws in Title 18 of the U.S. Code, and the fact that they're not being enforced doesn't make them invalid. It simply means that that places like the Department of Justice in both the state and the federal sovereignties are not doing their job and should be demanded to do their job. And you cannot lawfully exercise the functions of a public office in a place not expressly authorized to exercise it. 4 U.S.C. Section 72 says, for instance, that all public offices shall be exercised in the District of Columbia and not elsewhere except as expressly provided by law. So if there's no law authorizing the office to be exercised outside the District of Columbia in a specific identified place, then it is being illegally exercised. The person exercising that authority is impersonating a public officer and hence is a criminal. And this would include most taxpayers, I would imagine. Hence, you cannot exercise federal offices outside the District of Columbia unless expressly authorized, and if you do, you're criminally impersonating a public officer in violation of 18 U.S.C. 912. See Secretary's authority in the several states pursuant to 4 U.S.C. Section 72 on the Family Guardian Sister site. The only place where you can consent to give away a constitutional right is where such rights do not exist, which is only on federal territory not protected by the Constitution. And why is that? Because the Declaration of Independence says that your rights are unalienable, and you cannot bargain away any of them, including through a bribe called benefits. What keeps private rights separate from public rights? Moving on. All the powers of the government, including their civil enforcement powers, are implemented only through either public offices or contracts with private human beings. This is what the U.S. Supreme Court said on this subject in 1824 when the United States government attempted to establish the very first public office within the boundaries of a constitutional state. They said, quote, all the powers of the government, and this would have to include all of its civil enforcement powers against the public, must be carried into operation by either individual agency, either through the medium of public officers or contracts made with individuals. And by this they can only mean private individuals, because if you don't have any contracts, then you're private. And contracts themselves create agency on the part of the other party. And that agency begins at least with the obligation to deliver the benefits of the contract or agreement between the parties. But the important thing to notice here is that all the powers of the government are implemented through agency of one kind or another. And that agency is what Congress regulates. It is not the party performing the agency necessarily, but the agency itself. And the connection between that agency or that office and the private human exercising that office is consent. And in the absence of that consent, there is no one filling the office, there is no office, and there is a crime being committed. And they're identifying here two types of agency, either contracts or offices. So, for instance, if a government attempts to confront you to enforce an obligation that they claim that you have under any of their civil laws, the very first step is for them to demonstrate one of two things. They have to demonstrate that you either lawfully exercise a public office in the case of whatever it is they're trying to enforce, and they have to produce evidence that you consented to that office and that you're lawfully filling it, or they have to present legally admissible evidence that you have a contract with them. Those are the only two ways they can civilly reach you for any kind of an enforcement action. If they can't meet that burden of proof, then the case has to be dismissed and the enforcement action is illegal and a criminal tort. Moving on, whenever government seeks to enforce any civil statute, they as the moving party have the burden of proving on the record the existence of at least one, a lawfully created office, or a contract with you to deliver the property or thing they claim that you owe. That's it. And that's what we just said. Governments are instituted exclusively to protect private rights, as we said earlier in the Declaration of Independence, and any attempt to alienate private rights works against the purpose of government and is not only not a government function, but an anti-government function. It's anti-government because it's against what the government was created to do. They cannot, on the one hand, take an oath to support and defend the Constitution and your private rights, and then on the other hand, turn around and make a profitable business or franchise out of alienating those rights and auctioning them off to the highest bidder. Now, can they? It's an oxymoron that they could even think about doing that. But that is exactly what they're doing if they try to enforce franchises or public rights within the boundaries of a constitutional state. And that's why they can only exercise those franchises and offer those franchises on federal territory not protected by the Constitution, because that's the only condition under which they cannot violate their fiduciary duty to the public, because they don't have any fiduciary duty to people on federal territory. Everything that happens on federal territory, as a matter of fact, is a privilege by definition. Any attempt to presume consent to give up a constitutional right or to infer implied consent is a constitutional tort. And here's what the Supreme Court said on that in Bailey versus Alabama. The power to create presumptions is not a means of escape from constitutional restrictions. So they are not allowed to presume that you consented. They're not allowed to presume that you consented even if you look like you consented. They need to have something in writing, or they're violating their fiduciary duty. And anyone in government who claims the right to alienate your private rights, by definition, therefore, is not a government actor but a private human, and is engaging in a constitutional tort, and cannot be protected by official, judicial, or sovereign immunity, and if he or she is protected by a corrupt judge, is engaging in a protection racket that only protects its own criminal activities and acts of treason. So, once again, what keeps private rights separate from public rights? It is a violation of the fiduciary duty of public officers and a violation of their oath to interfere with or avoid the protection of private rights or undermine them in any way. And here's what the American Jurisprudence Legal Encyclopedia, 2nd edition, volume 63C, says on the subject of public officers and employees. This is their fiduciary duty. As expressed otherwise, the powers delegated to a public officer are held in trust for the people and are to be exercised in behalf of the government or of all citizens who may need the intervention of the officer. Furthermore, the view has been expressed that all public officers within whatever branch and whatever level of government and whatever be their private vocations are trustees of the people, and accordingly labor under every disability and prohibition imposed by law upon trustees relative to the making of personal financial gain from a discharge of their trusts. That is, a public officer occupies a fiduciary relationship to the political entity on whose behalf he or she serves and owes a fiduciary duty to the public. It has been said that the fiduciary duty responsibilities of a public officer cannot be less than those of a private individual. Furthermore, it has been stated that any enterprise undertaken by a public official which tends to weaken public confidence and undermine the sense of security for individual, that is private, rights is against public policy. And as we just said, any attempt to make a franchise out of protecting those rights and charging money for them, or convert those rights into something else for the privilege of protecting them, works to violate this very statement at the end here in red. So they're not allowed to offer it in a state of the union. And if they do, they're committing treason. And they're violating their fiduciary duty, and they're violating their constitutional oath, and they're violating the very purpose for the establishment of government, which is the protection of private rights. And the very first step in that protection is to prevent them from being converted to public rights, even with the consent of the owner. So, what is a franchise? Here is the legal definition. A special privilege, that is a public right, conferred by government on individual or corporation and which does not belong to citizens of the country generally of common right. Okay, so they distinguish here between citizens as private entities, which is what they are in this context, and government or individuals as public entities. Now, obviously, what they're doing here is they're essentially presuming that government and individual are synonymous and that both of them are public in nature, and that citizens are private here. Okay, so moving on, in England it is defined to be a royal privilege in the hands of a subject. And the reason they use the word hands of a subject is because usually it's a physical thing, like a license is, you carry licenses around in your hand, don't you? You carry Social Security cards around in your hand. You carry registrations around in your hand. And whenever a police officer stops you, what's the first thing he asks for? License and registration. And both of those are physical things, and he wants them in your hand before he can enforce the privileges and public rights within the franchise. And that franchise is the vehicle code. And that's why they call it the code rather than the vehicle law. It's a code, it's a contract, it's a compact that only activates or acquires the force of law upon your consent, and you consent by making application to receive a registration or a driver license card. The card is property of the state, and they're loaning it to you. Moving on, a franchise, as used by Blackstone in defining quo warranto, had reference to a royal privilege or branch of the king's prerogative consisting in the hands of the subject. And notice, if you have the king's property in your hands, then you're a subject. And that's the only condition under which you can be a subject. Otherwise, you're private. It says, and must arise from the king's grant, and that grant means a loan. It doesn't mean a gift. It means a loan of property. Or be held by prescription, but today we understand a franchise to be some special privilege conferred by government on an individual, natural, or artificial. Notice they didn't say a human being. They said an individual. Because an individual, by definition, if it appears in the statutes, is a public office. It's not a private human. And so that's how you distinguish with whether they were thinking of you as a private human or a public officer or a public office. It says, which is not enjoyed by its citizens in general. Okay, so these citizens are private, but generally, even even citizen is often treated as a public office, and especially in the case of the Internal Revenue Code. In this country, a franchise is a privilege or immunity of a public nature, hence public office, which cannot be legally exercised without legislative grant. And by grant, once again, they mean a loan and not a gift or an exchange. It says, to be a corporation is a franchise. The various powers conferred on corporations are franchises. The execution of a policy of insurance by an insurance company, e.g., social insurance or Social Security, and the issuing a bank note by an incorporated bank, such as a Federal Reserve note, are franchises. In a popular sense, the political rights of subjects and citizens are franchises, such as the right of suffrage. So they're even referring here to the right to vote as a franchise. It's always been a franchise. And hence, it's somewhat of an oxymoron to describe that right as a right. Technically, it's a privilege. They really, if you wanted to be accurate, you'd refer to it as the privilege of voting. And why do we say it's a privilege? Because it's revocable. You cannot take away a right, but you can take away a privilege. And an example of how your privilege to vote is revoked is if you are convicted of a violent offense, then your right to vote is extinguished. And in many cases, your right to even own firearms is extinguished. But notice we didn't say arms. We said firearms. A firearm is a franchise or public rendition of an otherwise private property called an arm. And that's what the Constitution calls it, arms, not firearms. So what they do is they'll invent a new term for it so they can regulate it. And then they'll fool you into calling it that, whatever that term is. And by using their terms and their words, then you are invoking their protections that they created, and hence you have an obligation to obey every aspect of those protections within the franchise agreement and to pay for the privilege of those benefits. Moving on. Synonyms for the word franchise. Franchises are known by any of the following names or associated with any of the following things: a public right, a public office, a trade or business, which is defined in 26 U.S.C. 7701A26 as, quote, the functions of a public office, unquote, for the purposes of income taxation. It's also called publici juris, or a privilege, or an excise taxable privilege, or a congressionally created right, or a license, or even a Social Security number or taxpayer identification number. And both of these are, in effect, a de facto license to represent a public office in the de facto government, as we'll talk about later. Roles and relationships as franchises. Franchises are a natural outgrowth of the way humans relate. Humans relate and interact through relationships, and each relationship has, quote, roles, unquote, or, quote, statuses, unquote, associated with it. Examples: boyfriend and girlfriend, husband and wife, parent, father or mother, and child, brother and sister, business and customer, employer and employee, clergy and parishioner, government and citizen, attorney and client, petitioner, respondent, and court for civil litigation, or state, defendant, and court for criminal litigation, or trustee and beneficiary, as we used earlier when describing public offices and their definition. Each role or status has both rights and obligations associated with it. And the purpose of that relationship is to regulate that relationship and firmly fix the rights of the parties, just like any contract would do, or any other type of franchise. In law, these rights and corresponding obligations are legally defined as property. And when the obligations of a role or status are avoided or violated, then a theft of property has occurred, enforceable in court against the violator. So now what we're going to do is we're going to show you a video clip from Judge Judy, and she describes her very own husband as, quote, hot property, unquote. Now keep in mind that Judge Judy was a family court judge for 13 years in New York. And what she's describing is that when you marry somebody with a license, you become the other person's property, in effect. A husband is property of the wife. A wife is husband of the property. Or a wife is husband, property of the husband, and so on. So, and we want to emphasize here that people who marry others for property are prostitutes. Any attempt to connect commerce or property ownership to a sexual act is criminal prostitution. So let's watch what Judge Judy says about her very own husband, and in describing him as property and therefore her as a prostitute.
Their relationship began to fall apart. Less than a year after the death of Judy's father, she filed for divorce. The whole thing left a bitter taste in Jerry's mouth, but he still loved Judy and knew deep down that she still loved him. During the next year, Judy dated other people, but she couldn't get Jerry out of her mind. She began to realize that she might have made a mistake when mutual friends told her that other women had their eye on her ex-husband.
He was a hot property. He was a judge. He was available. He had hair.
He had been dating this woman, or just this woman, who was financially very well heeled, lived on Park Avenue, and she told him that he was hot property. I said to myself, this jerk is going to start to believe that he's hot property. I better reel him back in.
I got a phone call, and it was Mom. So they gave me the phone. I said, what's up? She goes, oh, Jerry and I are getting married. I said, what are you talking about? Oh, yeah, we're going over to City Hall. We're getting married. We're going to find a witness, and I just wanted to let you know. I was like, all right, Mom, whatever. Terrific, I'm glad to hear it.
So a somewhat chastened Judy remarried Jerry, this time at a ceremony conducted by a judge who was a friend and colleague.
And when he got to the part in the ceremony where he said, and Judy, do you take Jerry to be your lawfully wedded husband, for better or for worse? And Judy stopped him right there, and Judy said, for better or forget it.
Good video clip, huh? So, roles and relationships as franchises, moving on. Written instruments often, but not always, define the rights and obligation of each role or status. In the case of private relations, these written instruments are called contracts. In the case of public relations, these written instruments are called the civil law. When written instruments do not define the rights and obligations, that is, property associated with each role or status, common convention, custom, or practice usually does. You cannot acquire a role or status or the obligations associated with them without your consent in some form. For private relations, consent is manifested by signing a contract. For public relations, consent is manifested by voluntarily acquiring the civil statutory status of citizen or resident or inhabitant, and we might also add driver under the vehicle code, or spouse under the family code, or taxpayer under the tax code, for instance. So, and they cannot force those statuses or the obligations of those statuses upon you without exercising the equivalent of eminent domain and stealing from you. This is a very important point. And eminent domain is unconstitutional in every state of the Union unless you receive just compensation that you determine and not the state, or that the free market at least determines and not the state. Those enforcing the obligations of a specific role in court, therefore, have the burden of proving that the party who has the private obligation consented to a contract or agreement, in the case of private property, or the party who has the public obligation voluntarily consented to become a citizen, resident, inhabitant, driver, spouse, taxpayer, and so on, and that they consented to the specific sub-role under the civil law, such as driver, spouse, and taxpayer. So what we're emphasizing here is that you cannot be a spouse or a driver under the vehicle code without first being a citizen or resident under the civil code. Why? Because the ability to acquire a status is a product of your domicile. All status is attached to domicile and the law of domicile. And you are not called a citizen or a resident within a specific jurisdiction until you have a domicile there. So if you don't have a domicile there, then you can't acquire any status under any of the civil laws of that place lawfully. And what would you describe such a person as? That person would be called a non-resident. They do not have a residence within the jurisdiction that they're doing business within. So they can't be a taxpayer, driver, spouse, and so on under the laws of that jurisdiction unless they consented to the status within that jurisdiction of taxpayer, driver, and so on, and also had a domicile there or represented an office that had a domicile there. Now, what the government might say if you're a non-resident, let's say you're in Arizona and you're doing business in California and you're not a citizen or resident of California, then you couldn't be a spouse, driver, or driver under the laws of California. And what they might try to do, illegally I might add, is they might presume that you have those statuses even as a non-resident. And if you protest against it, they might say, oh, well, you know, you purposefully availed yourself of commerce in our state and therefore you're under the minimum contacts doctrine, you have that status. Well, that's not true because it's civil law, and civil law activates upon consent. Maybe under the common law you might be subject to the rules, but you wouldn't be subject under the civil laws until you have the status of citizen or resident. That's important. Non-consensual civil roles and statuses. Absent express consent to the role or status, proven with evidence, the obligations associated with the role are not enforceable in court, and any attempt to enforce public statuses against the non-consenting party is unconstitutional eminent domain and a Fifth Amendment taking without compensation, and slavery in violation of the 13th Amendment, and theft of private rights and private property. And that is what you want to holler about and scream about if you ever end up in front of a franchise court and you're not a franchisee. Because as we said, the franchise courts are in the executive branch, and so they're not really courts in a constitutional sense. They're just administrative agencies that can preside only over public officers in the executive branch of the government and within that branch of government. And if they do anything else, they're exercising eminent domain. The above requirements is how governments enforce their equal sovereignty and right to be left alone. Anyone suing them civilly must produce an express waiver of sovereign immunity. Absent proof of such waiver and corresponding consent, the civil case against the government must be dismissed. And the same thing applies to everybody who's not a citizen. If you didn't consent to be a citizen, which is, according to the Supreme Court, the most voluntary of acts, if you didn't consent to be a citizen, then it's a tort to enforce the obligations of that status upon you. It's no different than if you force somebody else at gunpoint or through an alleged obligation and terrorizing correspondence that is warning you that you have to obey. There's no difference between that and terrorism, really. If they're forcing you to do anything, really, that's what the 13th Amendment is all about. It prohibits involuntary servitude. For further details on why you can't be compelled to assume any role or status, see your exclusive right to declare or establish your civil status, available on our website at the links indicated. So, how governments illegally force non-consenting parties into civil roles and statuses. Here are the many ways they do that. It's important to understand all these mechanisms because these are the mechanisms that you need to defend yourself against. They might presume that you have a specific status. This is a violation of due process of law. All presumption that prejudices or undermines private or constitutional rights is a violation of due process. Or they might impose a civil status against the non-resident parties not consensually contracting with the government for protection. An example would be, as we said earlier, if you're in Arizona and California tries to enforce the laws of California against you, and you're either domiciled or resident or at least present in Arizona, then they can't do that if you're not at least domiciled in California. And domicile is a choice. It's voluntary. If you don't want to have a domicile in California, even if you're physically in California, then you don't have to. Moving on, they might try not allowing you to quit franchises and thereby not allowing you to terminate a role or status associated with the franchise. For instance, they might say, oh, well, you got to use a social security number, and no, we're not going to permit you to quit. And no, we don't have any forms and we don't have any procedures to allow you to quit, even though technically you are allowed to quit and the regulations allow you to quit. They'll try to pretend like you don't have the ability to do that so they can continue stealing from you and enforcing the obligations of an office that you don't want. Imagine for a moment what would happen if you went to work for an employer, a private employer, and you quit, and they continue to enforce the obligations of the employment without paying you and without you wanting to be paid. That you would have a tort action in court, and you should have a tort action against the government for the very same reasons. If they will not allow you to quit, or if they say that it's voluntary and then they won't let you unvolunteer, that's fraud. Moving on, claiming that you need an exemption within the franchise, but while refusing to recognize or protect those who do not consent to the franchise and therefore don't need an exemption. For instance, not providing a non-resident, non-taxpayer option on their tax forms. They always rig their forms. They'll rig their forms so that there's no way that you can There's no checkbox, there's no status box in there to describe yourself as a non-resident, non-alien, non-person, or non-taxpayer. There's no way to describe yourself as that. And if you try to fill out a form like that, and you submit it to somebody and they call the IRS will lie literally and say, oh, you're not allowed to do that. And that's fraud because they're interfering with your right to contract. They're interfering with your right to associate, and they're forcing you to contract and associate with whoever it is that you're submitting the form to. And they're not allowed to do that. That's a violation of the Constitution. They might also try rigging the status block on their forms to not offer the civil status associated with non-consenting parties. As we just said, transient foreigner, non-resident, statutory non-person, and non-individual, or not subject but not statutorily exempt. Exempt is a statutory term, and you can't invoke a statutory status if you're not a franchisee and you're not subject to that statute. Or sovereign, all rights reserved. They'll never give you that choice, even though it exists, even though they have to recognize it, even though the common law requires them to recognize it, even though it violates the First Amendment for them to not recognize it, and even though they're compelling you to contract if they refuse to recognize it, they will pretend like there is no such status. Because why? Because it financially benefits them personally, and all they care about is the money, and they don't care about the reason that they were created, which is to protect your private rights. And the very first step is to offer you that option, and thereby protect your private rights by keeping them private, so you never acquire status that they can regulate or tax or burden. All franchises are contracts. And here's what the American Jurisprudence, 2nd edition, Legal Encyclopedia says under franchises, section 4. As a rule, franchises spring from contracts between the sovereign power and private citizens, made upon valuable consideration for the purposes of individual advantage as well as public benefit. And thus, a franchise partakes of a dual nature and character. So far as it affects and concerns the public, it is publici juris and is subject to government control. The legislature may prescribe the manner of granting it, to whom, and by grant we mean loaning the property to, not gifting it or exchanging it to whom it may be granted, and the conditions and terms upon which it may be held, and the duty of the grantee to the public in exercising it, that's you, the recipient of that so-called benefit and that property, and may also provide for its forfeiture upon the failure of the grantee to perform that duty. But when granted, it becomes the property of the grantee and is a private right, subject only to the governmental control growing out of its other nature as publici juris. So the important thing to notice here is that it's a contract between the sovereign power, meaning the government, and a private citizen. So you're private before you do the contract, and after you do the contract, you transferred some of your rights to the franchisee. Just like if you signed a McDonald's franchise, in exchange for the privilege of using their supply chain and their corporate logo and letting them come in and help you build their store. In exchange for that, you have to give up a portion of your profits. That's the property you give them as a condition of the franchise. And the government does the same thing. But once again, it can only do this on federal territory. And if it does it anywhere else, it's violating its fiduciary duty, it's violating the Bill of Rights, and it's turning the government into a whorehouse by trying to sell your private rights to the highest bidder. It always works that way. But the other important thing here to notice is it says that, but when granted, it becomes the property of the grantee and is a private right. So your interest in the property they loan to you is private. And as private, they can't tax it or regulate it. Okay? And until you donate your portion, your interest of the property back to the government by, for instance, consenting to become a taxpayer, and associating that private property and that private right with a public status, only then does it become taxable. Franchises, to be enforceable, must satisfy all the same criteria as contracts. By that we mean you need an offer, a voluntary acceptance, and that acceptance is based on full disclosure of all the obligations, and duress may not be present, and there may be no penalty or for failure to participate by the party offering. Duress makes the agreement voidable, but not necessarily void. And another form of duress, as we said earlier, is for them to say it's voluntary and that yet refuse to protect your right to volunteer. If they won't protect your right to volunteer, there's duress. No question about it. It also requires mutual consideration and mutual obligation. There can't just be one-way consideration. For instance, they can't say, "Oh, well, it's a benefit. It's a public benefit for you to be forced to work for us. And as long as we get to define what the word benefit is, then it's a benefit for you too, and therefore you're receiving consideration." That's not how it's supposed to work. Everybody is supposed to get a benefit as they define it and not as the government defines it. So in the case of the tax system, the benefit is they get revenue so they can conduct the operations of the government, and the benefit for you is you get the services that they're offering. But if you don't want those services, it's not a benefit, and therefore there is no mutual benefit or mutual consideration. It's just theft at that point if they try to enforce the obligations of the office and yet do not want to allow you or protect your right to not volunteer for the office or not be subject to the enforcement provisions of that office. And the other element that they need to be an enforceable franchise is the parties must be of legal age and thereby have the capacity to contract. If you're under 18 and your parents signed you up for Social Security, that's not a valid contract. And at any point, they have to give you the right to quit. And they'll be very secretive about how you quit if somebody else signed up for you. And the reason is because they don't want you to quit. And then they'll say, "Oh, well, you were eligible to receive the benefits, and so you owe us for the cost of delivering those benefits, whether you wanted them or not." Well, what does that sound like? That's theft. They're trying to steal from you because you can't extinguish the obligation and you can't elect to not participate. So you're just a slave at that point. A compelled benefit is not a benefit. It's just slavery and theft disguised to look like government benevolence is all it is. When the government makes contracts or franchises with private parties, it operates in equity on the same level as private individuals and may not assert sovereign immunity. And here's what the Supreme Court said on that subject. The United States does business on business terms. And when the United States, within constitutional authority, makes contracts, it has rights and incurs responsibilities similar to those of individuals who are parties to the instrument. There is no difference, except the United States cannot be sued, that is, under the contract, without its consent. The United States, and that contract is the civil law. If you're not subject to the civil law, then there is no constraint. And it says the United States, when they contract with their citizens, are controlled by the same laws that govern the citizen in their behalf. In other words, you're equal to the government is what they're saying there. You deal with the government in equity. And it's, explaining that when the United States comes down from its position of sovereignty and enters the domain of commerce, it submits itself to the same laws that govern the individuals there. So when you're doing business with the government, you're equal to them. And we would argue that you should never do business with them because they'll always try to be superior to you. They'll always try to rig the game because they write the rules. So that's why the Bible says that you cannot contract with the government. It says wherever the public and private acts of the government seem to commingle, a citizen or corporate body must, by supposition, be substituted in its place. And then the question be determined whether the action will lie against the supposed defendant. So in other words, if you are dealing with a contract with the government and you want to find out whether you're obligated to performing the contract, then you have to substitute the government for a corporate body, a private corporate body, and then you must determine whether there's an action against the defendant as the government. Okay, so they're really describing here a position of equity that the government has in relation to you when they're trying to enforce their franchises. And those franchises include the vehicle code, the family code, and even the tax code. Another important point, all government franchises are implemented through the civil law. All government franchises are implemented in particular through the civil statutory law. And all civil statutory law attaches to your voluntary choice of domicile and residence. And this is exhaustively covered in our form entitled Why Domicile and Becoming a Taxpayer, that is a statutory taxpayer, Require Your Consent, Form 05.002. In other words, you cannot become a taxpayer or a citizen or a resident without consenting, expressly consenting to a domicile in a specific place. And if you don't consent, then you're not any of those statuses, and you don't have the obligations of those statuses. And you must have that domicile, as we said earlier, before you can have a status under the civil laws of that place. Any status: driver, spouse, resident, citizen, taxpayer, and so on. The main difference between franchises offered by private companies and those offered by legitimate de jure governments is that government franchises require domicile or residence as a prerequisite to participate, while private franchises don't. Here's an example. McDonald's can offer a store franchise to people anywhere in the world exclusively through the exercise of their private right to contract. Now, can't they? They're not a government, even though they're a corporation like a government, and the franchises they offer for their stores are a contract. And as long as you sign that contract, they can enforce the provisions of those contracts anywhere you're physically found, or anywhere the choice of law provisions of the franchise itself dictate. And it doesn't matter what your domicile is at that point, because they wrote the rules. When you went in there and you asked for the privilege of a franchise with them, then they made up all those rules to protect their own interests wherever they are, regardless of where you are. However, the U.S. government can only lawfully offer its franchises to statutory U.S. citizens and permanent residents who have in common a domicile on federal territory that is no part of any constitutional state. So, as we said earlier, you must have a domicile on federal territory, because federal territory is the only place the national government can write laws for. They can't write civil laws that apply within a state. If the government offers franchises to those in constitutional states of the Union, then the feds are violating the mandate for Republican government, Article 4, Section 4. Why? Because they're invading a state and they're enforcing their foreign laws up within the boundaries of that state. And they're doing it upon people within that state, and thereby engaging in international acts of terrorism, because the whole goal of that enforcement is to promote commerce with the national government, because that's all they ever care about anyway, is money. And it also violates the separation of powers doctrine, the separation of civil powers, more particularly between the national government and the states. Now, here's another important point. The role or status extinguishes when the domicile extinguishes. And here's what the Supreme Court said on this subject in 1895. If marriage is a civil contract whereby the domicile of the husband is the domicile of the wife, and whereby the contract between them was to be located in that domicile, it is difficult to see how the absence in another state of either party to such a contract from the state where was located the domicile of the marriage could be said to carry such a contract to another state. So they're saying that the marriage as a status is located in the domicile that it was created in, is what they're saying here. Even if we were to concede that an idea, a mental apprehension, or a metaphysical existence could be transmuted so as to become capable of attaching to it some process of a court whereby it might be said to be under the exclusive jurisdiction of such court, if Mrs. McCreary could carry that res, a res is the thing, in the state of Illinois, and by that res they mean the marriage, the status of being a wife in this case, then Mr. McCreary had the same res in the state of South Carolina at the same time. In other words, the same thing could not be in two distinct places at one and the same time, which res the courts of Illinois could have power to control as if it were a physical entity, and which res the courts of South Carolina would have the power at the same moment of time to control as if it were a physical entity. Such a conclusion would be absurd. So they're saying you cannot, a res is treated as a physical thing. So they're treating the marriage as a physical thing, and they're saying it cannot simultaneously exist in two physical places at the same time. And they're thinking of it here as a physical thing because that's what all franchises are. They're a loan of property. And all property is usually a loan or grant of property. And all property is usually physical. So they're treating it here for abstract terms as being physical. Moving on, it says, the jurisdiction which every state possesses to determine the civil status and capacity of all of its inhabitants involves authority to prescribe the conditions on which proceedings which affect them may be commenced, and carried on within its territory. The state, for example, has the absolute right to prescribe the conditions upon which the marriage relation, that is the status, between its own citizens shall be created and the causes for which it may be dissolved. Why? Because they created that status in the civil law. They are the creators of the civil law. They own all the people who exercise rights or privileges under the civil law, and one of those privileges is the right to get married. That's what they're saying here. And the right to get divorced, which is what these people are trying to pursue here. And each person is in a different physical state. And therefore the domicile, they're saying, of the marriage, they have to choose which state that the marriage is domiciled in so they can dissolve it. And there's a conflict of laws here because the two parties are in different states. It says, Charles W. McCreary and Rhonda, his wife, whether it be said their contract should be governed by the laws of the state of New York, where the marriage was solemnized, or whether of the state of South Carolina, which was the husband's domicile, or where he is still domiciled, and where the marriage was to be performed, never agreed that their rights, duties, and liabilities as husband or wife should be determined by the state of Illinois, which is where the wife is at this point, or that the determination of these rights, duties, and liabilities might be had in an action for divorce for sedivitia, where service upon either of them might be made by publication, and when, therefore, a judgment of this last named state was rendered in an action to which Charles McCreary has no real party, such judgment was a nullity to him. Okay? What they're trying to say here is you have to consent to the laws of the place that you want to be enforced against you. And, you know, the wife was located in Illinois in this case, and the husband was located in South Carolina, and the marriage was performed in New York. So you had 3 different states involved. And technically, the domicile of the marriage was New York. The status of being married was in New York. That status itself has a domicile. And the parties who exercise or protect that status also have independent domiciles. In this case, South Carolina and Illinois. And they're trying to figure out which state's laws would apply to dissolving the divorce. And they said that it didn't apply. They said effectively here that the wife's domicile and the declaration of divorce of the wife in the state of Illinois did not apply to the husband, and therefore the divorce was null. It was not enforceable, is what they're saying. So, franchises are created mainly by loaning rather than gifting property. And here's an example from a book on the common law written by a Harvard law professor, Roscoe Pound, in 1925. Quote, how then are purely equitable obligations created? For the most part, either by the acts of third persons or by equity alone. But how can one person impose an obligation upon another? By giving property, in this case loaning property, to the latter on the terms of his assuming an obligation in respect to it. At law, there are only 2 means by which the object of the donor, that is the original owner, could be at all accomplished consistently with the entire ownership of the property passing to the donee. Namely, first, by imposing a real obligation upon the property. Secondly, by subjecting the title of the donee to a condition subsequent. And what they're saying here is they're imposing an obligation upon the status of donee as a condition of receiving the property or giving the property to the donee. And so what they're saying here is the rights established by the gift of property attached to the status of donee in this case. It says, the first of these the law does not permit. The second is entirely inadequate. Equity, however, can secure most of the objects of the donor, that is the person loaning the property, and yet avoid the mischiefs of the real obligations by imposing upon the donee, that is the recipient, and upon all persons to whom the property shall afterwards come without value or with no notice, a personal obligation with respect to the property. And accordingly, this is what equity does. It is in this way that all trusts are created and all equitable charges made, i.e., equitable hypothecations or liens created by the testators in their wills. In this way, also, most trusts are created by acts inter vivos, except in those cases in which the trustee incurs a legal as well as an equitable obligation. An example, you create a trust. You put your house in a trust. You're the original owner, and you're gifting it to the trust. The trust is a legal person, and there are conditions to that loan of the property from you to the trust, and those conditions have to be observed by the trustee. And the notice of those conditions is found in the trust document itself. And it's called an inter vivos transfer because it's a transfer from one life, vivos means life, which is your life, to that of another legal person, and that person is the trust, okay, that as a legal person. And the trustee is an officer or agent of the trust. In that sense, you could say he's a public officer if the property being gifted is public property, okay? And they're saying, in short, as property is the subject of every equitable obligation, notice they use the word every, so the owner of the property is the only person whose acts or acts can be the means of creating an obligation in respect to that property. Moreover, the owner of the property can create an obligation in respect to it in only two ways. First, by incurring the obligation himself, in which case he commonly also incurs a legal obligation, and secondly, by imposing the obligation upon some third person, and this he does in the way just explained. So, to use the house as an example, when you convey the house into the trust, the notice of the conditions of the loan are in the trust document. The trustee is the person who incurs those obligations when he consents to act as trustee, and you cannot force anybody to be a trustee, but once they accept the obligations, they have to conform with the conditions of the trust. And notice they use the word here, equitable, every equitable obligation. What they're trying to establish here is we all start out equal. You're equal, and the trustee, the future trustee, are equal, okay? And you can't make claims on him, and he can't make claims on you that neither one of you consented to unless you injured each other. Okay? So you start out equal, and the relationship becomes unequal, and the other party incurs an obligation they didn't otherwise have and becomes a servant of the trust as a trustee only with their consent. And so you start out equal, and then the gift of property makes you unequal. And it's unequal because the trustee has the obligation of following the terms of the trust, and you don't, okay? Because it's no longer your property. So you create an unequal relationship through consent only. You can never become unequal without your consent. And any attempt to treat you unequally in relation to a government ought to start with an inquiry and a demand on your part to the government to produce evidence that you consented to the obligation, that you consented to the office that the obligation is attached to, and that you consented to become unequal, and that the rights that you gave up were given up while you were physically present on federal territory, because otherwise your rights are unalienable in relation to a real government. Moving on. Here's another example from the Supreme Court that says the same thing. Munn versus Illinois in 1876. When Sir Matthew Hale and the sages of the law in his day spoke of property as affected by public interest and ceasing from that cause to be juris privati solely, meaning private property, that is, ceasing to be held merely by private right, they referred to property dedicated by the owner to a public uses, or to property the use of which was granted by the government, or in connection with which special privileges, franchises, were conferred, unless the property was thus dedicated or some right bestowed by the government was held with the property. And when they use the word held with, they mean the trust. The trust document, when you convey property, it is held with the property. It's inseparable from the property. As a matter of fact, the title of the house that was conveyed into a trust indicates that the owner of that house is the trust. So that's how they got connected, the trust and the property, that is the house, okay? Either by specific grant or by prescription of so long a time as to imply a grant originally, the property was not affected by any public interest so as to be taken out of the category of property held in private right. So in other words, the property is presumed to be private until there's a willful, express intent made, and a declaration made to convey it to the public, to donate it to the public, to donate it to a public officer in trust for the public, and so on. So, and this is a critical thing about the separation between public and private. Property is presumed to be private until it's donated to a public use. And every attempt by a government to regulate the use of private property begins with the government proving that you consented to donate it to a public use. And you can donate it either by changing the title to it, or you can donate it by changing your status and becoming a person subject to the rules of that government, which in turn makes the government essentially share ownership with you. Moving on, franchises are created mainly by loaning rather than gifting property. Maxims of law and biblical proverbs which implement this concept. The rich rules over the poor, and the human borrower is servant to, that is slave to the government lender. So if they lend you stuff, you're a slave and you're their whore until you give it back to them, whatever that is. And if that thing that they loaned was a public right or a privilege under a franchise like Social Security, then you got to quit. You should give them notice that you quit. And you should change your status so their rules don't apply. And here are some maxims of law that say the same thing. He who receives the benefit should also bear the disadvantage. And he who derives a benefit from a thing ought to feel the disadvantages attending it. Bouvier's maxims of law. Now, a critical thing to remember here is who defines whether it's a benefit. And the answer is you do if it affects your rights. If, an example, you may not regard it as a benefit to either receive government services or privileges, but the government might, because they want to collect taxes that they don't have to deliver anything in exchange for. So, but if you don't regard it as a benefit and you tell them you don't want to participate and you fill out an application to quit, or you notify them that you quit and that you don't want to be eligible to receive the benefit, and especially if they call that so-called benefit voluntary, then they have to change your status in their records so you're not eligible. And if they won't do that, if they continue to perpetuate the res or the status that's eligible, then they're stealing from you. And any public right they try to enforce is essentially stolen from you and is a violation of eminent domain within whatever jurisdiction that you're in. When someone loans rather than gifts you something, you become a trustee and the custodian over the thing loaned, and legal strings attached. That's what we talked about earlier. You know, that's how all equitable obligations are created, as that quote from Readings on the History of the Common Law said. They have to gift you, they have to loan something rather than gift it to you, and they have to give notice to you of the terms and conditions of the loan. And at that point, you have incurred an obligation. And however, if those terms are a civil provision of the civil code, you must also have a domicile on their territory before those terms can apply to you. Otherwise, they don't apply at all. Even if you have the property, they don't apply to you. And they try to work around that by saying, oh, well, he's a resident. Well, no, a resident is an alien, a constitutional alien. So no, you're not a resident. And you're not a citizen either if you don't have a domicile. You can't be a citizen or a resident under the civil laws of a place without a domicile in that place. And they try to play tricks with that by all kind of crazy things, including the minimal context doctrine and the Foreign Sovereign Immunities Act and all of these other crazy things that are just completely unfair because they never enforce the same thing against themselves. And until they do, it's just a tort. Because we're all equal, right? And the government cannot make you unequal, even with your consent, if you can't alienate a constitutional right. Now, can you? The only requirement to impose such duties and create the trust relation through the loan are that the property you receive must be in your custody and control, and the property, like a Social Security card or a driver's license or a professional license or a vehicle license plate or any number of other things, the property must remain the property of the party who gave it to you after you take custody, meaning that they loaned you something. You must receive notice of the terms of the loan. That notice is formally furnished by publication in the Federal Register of the terms of the loan, and no physical evidence of your express consent need to be generated to prove consent other than that you accepted physical custody of the property. And as we said earlier, you must also have a domicile if that loan is from the government, because all trust, all such loans are civil law, and all civil law activates or requires the force of law only by you having a domicile in their jurisdiction. Otherwise, they don't apply, because domicile is always a prerequisite to any status under the civil law, just like marriage, as we talked about earlier. Examples of property that uncle loans you to make you into a franchisee. Any kind of status you claim to which legal rights attach under a franchise. Remember, all rights are property. This includes taxpayer, Internal Revenue Code trader business franchise, or citizen or resident, civil law protection franchise, or driver under the vehicle code franchise of your state, or spouse under the family code of your state, which is a voluntary franchise. A Social Security card, 20 CFR 422.103D, says the card and the number belong to the U.S. government. And the back of the card even says that the card must be returned upon request of the government. So you don't own it. It's just loaned to you. And that loan is how they create the obligation. And they also warn you on the back of the card that that use of the card will subject you to penalties. So they're giving you notice of the obligations of the loan of that card, which is property. It says a taxpayer identification number issued under the authority of 26 U.S.C. 6109. All quote taxpayers unquote are public officers or offices in the U.S. government. Per 20 CFR 301.6109-1, use of the number provides prima facie evidence that the user is engaged in official government business called a trader business, which is defined in 26 U.S.C. 7701A26 as, quote, the functions of a public office, unquote, in the U.S. and not state government. Another type of property they can loan you that would make you into a franchisee is any kind of license. Most licenses say on the back or in the statuses regulating them that they are property of the government and must be returned upon request. This includes driver's licenses and contracting licenses. A USA passport. The passport indicates on page 6, note 2, that it is property of the U.S. government and must be returned upon request. So does 22 CFR 51.7. So once again, they're loaning you a property, even in the case of a U.S. passport. And the other interesting thing about the Social Security card up here is that when you go ask for a Social Security card and you fill out an SS5 form, look at the form carefully. What does it say? It says application for a Social Security card. It doesn't say application for benefits. It says application for a Social Security card. So technically what you're doing by filling out that application is you're requesting to receive physical property from the government. And that physical property, in effect, forms the corpus of a public trust. And you become the trustee and custodian over that property that was loaned to you. And any transaction that you use that property in connection with becomes private property donated to a public use to procure the benefits of a franchise. Moving on, more examples of property that uncle loans you to make you into a franchisee. Any kind of government ID, which including state resident ID cards. Nearly all such IDs say they belong to the government. This includes common access cards used in the U.S. military. A vehicle license plate is another example. Attaching it to the car makes a portion of the vehicle public property. Stock in a public corporation. Any stockholders in public corporations are regarded by the courts as government contractors. Did you know you're a contractor if you invest in the stock market in a federal corporation? And here's the proof from the U.S. Supreme Court in 1885. The court held that the first company's charter was a contract between it and the state, and this was a corporate charter they're talking about, within the protection of the Constitution of the United States, and that the charter to the last company was therefore null and void. Mr. Justice Davis, delivering the opinion of the court, said that if anything was settled by an unbroken chain of decisions in the federal courts, it was that an act of incorporation was a contract between the state and the stockholders, departure from which now would involve dangers to the society that cannot be foreseen, would shock the sense of justice of the country, unhinge its business interests, and weaken, if not destroy, that respect which has always been felt for the judicial department of the government. Now, what they're saying here is all subterfuge and it's propaganda, because technically corporations may be legal persons under the statutes, but they are not persons, they are not citizens, and they are not residents within the meaning of any portion of the Constitution of the United States. If they're not persons, then they're not subject to the protections of the Constitution. And they say here the protection of the Constitution of the United States. No, they're not protecting constitutional rights. They may be protecting the constitutional rights of individual people who are the stockholders, but they're not protecting the corporations. Since the corporations are not persons or people under the Constitution, then they're not protecting any constitutional right to protect the interests of the corporation in that stock. Moving on. Proof that uncle is loaning you their property. Every piece of government property must be accounted for. This is called plant accounting. Each item of government property is serialized with a plant account number. And by the way, every year or every few years, the General Accounting Office requires every government agency and office to account for its property. And they do that with an inventory. And each item has to be numbered, and they have to have a serial number on it, and they have to account for that serial number in their audit. Okay, and by the way, that's the same reason you have to file a tax return every year, and the same reason you have to put a Social Security number on that tax return, because it's a plant account number for government property, and that property is the office. And you're renting the office. They're running what I call a rent ident service. The ident being rented, or the res being rented, is the status of citizen, resident, taxpayer, and so on, or under the federal franchises. That's what's happening. They're renting you a status. And the Social Security card has a warning on the back that it is property of the government and must be returned upon request, and it contains a plant account serial number accounting for it as property. And here's the warning. It says, this card is the official verification of your Social Security number. Please sign it right away. Keep it in a safe place. Why? Because it's property. And you have to protect it. And you're the trustee of it. Hello? They say, moving on, it says, improper use of this card or number by anyone is punishable by fine, imprisonment, or both. So they're warning you. If you use this card, this physical property, in connection with any transaction, then you are subject to penalty. And whatever kind of penalty they want to give you. So, implicit in this warning is the right to not use this card in connection with any specific transaction, and thereby to avoid the penalties if you don't want them, or you don't perceive them as a, quote, benefit, unquote. Moving on, it says, this card belongs to the Social Security Administration. In other words, it's property of the government, because Social Security Administration is part of the government. It says, and you must return it if we ask for it. And if you find a card that isn't yours, please return it to Social Security Administration. The original owner, by the way, you're just a custodian over that property, government property. And it says, for any Social Security or business information, contact your Social Security office. If you write to the above address for any business other than returning a found card, it will take longer for us to answer your letter. Now, there's a fraud even in this warning here, because it says your Social Security number. Now, if this card belongs to the government, and the regulations say that it's property of the government, can it be yours as a human being? And the answer is no. You can't own that which doesn't belong to you, now can you? And yours implies ownership. So they're lying, because they're writing this to you not as an office, but as a human being. A human being is reading this, and that human being is private, and only becomes public except through their consent, and must be lawfully elected before they're public. Okay? So by saying they're confusing you as a private human with an office, aren't they? And that's the whole heart of the scam. They're confusing the public with the private. They're making you think that they're synonymous. And that confusion is called an idem sonans. They're confusing you, the all caps you, John Doe, all caps, and in connection with the number, the Social Security number on the card, those two together constitute the res or office that they can regulate. Okay? And they're referring to both of those synonymously as the same thing. And they aren't. Okay? And if they were honest, they would warn you about that. They would tell you that they would, instead of saying this card is the official verification of your Social Security number, they would say this is the official verification of the office that owns the Social Security number, and which you are custodian over, and which you can quit from if you want. But of course, then they'd have to admit that they can only regulate you by your consent, and they can only govern you civilly by your consent, and they don't ever want to do that, because all they want to do is steal and lie to you through propaganda. That's the heart of the fraud that's going on here. Moving on. Use of government property is what creates the obligation, not the possession of the property. Simply having possession of a Social Security card does not create an obligation other than to return it upon notice and demand by its owner, and it does not convert any of your formerly private property to public property. For the SS card to transmute private into public, it must be voluntarily connected to a specific property or a specific transaction. For instance, when you open a bank account, they'll ask you what's your social security number, and they're really asking you two questions. The first question is, are you a public officer on official business? And if you are, what is your license number to represent to act in that capacity? And if you provide a number, you answered yes to the first one. Yes, I'm serving as a public officer. And the answer to the second one is, here's my license to act in that capacity. Now, if you decide that you don't want to act as a public officer in the context of that transaction, you cannot provide, you cannot use a number. And if they compel the use, they're violating 42 U.S.C. 408A8, and they're committing a crime. They cannot compel the use because they can't force you to work for them, the government. They cannot force you to occupy an office. Why? Because the 13th Amendment forbids that, doesn't it? And that 13th Amendment applies everywhere, including federal territory. So they can't force you to use the number or to have a number or to apply for a number even. But if you have one, they have to ask for it because they need to know who the real owner of the property is that you're of the account is that you're establishing, don't they? If you provide a number, you're saying Uncle owns this account and they can take whatever they want out of it, and I'm just a custodian. I'm not the owner. I have equitable interest. I do not have absolute ownership. I have qualified ownership over the content of the account, and Uncle can take whatever they want out of there through a levy. And if you look in section 6331A, you'll see that. It says levy may be made by any office or instrumentality of the United States government. Okay? So they can't levy private property. They can only levy public property, and the use of the number in connection with the account is what creates at least the appearance, usually the false appearance, that the account is Uncle's property, that it's public property. Moving on, the act of consensually using the property to hold or affect title to property, formerly private property, is what transmutes the ownership from private to public. And here's what they said, Supreme Court. When Sir Matthew Hale and the sages of the law in his day spoke of properties affected by a public interest and ceasing from that cause to be juris privati, meaning private, that is, ceasing to be held merely by private right, they referred to the property dedicated by the owner to public uses or to property the use of which was granted by the government or in connection with special privileges were conferred, unless the property was thus dedicated or some right bestowed by the government was held with meaning in connection with, meaning attached with, meaning like putting a social security number on an account. So you're holding government property, the number, in connection with formerly private property, which is the money in the account, and those two, that connection creates the appearance that private property has been donated to a public use. That's how they do it. Okay. And we read this earlier, so we're not going to finish that quote again. So you could then say that in talking about the government property that was loaned to you, you could say that that property in effect acts as anti-property and anti-matter, right? Because anything you touch it with, anything you use it with, is transmuted from private to public, or at least it looks like it's been transmuted, even though technically it hasn't. Why? Because as we said, an unalienable right is one you cannot give up. You're not allowed legally to give it away. So even hooking it up to a social security number doesn't really constitute a donation. And it isn't a donation because you're the original owner and they will not recognize your right to not donate it. They will not protect it. They'll call it voluntary, which is true, but then they won't recognize your right to unvolunteer. So technically, there is no donation. It's just a fraud at that point if they won't recognize your right to not donate or to not use it in connection with a number. If they won't recognize or protect that right, they're just thieves. And they're using propaganda and confusion between the office and the officer and the confusion between public and private to steal from you. That's what they're doing. So we say then that government franchise properties such as the Social Security number card are like antimatter in Star Trek science fiction series. Whatever you voluntarily and consensually touch with this public property transmutes ownership from private to public, transmutes ownership from exclusive ownership to shared ownership. And by exclusive, we mean absolute ownership. And shared ownership, we mean qualified ownership. The statutory person you are sharing it with is the government corporation. And it converts the original private and absolute owner of the property into an equitable owner, and a qualified owner for that matter. And it changes the status of the property to private property voluntarily donated to a public use and a public purpose to procure the benefits of a government franchise. Now do you see the mechanisms they're using? Other examples. vehicle registration. When you register the vehicle, you convert the vehicle from absolute to qualified ownership, and that's why the state government can take it from you if you violate the vehicle code under certain conditions, because they have an interest in the property. They can't take it unless they have an interest in it. And you have to convert it from private to public before they can have an interest in it. And you're an idiot if you do. And there are no real benefits to doing it. And furthermore, there's no reason that they have to acquire an interest in the property to protect it. Would you hire somebody as a security guard to protect property if you had to sign over title or an interest in the property to them before they would protect it? Would you do that, realistically speaking? And if you wouldn't, then why the hell would you hire a government to do the same thing? Hello? Anyway, recording title to land under the Torrens Act system of land registration. You could say that the county recorder is a method of, quote, protecting, unquote, your ownership, right? So in effect what they do is they're turning the protection of title into a franchise, and they're making you a beneficiary of the franchise, and they're forcing you to donate an interest in the property for them to protect it. And that interest is their right to collect property taxes on the property. If you never register it, then you don't owe the property taxes. They have to know about it, and you have to notice them that you know about it by using their title system, their land registration system. And you're not required to register it as land. You can register it as a contract and protect the contract, and then they can't steal from you. Keep that in mind. Acquiring a license and using it in connection with your professional activities is another example. Okay? So just be very aware that anytime you deal with the government, they're going to try and steal a portion of the property that you want them to protect. And that's why we say that they're not really a government, because the whole purpose of government is to protect private rights, and the very first step in protecting them is to prevent them from being converted to public rights of the owner under any circumstances. They don't need to own it to protect it, now do they? And the minute they do is the minute they're thieves. And so government really is an oxymoron, because they really refuse to do the only job they're created to do. So we could say then that Uncle is in the property rental business, aren't they? Uncle has made a business out of renting its property. The property it rents out are the statuses or roles to which public rights and public entitlements attach, and we call what they are doing a rent and ident service. And those renting this property are the only ones who the Internal Revenue Service can lawfully, quote, service, unquote. And the SSN or TIN acts as a de facto license to represent a public office, and the role or status of taxpayer is the public office being represented, and the domicile of that public office, by the way, under 4 U.S.C. Section 72, is in the District of Columbia. Okay, so, and by the way, all liens must be filed in the place of domicile of the taxpayer, and therefore all tax liens must be filed only in the District of Columbia. Now, and the reason they file them in other places is because they're trying to confuse you with the office. You're not the taxpayer if you're the public officer. The office is the taxpayer. And since they're trying to confuse you with the office, then they're filing the lien in the state recorder's office instead of the District of Columbia recorder's office, and that's a fraudulent lien. And it violates the Federal Lien Registration Act, and it has to be removed from the records of the state because it does so. The Social Security card and associated number is just like a Costco or Sam's privilege card, now isn't it? If you use that privilege card or the license number on the card, then you incur the obligation that go with delivering the benefits of the card, right? Hello? And if you don't consensually use the card or the number in connection with a specific transaction or specific private property, then you don't incur an obligation. And that includes any instance in which you are compelled to use it. In every such instance, you ought to make a big deal about putting evidence of duress in the record of whoever it is that instituted the duress and the government whenever that happens, because at that point, the Department of Justice is responsible for enforcing the criminal laws and prosecuting those who institute the duress. And anything you do under the influence of duress is voidable, but not void. So you have to express that you are under the duress before the consequences of the act are no longer enforceable by the government against you. For instance, if you open an account and you're compelled to use a number, and you didn't consent to use a number, and you knew you were not lawfully occupying an office in the government, then you couldn't use a number even if you wanted to, and yet the party, the institution that you're making the account with, forces you to use the number, there's an instance of duress. So now you have to notify them with proof of service, the bank or the institution, that they are violating the law. Then you need to file a criminal complaint with the Department of Justice and possibly the IRS, letting them know that you are compelled to do this. And then every tax obligation that then tries to attach to that account is an illegal enforcement, and all evidence gathered and all information returns submitted in connection with that account, that illegally connected and improper number, then become false reports and false returns, because information returns are false returns. And in any criminal enforcement action that would use or invoke any of that evidence is using what they would call the fruit of a poisonous tree. They're using improperly or illegally connected evidence that is the product of a crime, no less, to prosecute yet another crime, and they're not allowed to do that. So it's very important that your administrative record reflect the existence of the duress at every opportunity to interact with the government. So if someone compels the use of either the card or the number, they are engaging in the crime of compelling you to impersonate a public office without your consent, and therefore criminally stealing and enslaving you in violation of the 13th Amendment. Residence requirement for franchises. De jure government franchises cannot lawfully be occupied to non-residents. Offering them to non-residents constitutes private business activity beyond the core purposes of government, and refusing to enforce the statutory domicile requirement, e.g. the requirement that you must be a citizen or resident, statutory citizen or resident, against those participating, turns the franchise into private business activity that is not legitimate government activity and may not therefore be protected through sovereign immunity. Why do we say that? Because all law, all government law, is prima facie territorial, according to the Supreme Court. It attaches to the territory over which the lawmaking power of the government has. And more specifically, it attaches to those domiciled on that territory. If you are not domiciled on that territory, and domicile is a prerequisite to enforce the civil law, then that civil law doesn't apply to you, and that civil law includes all franchises. So they cannot offer a franchise to a non-resident. And if they do, and especially if they impose an obligation for you to obey the franchise as a non-resident, in effect they're engaging in acts of international terrorism. That's what the Supreme Court said. They described it as a theft and an extortion rather than a tax. Examples of residence requirements within existing government franchise. Social Security, available only to statutory U.S. citizens and permanent residents in 20 CFR 422.104 who have in common a domicile on federal territory. Hello? People in a state, a constitutional state, are not domiciled on federal territory. They're not domiciled in the statutory, quote, United States, unquote. They're not domiciled in a statutory, quote, state, unquote, because that statutory state is, without exception, a federal territory and not a constitutional state. And that's in spite of what all the propaganda says in the Program Operations Manual System and all the Social Security publications about that subject, because they're wrong. And that propaganda is designed to recruit people who are not eligible and thereby to engage in economic terrorism against the states in violation of Article 4, Section 4, and to violate the fiduciary duty of the people who work in the federal government, and to violate the Constitution itself. Another example of a residence requirement, IRC Subtitle A, income taxes, only imposed upon statutory but not constitutional U.S. citizens and permanent residents when abroad. 26 U.S.C. 911 is where it says that. And non-residents are expressly exempted by all the following statutes and regulations. So if you're not, and by the way, even in the case of non-resident aliens, for instance, you can be a non-resident without being an alien. And you can be a non-resident without being an individual either. An example would be, and you cannot be an individual until you're engaging in a franchise. You cannot be an alien until you're physically on federal territory. So if you're, let's say, in Arizona, to use the earlier example, You would be a non-resident in relation to California. And by in Arizona, I mean domiciled in Arizona. If you're domiciled in Arizona, you're subject to the civil laws of only Arizona. Then in California, you would be an alien, but only while you're either physically present in California or you're doing business in California and consent to the protections of the laws while you're doing business. Otherwise, you're not even an alien, and you're certainly not a resident of California at that point. So you have to, in effect, engage in a franchise and represent an office in the state, which is franchised in the state, and domiciled in the state, before you can be subject to the laws of that state. Those are the choice of law rules that govern all interactions, and it's universal and it's international. It applies to different countries, the interactions of people in different countries, or even in different states within a country. Where may de jure government franchises lawfully be implemented and enforced? Enforcement of de jure government franchises is limited to those with a domicile on federal territory in the statutory but not constitutional United States. Why? Because Federal Rule of Civil Procedure 17b identifies the authority for this, and it says the capacity to sue or be sued. The capacity to sue or be sued is determined as follows. For an individual who is not acting in a representative capacity, by the law of the individual's domicile, and for a corporation by the law under which it was organized, and for all other parties by the law of the state where the court is located, except that a partnership or other unincorporated association with no such capacity under the state's law may sue or be sued in common name to enforce a substantive right existing under the United States Constitution or laws, and 26 U.S.C. 754 and 959A govern the capacity of a receiver appointed by the United States court to sue. So the bottom line is, what they're basically saying here is you either have to have a domicile in the state, or you have to be acting in a representative capacity of an entity that is domiciled in the state before you can invoke the laws of that state for a remedy. Because they're saying here, capacity to be sue or be sued. So they cannot invoke the civil laws of a place without proof on the record that you are domiciled as the defendant in that state, or the entity you're representing is domiciled in that state. And by domiciled, I mean, for instance, a corporation can be domiciled in a state. It's domiciled, in fact, in whatever state that it's registered in. So if you fill out a corporation application in your state, then the domicile of that corporation is technically the capital of that state and no place else. Just like the domicile of all federal corporations is the District of Columbia, because that's the capital of the country. And while you're on official business representing that corporation, the laws of the place of domicile of the corporation apply and are enforceable in that civil court. And only those laws. And as we said earlier, that corporation is not a person or a citizen or a resident within the meaning of any provision of the Constitution, and therefore it's only protected by the civil law, the civil statutory law. That's the only thing that can protect it, because the Constitution cannot protect it. And that protection is limited to whatever the state consents to. Because why? Because corporations are creations of the state, they are property of the state, they are franchises of the state, and the creator of a thing is the only one that can define the authority or privileges or rights of that thing, and the only one that can revoke those rights, and the only one that can tax or regulate those rights. Okay, and once again, no government created you. They didn't create your body. They didn't create the land you're standing on. The only thing they can create are franchises, and then charge you for the privilege of exercising those franchises. And if you don't consent to receive the privileges or benefits, then all they can do is go away. For further details on this subject, see Federal Enforcement Authority within States of the Union, Form 05.032, and Federal Jurisdiction, Form 05.018. And where may franchises lawfully be implemented and enforced? Here's what the Supreme Court said on that subject in 1866. Thus, Congress, having power to regulate commerce with foreign nations and among the several states and with the Indian tribes, may, without doubt, provide for granting coasting licenses, licenses to pilots, licenses to trade with the Indians, and any other licenses necessary or proper for the exercise of that great and extensive power, and the same observation is applicable to every other power of Congress, to the exercise of which the granting of licenses may be incident. All such licenses confer authority and give rights to the licensee. But very different considerations apply to the internal commerce or domestic trade of the states. Over this commerce and trade, Congress has no power of regulation nor any direct control. This power belongs exclusively to the states. No interference by Congress with the business of the citizens transacted within a state is warranted by the Constitution, except such as is strictly incidental to the exercise of powers clearly granted to the legislature. The power to authorize, that is, license or turn into a franchise a business within a state is plainly repugnant to the exclusive power of the state or the same subject. It is true that the power of Congress to tax is a very extensive power. It is given in the Constitution with only one exception and only two qualifications. Congress cannot tax exports, and it must impose direct taxes by the rule of apportionment and indirect taxes by the rule of uniformity. Thus limited, and thus only, it reaches every subject and may be exercised at discretion, but it reaches only existing subjects. Congress cannot authorize, that is, license, a trade or a business within a state in order to tax it. Now note the very key use of the word trade or business. That phrase, trade or business, is the very same thing that the Internal Revenue Code itself imposes the tax upon. And that thing is an activity, okay? A trade or business. And that trade or business is an office in the U.S. government and not the state government. And that office is the subject of the tax. And all property voluntarily donated to the office is also the subject of the tax. And that is the only thing that is taxable, and nothing else. And that office, as we said earlier, can only lawfully be exercised in the District of Columbia and not elsewhere, except as expressly provided by law per 4 U.S.C. Section 72. So they cannot create new offices in a state. Notice they use the word existing subjects. So what they're implying here is they cannot create an office in a state and then make it the object of a tax. So they cannot create taxpayers in a state. You cannot elect yourself into an office in the state so they can tax it, even with your consent. Why? Because your rights are unalienable, according to the Declaration of Independence. And the Declaration of Independence is organic law, enforceable organic law. Why? Because it was published in the very first enactment of Congress in the first section of the statutes at large in Volume 1. So it is law, regardless of what anybody says about that subject. So the important point to derive from all this is that federal or national franchises can only be enforced and offered on federal territory, and territory subject to the exclusive sovereignty of the United States government. And that territory is the coastal waters, federal territories, and from what they say here, Indian reservations. Okay, and no place else. So they cannot offer, they cannot enforce franchises or public offices or the activity, any kind of activity that they would license or regulate within the boundaries of a constitutional state. And that's why the definition of the term state in the Internal Revenue Code and in many other enactments of Congress only includes federal territory. And that would include, for instance, 4 U.S.C. Section 110D. Read that definition of the, quote, states, unquote, and you'll be surprised. Parties eligible to participate in franchises. Parties eligible to participate in de jure government franchises must have a domicile on federal territory, without exception. Why? Because we said domicile is a prerequisite to being eligible to participate in government franchises. Why? Because the franchise provisions are civil law, and the civil law, all the statuses imposed by the civil law are attached to your domicile. And if you change domiciles, all those statuses extinguish when you leave that place. Moving on, parties with a domicile on federal territory include statutory but not constitutional U.S. citizens, per 8 U.S.C. 1401, statutory but not constitutional permanent residents, 8 U.S.C. 1101A3, and 26 U.S.C. 7701B 4B, and statutory U.S. persons pursuant to 26 U.S.C. 7701A30, and residents of the Virgin Islands and the District of Columbia. Now, a very important concept of domicile is that you cannot have a status in a place that you're not domiciled unless you consent to it. So, you cannot be a U.S. person or a U.S. citizen or a U.S. resident without your consent. Why? Because rights attach to those statuses. All public rights attach to statuses. And those rights adversely affect your private property if they're enforced against you. And they can't take your private property under the Fifth Amendment, so they can't enforce the status or the obligations of the status without proof on the record that you consented to the status. Now, can they? So they got to basically fool you that there's no difference between the status and you as a human being. They have to fool you into thinking that there is no separation between the public and the private, that the private and the public person are one and the same thing, that the public office and the public officer are the same thing, and they're not. And that's the heart of the fraud, as we said earlier, on the back of the Social Security card, for instance. Parties domiciled in states of the Union are constitutional state citizens, but not statutory U.S. citizens, per 8 U.S.C. 1401. And we prove this in why you are national, state national, and constitutional, but not statutory citizen, Form 05.006. And persons domiciled in states of the Union cannot lawfully alienate or alien their rights in relation to a real de jure government. That's what the Declaration of Independence says. In fact, it says their rights are unalienable, meaning that they cannot lawfully be sold, bargained away, or transferred by any legal vehicle in relation to a real de jure government, including through franchises, because that's what franchises are. They're a contract and they're a bargain between you, the franchisee, and the government, which is the franchisor. And if you can't bargain away rights, then you're not even allowed to engage in it, and that's why Uncle can't even offer those franchises within a constitutional state. And that's also why everybody who serves in federal offices within a constitutional state, if they are authorized to do so, typically serve on federal land, which is subject to the exclusive jurisdiction of Congress, so they do fall under the laws of Congress while they're on federal territory. And parties domiciled in states of the Union are not lawfully eligible to participate in government franchises and are not subject to federal civil law. This is a requirement of the separation of powers doctrine that is the heart of the United States Constitution. And we prove that in Government Conspiracy to Destroy the Separation of Powers, Form 05.023. So now let's talk about the effects of participating in government franchises. One becomes a franchisee usually by voluntarily applying for a license or benefit or to receive a government property such as a Social Security card or number. Remember we said the SS5 application was an application, identifies itself in the upper left-hand corner as application for a Social Security card, which we said was property. So you have to accept custody of government property, and that government property is essentially the res, the corpus of a federal trust. And you are the trustee over that corpus. And you add to the corpus by associating that number with otherwise private property. And doing so illegally, I might add, if your rights are unalienable. And next, the application for the license constitutes constructive consent to abide by the franchise contract in exchange for the privileges of procuring the, quote, public benefits, unquote, or public rights or public property associated with the franchise. And here's an example from a district court in 1869. For the granting of a license or permit, the yielding of a particular privilege and its acceptance by the meadors was a contract in which it was implied that the provisions of the statute which governed or in any way affected their business and all other statutes previously passed which were in para materia with those provisions should be recognized and obeyed by them. When the meadors sought and accepted the privilege, meaning the property, the grant of property, the loan of property, the law was before them. And can they now impugn its constitutionality or refuse to obey its provisions and stipulations and so exempt themselves from the consequences of their own acts? So, caveat emptor, if Uncle offers you anything, they're trying to recruit you into an office and make you into an employee, whether you want to be or not. And even if you don't realize that you're an employee, they're going to treat you like one. So bend over. Moving on, an alienation and surrender of specific private rights over private property occurs under the franchise contract. And as we said, that alienation can only occur where the Constitution doesn't apply on federal territory. And that's why the corpus can only exist, the status can only exist on federal territory, where the rights don't exist and where the Constitution doesn't apply. The formerly private human being agrees to act as a public officer within the scope of the franchise contract and all activities described therein, and the private property associated with the franchise is converted to a public property held in trust by the public officer. That's how it works. And whether you understand that process or not is really doesn't matter, because every citizen is supposed to know the law. That's what the Supreme Court said. And if you ain't reading the law, then you're going to be a victim. And the law is just a trap, most of it. All the civil law is just a big trap. And the bait that entices you to the trap are the, quote, benefits, unquote, of the franchise. That's how it works. And Uncle is just a big hunter of animals. You're the animal. They're hunting you and trying to capture you in their trap. And the minute the trap springs is the minute you have a new landlord. And you're tied down because the trap is tied down to the ground with a chain. You're tied down to the district of criminals. And you are Uncle's property, and you're a servant of the state at that point, whether you want to be or not. And you damn well better leave the franchise as quick as you can, because if you don't, the Bible says that you're not allowed to be surety for debt, any kind of debt, including public debt. And that's what a franchisee is, surety for public debt. Effects of participating in franchises. All franchises are contracts. All contracts create agency on each party on the part of the other parties to the contract. As a minimum, that agency requires each party to act for the benefit of the other party in providing the consideration promised by the contract, and the agency created by the contract is referred to as an office in government parlance. And all franchises are public officers, franchisees are public officers within the government. And remember, according to the Supreme Court, once again, Osborne versus Bank of the United States, all the powers of the government, including all of its civil enforcement powers against the public, must be carried into operation by individual, that is, government agency, either through the medium of public officers or contracts made with formerly private individuals. So anytime you contract with Uncle, you're going to be their agent, and as an agent, they can legislate against you. And that legislation becomes, in effect, a provision of the contract. And they can modify all those provisions anytime they want, unilaterally, and they very frequently do. And that's why you should never contract with the government. That's why the Bible says you can't contract with any government, because it says it'll be a snare to you. That's what it says. Franchisees must become public officers, or become officers and public officers within the government and take on a public character, because it is otherwise repugnant to the Constitution to tax, burden, or regulate private conduct. So they can't reach you until you're public, until you're publicity juris, until you occupy an office. And they can't force you into office. You have to volunteer. And here's what the Supreme Court said on this subject in 1997. The power to legislate generally upon the life, liberty, and property, as opposed to the power to provide modes of redress against offensive state action, was repugnant to the Constitution. And you read through all those cases, and they're very interesting. Although the specific holdings of these early cases might have been superseded or modified, blah, 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 the power, Congress's power as a corrective or preventive, not definitional, has not been questioned. That's City of Bern versus Flores, Archbishop of San Antonio. So the bottom line is, the Constitution protects private rights, and it's repugnant to the Constitution to encroach upon those rights, or to regulate those rights, or to tax those rights. And so you have to make them public rights, and you have to become a public officer, and you have to donate those rights to the public before they can reach those and regulate those lawfully. And the only place you can physically do that is while you're physically on federal territory and you have a domicile on that territory. And otherwise, they can't enforce any obligations associated with the franchise. An association of private property within the public domain is called publicity juris in law. And here is a definition of publicity juris from Black's Law Dictionary, 4th edition, page 1397. Publicity juris, Latin, of public right. The word public in this sense means pertaining to the people or affecting the community at large. And we put in brackets, the socialist collective is what they would refer to as the community. That which concerns, or the collective, as what some people would say. that which concerns a multitude of people, and the word right, as so used, means a well-founded claim, an interest, concern, advantage, benefit. So when they use the word right in the context of a franchise, they really mean benefit. And the benefit is the bait that attracts you to apply. And if you don't apply, if you don't consent to receive that benefit, then they cannot enforce the provisions of the franchise. Why? Because a valid contract has not been created. A valid contract requires mutual consideration and mutual obligation. If they don't have to give you anything, then, or if you don't receive anything, then you're not obligated to do anything in return. And that obligation is the so-called consideration they receive from you in return for the benefit they provide to you. And we define everything the government does as not a benefit but an injury, and that way we can never owe anything to them. Keep that in mind. And the Bible requires you to take that approach, by the way. This term, as applied to a thing or right that is a privilege, means that it is open to or exercisable by all persons. It designates, and notice the word persons here, okay? If you're not, you can be a human without being a person. It's perfectly lawful. A civil person under the civil law is a status that attaches to your domicile in that place, and the franchise is offered within that domicile. And if you don't avail yourself of the benefits, privileges, and protections of the domicile in that place, then you're not a person. You're a transient foreigner. It's just like if you're in California and somebody in China hurts you, they're not a person under the laws of California because they don't have a domicile in California. And unless they're physically present in California, then you can't sue them. Unless they, quote, purposefully availed themselves, unquote, of commerce, and you invoke the Foreign Sovereign Immunities Act to sue them. Otherwise, you can't reach them because they're not persons, so to speak. And the Foreign Sovereign Immunities Act, in fact, makes them a, quote, person, unquote, a civil person under certain circumstances, but otherwise they're not a civil person. Moving on, it says, it designates things which are owned by the public. Notice that keyword owned, okay? That is the entire state or community and not by any private person. So they're distinguishing here between public and private. When a thing is common property, meaning public property, so that anyone can make use of it who likes, it is said to be publici juris, as in the case of light, air, and public water. Another example would be a public park. That's publici juris. Black's Law Dictionary. And their ownership of that park, that public park, is why they can post signs within the park saying, you got to pick up your dog doo-doo, because they own it and they can place conditions on the use of that property by anybody who's on that property. But they have to give you notice of those conditions, and they do. They'll put, on the sign, the dog doo-doo sign, they'll put notice. This, residents who use this park, have to pick up their dog doo-doo, and if they don't, they're going to get a fine. And if they never put that sign up, so you never receive notice, then they can't enforce the fine. That's how it works. It's called reasonable notice, and the Constitution requires it. They have to give you reasonable notice of the conditions of the loan of their property. Moving on. Publici juris. We allege that associating anything with a government identifying number, number one, changes the character of the thing so associated to publici juris. Number two, donates and converts private property so associated to a public use, public purpose, and a public office. And number three, makes you the trustee with equitable title over the thing donated instead of legal owner of the property who has absolute ownership. Keep that in mind. Don't ever use uncle's numbers because they're, as we said, those numbers are a de facto license to represent a public office in the government. Moving on. The compelled involuntary use of government identifying numbers therefore constitutes theft and conversion, which are crimes. See, why is it illegal for me to request or use a taxpayer identification number, form 04.205. So don't ever use their numbers, and every case where you do use it should be compelled. And there ought to be a record in the records of the person doing the compelling, and there ought to be a record with the government that you've given to them as well, possibly in the form of a criminal complaint. And 18 U.S.C. 654, for instance, also makes that conversion unlawful if it was compelled by a public actor, a public officer, or a federal employee. Examples of franchisees who are public officers. Elected or appointed public officers within the government are an example. Taxpayers under IRC Subtitle A at 26 U.S.C. 7701A14, which is where they're defined. See also 26 U.S.C. 6671B and 26 U.S.C. 7343, which identify a person, a statutory person, as an officer or employee of a corporation or partnership involving the United States government. So, in other words, if it's a federal corporation or you're in partnership with that federal corporation as a contractor, then technically you can be a taxpayer as the term person is defined. But otherwise, you're not. And that gets back to the definition that we said earlier from Osborne versus Bank of the United States, in which the Supreme Court said that all the powers of the government are carried into operation through individual agency, either through the medium of public offices or through contracts made with private individuals. And that phrase is exactly replicated in the definition of person itself in Section 7343 and Section 6671B of the Internal Revenue Code. That's what they define a person as, is somebody who is an officer or who has a contract with the government. And that contract is represented by the phrase partnership in that definition of person. So they know exactly what they're doing. And you need to know too. And here's the proof. Why you are your government is either a thief or you are a public officer for income tax purposes. Form 05.008. We go into exhaustive detail proving that all taxpayers are public officers in the government. Why? Because they cannot regulate private property or private rights as held by the Supreme Court, and it's repugnant to the Constitution to do so, and they need a contract with you, and you have to be their officer or an instrumentality of the government or an agent of the government before they can legislatively reach you. And you have to consent to that agency and that contract before the laws of that otherwise foreign jurisdiction acquire the, quote, force of law, unquote. Social Security benefit recipients are also treated as public officers. See 5 U.S.C. 552A, paragraph A13. It says, definitions for the purposes of this section, the term federal personnel means officers and employees of the government of the United States, members of the uniformed services, and then it says individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States. Okay, so they're individuals because they're public officers, and they wouldn't be individuals or persons if they weren't, but the key is that they must be eligible to receive the benefit. And that eligibility is what makes them essentially purposefully availing themselves of commerce within that jurisdiction, and therefore a person and a resident or otherwise of that jurisdiction. Jurors are another example of public officers. See 18 U.S.C. 201A1 identifies a juror as a public officer. And FDIC insured banks. See 31 CFR 202.2. It identifies those banks as essentially agents and officers of the government. Now, why is that? Because FDIC, Federal Deposit Insurance Corporation, is owned and created by Uncle, and Uncle is the government, and that insurance is a benefit, and the bank has to apply to receive the benefits of that insurance before it's subject to the terms of that insurance. And once it's subject to the terms, it becomes an agent of the government because it has what? A contract to procure those benefits. And that contract is called a franchise. In this case, the FDIC insurance franchise. Moving on. Licensed drivers under the Motor Vehicle Franchise Code in your state. Statutory driving is a privilege, and the Motor Vehicle Code is a franchise that governs the exercise of the privilege. And as a matter of fact, the term motor vehicle is defined in federal law as a vehicle that is put to use for commercial purposes on the public roadways for hire. If you're not using the public roadways for personal benefit and financial benefit, then you're not a driver, and the vehicle you're in is not a motor vehicle. It's just a private conveyance at that point, in which case it's not subject to the vehicle code. So if an officer stops you and asks you license and registration, even if you have a license and registration, if you're not using the vehicle for public use, then you cannot present those things because you're off duty. You're not exercising the functions of the office of driver at that particular point in time, and it's illegal for you to impersonate an officer at that point if you're not engaged in the activity. It's a crime, in fact, to impersonate a public officer in every state. Spouses who are joined by a marriage license, which is a franchise agreement and a trust indenture that has a third party to the trust contract and therefore constitutes polygamy. And here's an example. West versus West, 1998. Marriage is a three-party contract between the man, the woman, and the state. The state represents the public interest in the institution of marriage. The public interest is what allows the state to intervene in certain situations to protect the interests of the members of the family. And in that sense, you could say a family within the family code is really just a corporation, a three-party corporation, you, your spouse, and the state. And in that sense, when you get a marriage license, you're a polygamist. And there's only one party to that polygamy that can rewrite the marriage contract, and that's the government. And I would allege it's not even a government at that point, because they're trying to alienate a private and a right that's supposed to be protected, and they're making a business out of it, as a matter of fact, and they're making a profitable business, and therefore they violated their fiduciary duty, they violated the Bill of Rights, especially if one or the other party refused to consent. Then they're essentially sticking their nose in other people's business. It says the state is like a silent partner in the family who is not active in the everyday running of the family, that is the family corporation, the state corporation, but becomes an active and exercises its power and authority only when necessary to protect some important interest of the family life. And by important, they don't mean important as you define it. They mean as they define it. They're the only ones who can define it. And that's the problem. That's why you should never get a marriage license. There's no reason why you can't write a private marriage contract that defines all the terms of your relationship. And that is why we refer to the family code in every state essentially as the default marriage license for people who don't want to write their own contract or negotiate their own contract. And anybody that would let a government write that contract and do so in a manner that doesn't allow them to even participate or change the contract or revoke the contract is an idiot and a polygamist. Moving on, privileged statutory U.S. citizens under 8 U.S.C. 1401, which are really just officers of the United States federal corporation and not human beings. See why you're a national, state national, and constitutional but not statutory citizen. Form 05.006, Section 3, we prove that. Here's another example of people who are public officers. Notaries public. And here's a quote right from the Notary Manual, Anderson's Manual for Notaries Public, 9th edition, 2001. Chapter 1. A notary public, sometimes called a notary, is a public official appointed under authority of law with power, among other things, to administer oaths, certify affidavits, take acknowledgments, take depositions, perpetuate testimony, and protect negotiable instruments. Notaries are not appointed under federal law. They are appointed under the authority of the various states, districts, territories, as in the case of Virgin Islands and the Commonwealth in the case of Puerto Rico. The statutes which define the powers and duties of the notary public frequently grant, that is loan, the notary the authority to do all acts justified by commercial usage and the law merchant. And this is a critical distinction here, because that office of notary public, that public office, is revocable. And if you violate the statutes that regulate that office under the civil law, and those statutes are civil law, and they're also franchise provisions because they establish the terms and conditions under which you exercise the office. If you violate those terms and conditions, then they revoke the office, and you lose your certification as a notary. In other words, they take back the property that they loaned you, the office, if you improperly exercise the office, or you violate the authority delegated to the office by the statutes, the franchise statutes. The ability to regulate or tax the use of private property is repugnant to the Constitution. And here's an example, Munn versus Illinois. A body politic, as aptly described in the preamble of the Constitution of Massachusetts, is a social compact by which the whole people covenants with each citizen, covenant is a contract by the way, and each citizen with the whole people, that all shall be governed by those certain laws for the common good. This does not confer power upon the whole people to control rights which are purely and exclusively private, Thorpe versus R&B Railroad Company, but it does authorize the establishment of laws requiring each citizen, not everyone, but only those who consent to call themselves statutory citizens, to do so, to so conduct himself and so use his own property as not to unnecessarily to injure another. This is the very essence of government, and has found expression in the maxim sic utere tuo ut alienum non latus. From this source come the police powers, which was said by Mr. Justice Taney in the license tax cases are nothing more or less than the powers of government inherent in every sovereignty, that is to say, the power to govern men and things. Let's go back and look at this, analyze this. First of all, they say that it's a social compact. A compact is defined as a contract or an agreement. Okay, so all civil societies are built around a compact or agreement. Okay, and that compact and agreement, I would add, is implemented by the civil statutory laws of that sovereignty. And the implication here is that you cannot become a party to that compact without your consent, because they can't force you to contract. They can't force you to agree to anything. So the very first step in any civil society is to create civil laws that enforce that covenant, and to recruit people to become members of that clubs that we call, or parties to that contract. And those members are called citizens and residents. And if you didn't consent to become a member, then you're treated as you're treated as a non-resident, a transient foreigner, and exclusively private. And then later on they say that it says, this does not confer upon the whole people to control the rights which are purely and exclusively private. And by private, they can only mean that which has not been donated to the public, right? Because everything's presumed to be private until it is donated to the public. And if you don't donate any of your rights to the public by consenting to become a citizen and remaining essentially foreign to the civil laws of that society, then you are exclusively private, and they have to leave you alone. At least from the terms of this civil code and the civil laws and the franchise codes, they have to leave you alone. And as a matter of fact, that's the very essence of what justice is defined as to begin with. Justice is legally defined as the right to be left alone. And the first duty of government is to protect that right. And the Supreme Court said in Olmstead that the Constitution confers the right, your right to be left alone. So the only way that you can lose that right to be left alone is to waive the protections of the Constitution by becoming a statutory citizen. That's a very important point. And you're an idiot if you waive any of those rights. Because the minute you waive any of them is the minute you waive sovereign immunity, it's the minute you agree to the social compact, it's the minute that you become an agent and officer of the government, subject to the contract or social compact or civil law, however you want to put it. And at that point, you're just a slave. You're a whore. And they can put whatever they want in that contract, and anything and everything they want, they're going to put in that contract, and they're going to steal everything you own. They're going to pretend like they own everything. They're going to pretend like you're a custodian over that which they own. They're going to make you into from a absolute owner to a qualified owner, and they're going to claim they own everything and that everything is a privilege and that you work for them and that you're just a dependent. And just bend over, and the only question is how far to bend over and how much KY jelly to use at that point. And that's why we say you're an idiot if you consent to be a statutory citizen. Because at that point you consented to become unequal, you consented to be a slave, you consented to create a civil religion in which the state is the thing being worshipped, the collective, and you consented to be subject to whatever laws the collective wants, and you also consented to laws, not even laws, they're not technically not laws, because technically a law is that which you didn't have to consent to. And if you have to consent to be a citizen, then the civil statutory code is not really law for you if you're not a citizen. So technically it's not law at all. It's a compact. And because a compact is that which you have to consent to, and law is that which you don't have to consent to. So technically a compact, that social compact and that civil code that implements that compact is not law for you. It doesn't have the force of law. It's just a contract. It's an agreement. It's not law. And as a matter of fact, it's fraud to call it law. Keep that in mind. And that's part of the propaganda, the layer of propaganda they put over all this civil code crap and all the internal revenue code and the vehicle code and everything else. They call it a code because they know it's not law for you. It's not law for everybody. So they call it a code. And then they pretend like it's law. They call it a law, but they never put in writing that it's a law in the code itself. They'll never put that it's law. They'll just call it code. And they'll fool you into volunteering for that code and into volunteering to become a citizen subject to that code. And at that point, you're hooked. And you ate the bait, and you're now anchored to the ground, and your domicile switched to the capital of the state or the capital of the country, the district of criminals, and now you're property, you're chattel. you're a slave. And you're chained to that office until you quit. And that office is surety for public debt, so you're screwed, buddy. Moving on. The rules for lawfully converting private property into public property. All property starts out as exclusively private and beyond the civil control of the government. Notice we didn't say criminal control. If you steal somebody's property, whether you consent or not, they can put you in jail, and they should. We're not arguing about the non-consensual nature of the criminal laws, but what many people think of as criminal laws are technically not. And an example would be the penal provisions of the Internal Revenue Code in 7201 through 7217. Those are penal. They're not criminal provisions. And a penal provision is different from a criminal provision because you have to be subject to the franchise that implements the penalty before they can invoke it. Meaning you have to be a person under the code in order to be the subject of that penal provision. So first you have to be a taxpayer, and you have to consent to be a taxpayer before the penal provisions of the code, including failure to file, false returns, and so on, are enforceable. Okay, and they'll try that case as if it were a criminal case, but technically it's not. It's a penal case, and they're playing mind tricks on you, Jedi mind tricks, by pretending that it's criminal, but it's not. It's penal, and it would definitely be criminal if it was in Title 18, the criminal code, but it's not there. And they can't put it there because it's not criminal. It's penal. And it's been disguised to look like it's criminal. And next, it says it is very important to understand the simple rules the government must abide by for converting private property to public property. This is extremely important. Any attempt by government to do any of the following in respect to one's private rights and or private property is theft and a taking of property in violation of the Fifth Amendment if the rules we will show you have been violated. They assert a right to regulate the use of the private property. They assert a right to convert the character of the property from private to public, or they assert a right to tax said property. If they do any of those things, then in effect they have to prove that the property is public property. And if they don't, they're stealing. And there's a presumption in your favor, the citizen's favor, or the party's favor, the owner's favor. There's a presumption against the idea that it is public property. And they have to prove that it is before they can regulate or tax it or steal it or levy it or lien it or anything else. Moving on. Supreme Court rules for lawfully converting private property into public property. Very important. And this is Budd versus People of the State of New York, 1892. Men are endowed by their creator, not by their government, not by a franchise, but their creator, with certain unalienable rights, life, liberty, and the pursuit of happiness. And to secure, not grant or create these rights, governments are instituted. That property, which a man has honestly acquired, he retains full control of, subject to these restrictions. And these are the rules. Okay? So, if you have the property in your custody and you're the owner, and if the government even says you're the owner, then it's presumed to be private. And here are the rules for converting it to public. First, that he shall not use it to his neighbor's injury, and that does not mean that he must use it for his neighbor's benefit, that is, Social Security, Medicare, and every other public benefit. Second, if he devotes it to a public use, he gives the public the right to control that use. And third, that whenever the public needs require, the public may take it upon payment of due compensation. And that would be an example of eminent domain. They decide to take it, your property, your house, to build a public roadway. But in the process, they have to pay you the fair market value of that property before they can take it. In other words, they have to compensate you with equal consideration before they can take the property. Because if they don't, they're stealing. So what we did here is we took all those rules and we itemized them. We broke them down. There were 3 items there, but we broke them down even further into 5 individual conditions. And we put them into a table and we gave them numbers so you can refer to them. And so the number is on the left here, and then the condition that applies is in the middle column. And then the right column is whether or not they need your consent to take it. Okay, so the first thing they said was the owner justly enjoys full and exclusive use and control over the property. This right includes the right to exclude government uses or ownership of said property. And does the government need your consent before they can take that property? And the answer is absolutely yes. If you're the exclusive owner, if you're the absolute owner, if you don't share ownership or title of ownership to the property, then it is presumed to be private and they can't take any portion of it. They can't claim any interest in it. They cannot invoke duties upon the use of it either. That's the very essence of property ownership itself, is the right to control all uses and all benefits and all beneficiaries of that property. That's what ownership means, by definition. So number 2, he may not use the property to injure the equal rights of his neighbor. For instance, when you murder someone, the government can take your liberty and labor from you by putting you in jail, or your life from you by instituting the death penalty against you. Both your life and your labor are property. Therefore, the basis for the taking was violation of the equal rights of a fellow sovereign neighbor. So you took that neighbor's life, and in return, they took your life. So you lost an equal amount of property in return for stealing somebody else's life. And to the question of whether they require your consent to take your life, the answer is no. Because, why? Because the early Bible in Exodus says, and Genesis says, an eye for an eye and a tooth for a tooth. If you take your neighbor's life, then your life gets taken. And that's equity, meaning you get the same treatment that you doled out. You killed somebody, so you get killed. You take your neighbor's donkey, so you lose your donkey, and so on. Item 3, he cannot be compelled or required to use it to benefit his neighbor. That means he cannot be compelled to donate the property to any franchise that would benefit his neighbor, such as Social Security, Medicare, and Medicaid. So in other words, all those different franchises, we call them, Medicare, Social Security, Obamacare, all of those franchises, they cannot compel you to participate. And even if you signed up, even if you applied for to participate, to receive the card itself as property, if you don't use that card and that number in connection with a specific activity, then that activity and the property associated with that activity has not been donated to a public use and cannot be regulated. And so the answer is, they need to, whether or not they need your consent before you donate it to a public use, and the answer is yes. After you donate it by associating it with a number voluntarily, or after you apply and then use the license issued with the application, then and only then do they no longer need your consent. But the consent is found in the law itself. The law determines what they need your consent for and what they don't need your consent to. And you are implicitly presumed to consent to the franchise if you use property associated with the franchise in connection with your activities. That's the whole point. When you use that property, then you are acting as a public officer. That's what a public officer is defined as. It's somebody who is in charge of the property of the public. And so they loan you the property, and you're a public officer while you're using that property in connection with a specific activity. If you don't want to use it, you're perfectly entitled not to use it in connection with any activity, and every activity for that matter. But if you do use it, you are presumed to consent to occupy an office and accept the obligations of the office and all the liabilities associated with it. Number 4, if he donates it to a public use, he gives the public the right to control that use, and we describe one method of doing that, using it in connection with a number, the license to represent a public office. It's what we call a Social Security number. And the answer is they still need your consent before you donate it, and after you donate it, they don't, because at that point they have an interest in the property and they can do what they want with it under the terms of the franchise that you consented to by doing the donation, right? And number 5, whenever the public needs required, the public may take it without his consent upon payment of due compensation. That is eminent domain, as we described before. And the answer is no, they don't need your consent for that kind of a taking, but they do have to provide equal consideration. Okay, as required by the Fifth Amendment, takings clause. Okay, but note, there is only one condition, which is item 2 above, right here, in which the conversion of private property to public property does not require compensation or consent, which is when the owner injures someone with it and the taking happens after the demonstrated injury. So in other words, if you run into your neighbor's car and you damage their vehicle, that's probably not a good example. If you damage a government vehicle, then you used your private property to injure somebody else's property, and a government property in that case. And so they have the authority, the implicit authority under the rules of equity to take property from you to restore that injury that you created. So if you damage their car, you have a right under the common law to take the person who damaged it into court and to recover the damages. And the amount of money that is recovered in that litigation is the amount that you that money was taken without your consent oftentimes. That's why you litigate it, right? Otherwise you just pay them. And so you didn't give consent, but the court took it anyway, and they did it with a court order. And they didn't need your consent because you injured the equal rights of somebody else. But under every other circumstance in this list, they either have to provide equal value in exchange for the taking, or they need your consent. And so if somebody wants to collect a tax, for instance, then they have to prove that you consented to donate the money they're taking, which is equal value. And if they can't demonstrate that you consented to donate the property, then it's a violation of the Fifth Amendment Takings Clause. And there's lots of ways they try to dance around that, including secretly presuming that you're an officer of a corporation and not being willing to admit that presumption, and then saying that the Constitution doesn't apply or it's superseded by the Code, which is bullshit, because we know the Code doesn't apply where the Constitution applies. They're mutually exclusive. Constitution applies in the states, and the federal code doesn't apply in the states. And likewise, the Constitution doesn't apply on federal territory, but the code does. So they're going to try to essentially kidnap your identity and move it to federal territory and remove you from the protections of the Constitution using presumptions before they can really steal anything from you. And that's where all the fog of the propaganda comes in. And that's why we're trying to educate you about how this all works, because it's a trap. It's a big game. And if you don't know the rules, you're going to lose every time. So we have some questions for the listener. The only way you can lose your private property without consent and without compensation is to either donate it to a public use or injure the equal rights of others in the use of it. So our question is, how did your private property, your private labor, become the subject of taxation? It has to be one of those two methods up there, right? Which one was it? After all, taxation is the process of converting private property into public property, isn't it? You might want to ask the Internal Revenue Service which of those two it's satisfying. And if they were truthful, they would say the first one, that you donated it, and then they'd say you donated it by using our number in connection with your activity voluntarily and by applying for the number to begin with. That's what they would say if they were truthful. But they're not truthful. And even that wouldn't be truthful, because if you're protected by the Constitution and your rights are unalienable, even signing up for the number or even using it cannot alienate a constitutional right. Or else the Declaration of Independence means nothing, does it? And secondly, second question is, by what specific authority does the government regulate or control any aspect of the use of your exclusively private property that you have not hurt someone else with? How do they do it? And I'll give you a hint. The only way they can do it is if you walk in and apply for a license of some kind, whether it's a driver's license, whether it's a marriage license, or whether it's a land registration franchise, or some other method. That's the only way they can reach it. You have to walk in and ask for the benefit before they can regulate and control it. And the fallacy, the fraud, the propaganda is that they don't have to admit how they acquired your consent. And they won't talk about the fact that they need your consent. And therein lies the fraud. At that point, they're just thieves. Because you can't regulate private property until you're at least willing to recognize it as private property and recognize how it got converted. If you can't even do that, how can you, as the alleged owner of a property, even know what you own? If they don't have the burden of proving that you gave it away, or that you converted some interest in it, and how you did it, in every case that they try to enforce, then how the hell can you ever know what you own? And if you can't know what you own, is there really a government? Because that's what governments are for. That's what they're created for, is to protect what you own, right? Isn't that what the pursuit of happiness is defined as in the Declaration of Independence by the Supreme Court? The pursuit of happiness is defined as the right to own property. And so the only way they can keep you happy, the only way they're allowed to keep you happy, is to recognize your ownership of property as private and to prevent it from being converted to public. And if they won't do that, you got no business hiring them to protect that ownership from the injuries of anyone else. If the government won't protect you from their own injuries, why the hell would you want to hire them to protect you from anyone else? Think about that. It's ridiculous. So here's the answers. You can't become a statutory taxpayer without volunteering and thereby donating your property to the government. See why domicile and becoming a taxpayer require your consent, Form 05.002. And only by volunteering to assume the civil status of a franchisee, that is taxpayer, citizen, spouse, driver, etc., absent duress or coercion of any kind, can the government regulate the use of exclusively private property. And as we said earlier, you can't even volunteer for the status until that civil status until you have a domicile on their territory. So it's technically it's illegal to even volunteer to be a taxpayer, citizen, spouse, or driver under federal law or national law if you're not domiciled on federal territory. And if you do, you're impersonating a public officer, we would add. In this way, you donate your private property to a public use, a public purpose, and a public office. And if there was any duress applied to force you to volunteer, then the regulation becomes a form of theft. And an example of that duress would be for them to call the participation voluntary, like they do with taxes, and yet refuse to protect your right to volunteer. If they won't protect your right to not volunteer, then there's duress, period. And they're just terrorists at that point. And they're running a protection racket where you got to pay them for the privilege of being left alone and for the privilege of having even an equitable interest or a qualified interest in your property. So you're renting everything you own from them. Is that the kind of government you want? It's not a government in our book. It's not a government in any legal book we've ever read. Violation of the rules for converting private property to public property. And so we need to be clear about what those violations are and how they happen. A theft of property has occurred on behalf of the government if it attempts to do any of the following. It circumvents any of the above rules, the 5 rules we talked about. It tries to blur, confuse, or obfuscate the distinction between private property and public property. And as we said earlier, they do that by confusing the officer with the office. They'll write a letter, a Dear Taxpayer letter to you, and they're really talking to the office. But if you're not a lawful officer, they're not talking to you. But they'll refer to you as you in the letter. So that's a fraud. That's an absolute fraud. And to be more technical, it's called identity theft. And it's a fraud in every jurisdiction. Because they're treating you as having a status that you can't lawfully have, and that you don't have, and that you don't consent to have. You cannot have any status, any civil status. You can't even be a citizen until you consent to the laws of a place by calling yourself a citizen and doing so absent duress and having a domicile on federal territory of that place. That's the only way you can become a statutory citizen. So, it refuses to identify exactly which of the 5 mechanisms identified in the preceding table was employed in each specific case, where it asserts a right to regulate the use of private property, or asserts a right to convert the character of the property from private to public, or asserts a right to tax what you thought was private property. Private, by definition, is absolute and exclusive. It's not private unless it's absolute ownership that you don't have to share and which you can control every other use of. Otherwise, you don't own anything. And they're lying if they say you're the owner at that point. If it really is private, that you can control everybody who uses or benefits from the thing, and you can charge whatever you want for the use of that thing. And you can take it back anytime you want, and you can impose conditions on the loan of that property to anyone. And you can retain ownership even after they physically received the property, as long as you gave notice to the person receiving the temporary custody. And that's exactly how all franchises work. Is your ignorance of law and the rules of converting property causing you to unknowingly donate property to the government, or to condone and further government theft? The only difference between theft and donation is consent. Do you know how you gave consent? And more importantly, are you insisting that the government prove that consent? Because if you're not, then now you're their servant. If they have sovereign immunity and you need their consent to sue them, then they ought to need your consent to sue you or to take your property, right? How come you're not enforcing equal rules? That's what being sovereign is all about. It's being equal to the government. And Obama said in his inauguration speech that all are equal and all are free. Then that must mean that you're equal to the government. And if you're not, you're a slave. End of discussion. Because all your freedom comes from equality of rights. If you're not equal to the government, you're a slave. And all you have to do is be unequal in one small little area, and they can destroy every one of your other rights. Every one. And that's exactly what Pharaoh did to the Egyptians during the famine. And that story is in the Bible. When there was a famine and the people absolutely had to have food, and they were going to die if they didn't have it, and they came up to Pharaoh asking for food, Pharaoh placed conditions on the loan of his wheat to the Egyptians. And he said, if you want food, then you're going to have to give us all your money. And so he stole all their money. And then he came back again a second time and said, now, if you want more food, you're going to have to give us all your land. And then he took all their land. And then the third step, when they're still hungry, he placed another condition, and he said, now if you want food, you're going to have to sell your kids into slavery. So now they sold their kids into slavery. And then the last step was for them to sell themselves into slavery. And at that point, when the famine was 5 or 7 years in, Pharaoh owned all the land, all the money, all the kids, and all the Egyptians. And then he took all those things and he put them inside of a big walled city, a gated walled city, because that was his ranch, his corral, and he put all his cattle in there. That's what a city is. That's what the very first city in the Bible was, Babylon. Nimrod was the ruler of that city, and he was described in the Bible as a mighty hunter. And the thing that he hunted was not animals. He hunted men. And the cage for the animals that he hunted and trapped was the walls of the city, and the laws that kept people inside those walls, and the laws that protected and regulate his cattle inside those walls. That's how it works. That was the model of the government from the very beginning, and that's why God says you can't contract with the government, because you're going to become their prisoner and their slave and their chattel and their property and their cattle and everything else. Keep that in mind. And is your ignorance of the law and the rules for converting property causing you to aid and abet conspiracies by public servants to deceive you about what the law permits and requires, and to deprive you of your constitutional rights? And the answer is absolutely yes. Our enemy here is not the government. The enemy is illegal ignorance, your illegal ignorance, that allows and condones them to continue doing all this usury that they're doing, and all this violation of the Constitution, and this violation of their oath as public officers to protect your private property. So now let's compare private versus public franchises. So we have the characteristic on the left here. We have public or government franchises in the middle column, and we have private franchises on the right. The franchise agreement is, under public government franchises, the civil law associated with the domicile of those who are statutory but not constitutional citizens or residents within the venue of the grantor. Now, in the case of private franchises, the franchise agreement is private law among all those who expressly consented in writing. If you didn't sign up for the McDonald's franchise, then you're not subject to it, obviously. You have to consent, and you have to do so in writing. And every government franchise should be exactly the same way, and in fact it is, because you have to walk in and fill out an application to be subject to the terms. Consent to the franchise is procured by, in the case of government franchises, implied by action of the participants, using the government's license number or declaring a status under the franchise, such as taxpayer, on a government form. Those are the two ways that you invoke the protections, benefits, and privileges of the franchise. And in the case of private franchises, the consent is expressed by signing a written contract absent duress. Franchise rights or privileges are the property of, in the case of public franchises, the government, the de facto government, if property is outside of federal territory. Okay, so the thing being loaned is the franchise right. So the Social Security card or the driver's license or something like that is the thing that's being loaned by the government. That is the franchise right. And under private franchises, the human being or private company, under the franchise, so under private franchises, the property being loaned or gifted or granted is owned by the human being or the private company instead. The choice of law governing the disputes under the franchise agreement in the case of public franchises is the franchise agreement itself, which is then governed by Federal Rule of Civil Procedure 17b. In the case of franchise provisions of private franchises, it would be the franchise agreement only. Every franchise usually has what they call a choice of law provision, which governs the law, the civil law in this case, that will be used to govern disputes between the parties to the franchise. Disputes are legally resolved in the case of government franchises, in Article 4, Section 3, Clause 2, statutory franchise court with inequity, meaning inequality. The government is the arbitrator of its own franchises, which is wrong. And typically in a franchise court, there's no jury. So, and the singular judge who rules over the issue, like in tax court or traffic court, that singular judge always has a conflict of interest. And his only goal is to generate revenues for the government. And if you walk into a traffic court, the only thing the judge wants to talk about is when can you pay and how much can you pay and how much can you afford. That's all he'll talk about. So in effect, you could say that he's purposefully availing himself of commerce in your otherwise private life, and he's stealing from you if you didn't consent to that exchange of commerce. And an example of a person who didn't consent is somebody who wasn't a driver, or even somebody who had a license but wasn't on official business using the public roadways for hire. That also would be a person who didn't consent and can't consent to be a public officer driver, and therefore is being stolen from if he's fined or taxed or regulated. Moving on, courts officiating disputes operate in the case of government franchises, political context and issue political opinions. And in the case of private franchises, legal context and issue legal orders. Because why? Because the contract is law between the parties. And so whereas in the case of public franchises, they're operating in a political context. Why? Because all franchise courts are in the executive branch and not the judicial branch. And the executive branch is a political branch. And so these franchise judges, without a jury box, essentially are administrators, public officers, and public employees who are officiating a dispute among fellow public officers within the executive branch and not other branch of the government. And they essentially act as a binding arbitration boards for fellow disputes between fellow public officers in only the executive branch. And they can only preside by consent, because you have to consent to be a public officer. You have to consent to serve in the executive branch. And you have to be lawfully elected or appointed, period. And the parties to the contract in the case of public franchises are public officers within the government, grantor of the franchise. And in the case of private franchises, they maintain their status as private parties. In other words, they're not subject to civil laws unless they want to be, and unless they have a domicile in that jurisdiction within that government. A domicile of the franchise participants, the effective domicile, is federal territory. Under the government franchises, see 26 U.S.C. 7701A39 and 7408D. And under private franchises, the domicile of the participants is wherever the parties declare it or express it in the franchise. And that domicile can be different from the choice of law rules in the franchise contract itself, because McDonald's headquarters may be in San Diego like it is, and yet the franchisors, the franchisees, could be in any country in the world. And ordinarily, if you have a dispute with somebody in another country, you have to go into the courts of that country to settle the dispute. But the franchise agreement in the case of McDonald's dictates choice of law, and it says that it has to be litigated under the laws of California and not the place where the fast food office is physically located, like Hong Kong. Or you don't have to use the courts of Hong Kong. You have to go to the California civil courts and invoke only the contract, the provisions of the contract. So in effect, the effective domicile of the franchisee in Hong Kong, if the McDonald's chain office was in Hong Kong, the effective domicile for the purpose of that dispute then is California, if there ever is a dispute, under the choice of law rules within the franchise itself. So when is government operating a franchise as a private company in equity? When domicile and one's status as a statutory citizen, resident, or person under the civil laws of the grantor is not required in the franchise agreement itself, or is in the franchise agreement but is ignored or disregarded as a matter of policy and not law by the government. For instance, the government ignores the legal requirements of the franchise found in 20 CFR 422.104 and insists that everyone is eligible and to hell with the law. So an example, and that particular regulation governs Social Security. And they can only offer Social Security to people who are citizens or permanent residents of the United States, meaning federal territory, meaning that they're not within a state. And the definition of state in Section 1301 of Title 42 confirms that a state is not defined as a constitutional state. So they can only offer Social Security within a federal territory that is listed in Title 42. And they may not offer it in a constitutional state. And what we're describing here is that even though the law requires that it cannot be offered to people in a constitutional state, if they ignore that requirement, that constraint upon the law, and they offer it anyway, at that point they cease to be a government. Because now they're operating outside their territory, they're operating against people they're not authorized to protect, and they're operating in a private contract capacity only. Because the only way that they can reach outside their territory, per the common law and the maxims of law, is either debt or contract. And so, and domicile is one type of a contract or compact or protection franchise, but another type is just the Social Security franchise contract itself, or agreement, or compact. And if that alone is the source of jurisdiction, because the party they're offering it to does not have a domicile on federal territory, then we would allege that they're operating as other than a government. And at that point, they may not invoke the protections of the Foreign Sovereign Immunities Act against their activities. At that point, they have to operate in equity, and they may not assert official, judicial, or sovereign immunity. Why? Because they're not acting as a government. Because all law is territorial, and they're operating outside their territory. So they're not a government anymore. In fact, they're just a private business activity, and they're competing with other private business activities, and they have to operate on an equal footing with those other businesses. And another way of saying that is they're exceeding their delegation of authority order, and therefore they're outside the bounds of the law and the territory associated with that law. And at that point, they're operating in equity, and they may be sued as a private party under the Foreign Sovereign Immunities Act, just like any other government. And in the case of a state, if you sue them in a state, under state law, you would invoke what they call the minimum context doctrine and the long arm statutes of that particular state. Moving on. So when, again, is the government operating a franchise as a private company in equity? When either of the two above conditions occurs, then the government is engaging in them. It is engaging in private business activity beyond its core purpose as a de jure government, and is abusing its monopolistic authority to compete with private business concerns, and it is purposefully availing itself of commerce in the foreign jurisdictions, such as states of the Union, that it operates the franchise. And it's implicitly waiving sovereign immunity under the Foreign Sovereign Immunities Act, 28 U.S.C. Chapter 97, and its equivalent act in the foreign jurisdictions that it operates the franchise. And it implicitly agrees to be sued in equity in a constitutional court if it enforces the franchise against non-residents. Why? Because it's enforcing foreign law against non-consenting non-residents, and it's engaging, therefore, in acts of international commercial terrorism. Why? Because the enforcement of the franchise provisions outside its territory against non-residents threatens human life. In many cases, it engages it involves all the same activities as real terrorism does. A real terrorist typically kidnaps people and threatens human life, and also threatens acts that are threatening to human life. And to put an example, and compare that with what the IRS does in foreign states, that is states in the Union, by enforcing national law that applies only in federal territory to a constitutional state, they're violating Article 4, Section 4 of the Constitution. They're waiving their sovereign immunity because they have no delegated authority to operate in a state. And if you doubt that, look at the definition of state in the Internal Revenue Code and 4 U.S.C. Section 110D, and you'll see that the state does not include a state of the union. So they can't operate there. There are no internal revenue districts there. They're operating outside their delegated authority, and therefore they waive official, judicial, and sovereign immunity. They waive sovereign immunity under the Foreign Sovereign Immunities Act, and they're also engaging in terrorism. Because, why? Because the enforcement actions they engage in those foreign jurisdictions, those legislatively foreign jurisdictions, Those enforcement actions are threatening to human life because if you can't feed your face, you die. If they take away all your money so you can't feed your face, then you die. And if you want to prevent dying and you go out and you can't collect anything, you can't even collect your own pay because they'll levy it all, then now they're forcing you to commit crimes just to even support yourself so you won't die. So that causes further acts of violence. So the indirect effect is that violence occurs because you can't feed your face, and your life is threatened, and you're going to die without the ability to feed your face. And in order to implement the enforcement and justify it, they had to legally kidnap you, and they had to transfer your identity to the District of Criminals. That's what Mark Twain calls it, in order to justify and protect that enforcement action. And justifying it in that way is most often a misrepresentation of their authority, because they have no jurisdiction and they know it. And the only defense they typically have for that sort of terrorism is they'll say that your response is frivolous. But guess what? If the only law they can quote in their defense is law from your domicile, and you're not domiciled within their jurisdiction, they can't even quote their own laws to justify what they're doing, because they don't apply outside their territory. So even any attempt to even represent that their laws apply in a foreign jurisdiction is fraud, number one. And number two, if they insist that it obligates you, they're engaging in identity theft by connecting you to a status of taxpayer, citizen, and resident that you don't have. That's called identity theft. And identity theft is the moral equivalent of kidnapping. So they're kidnapping you. And that's what terrorists do, is they kidnap you. So moving on, they cannot truthfully identify the statutory franchise courts that administer the franchise as government courts, but simply private arbitration boards, as we described earlier. If you get dragged into tax court, or if then in effect, you can't even go into a tax court unless you're already in the government as a public officer and exercising the benefits, privileges, and protections of the franchise in that. And the court itself is in the executive branch, so it's technically not a constitutional court under Article 3. And there's no jury, so you're being deprived of due process under the Constitution. And the judge has a criminal conflict of interest in violation of 18 U.S.C. 208 and 28 U.S.C. 144 and 455. So he's got a criminal conflict of interest, and he has to recuse himself anyway. And so there's no way you're ever going to get justice in a tax court or any kind of franchise court, whether it's a traffic court or a family court. Don't ever expect justice, and that's why you should never ask for any license or privilege or benefit of any of those courts, and you should never sign up for any of those benefits. And you're an idiot if you even call them a benefit. You ought to define everything they provide as an injury. Absolutely everything they provide is an injury, and at that point, all they can do is leave you alone. If the only thing you ever want to be protected from is the government, and their first obligation is to protect your right to be left alone, that's what justice is defined as, then you're free. You're truly free, because at that point you're equal. You're not obligated to do anything for them. They're not obligated to do anything for you except leave you alone. And the minute they cease to leave you alone is the minute they're terrorists. And the fact that we call them terrorists may be why they're turning around and calling all sovereign citizens terrorists. Because in effect, they're committing a Freudian slip. They're calling other people that which they really are, to divert attention from their own problem. When are they going to level with the public? Because right now, everything they're doing is propaganda and fraud. So remember, all de jure government law is territorial in nature. And here are some examples. Foley Brothers versus Falardo, 1949 U.S. Supreme Court. It is a well-established principle of law that all federal regulation applies only within the territorial limits of the United States unless a contrary intent appears. And that word territorial is important, because if you look up the definition of territory under the legal dictionary or especially the legal encyclopedia, you'll find out that a territory does not include any state of the Union. So it only applies on federal territory. Here's another one from the Supreme Court, 1894. The laws of Congress in respect to those matters that is outside the constitutional delegated powers do not extend in the territorial limits of the states, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. And U.S. versus Spellar, U.S. Supreme Court, there is a canon of legislative construction which teaches Congress that unless a contrary intent appears, legislation is meant to apply only within the territorial jurisdiction of the United States. So keep that in mind. All law is territorial. They cannot enforce the law outside their exclusive territory, and states of the Union are not territory within the meaning of the Constitution or any enactment of Congress. So, de facto government law is not territorial, but instead is implemented exclusively through your consent and right to contract like any other private business or franchise, like McDonald's. The minute Uncle starts acting like McDonald's and extends its influence and its property exclusively by the right to contract and ignores their domicile prerequisite, that's the minute they cease to be acting as a government. They're just acting in equity as a private business activity, competing with all the other private businesses in that region. And at that point, they have to waive sovereign immunity. And if they don't, then technically they're instituting what we call a title of nobility, because they want to be above and beyond and better and have more power and more rights than the other person they're litigating against. And another way of saying that is they want to establish a religion, because that's what religions do. They worship superior or supernatural beings. They want to be supernatural. They want to have more rights than the natural. They want to have more rights than other private businesses in that region. And they're not allowed to do that. The Constitution does not allow titles of nobility. and if it prohibits titles of nobility, whether Congress does it by legislation or whether judges do it by fiat, and sovereign immunity, by the way, is a judicial fiat provision. It's not. There is no law that mandates sovereign immunity. It's just there, and it's created by judges, and so it's judge-made law, as they would say. So they're operating in a de facto mode also if the law is not territorial, but instead has a purpose opposite to that of any government, in that it aims to alienate rights that are supposed to be unalienable, and therefore turns the public trust into a sham trust. Because what is the public trust for? Meaning government. It's there to protect private rights. If they make a business out of converting those rights to public rights and stealing them, can they really be claiming to be a government? The answer is absolutely not. And we would argue that's the only thing they ever do anymore. They don't even recognize private rights, much less protect them. If you want their protection, they insist that you prove that you're a citizen, that you're subject to the statutes, that you're subject to the franchise, that you essentially have no rights, that they're a god who has supernatural powers, and that they can do anything they want with any part of your property. Would you call that protection? I'd call that slavery, wouldn't you? So by territorial, we mean it attaches to property located on federal territory or to people domiciled on federal territory. So if they operate extraterritorial, outside the territory, the land, the federal territory that they have exclusive jurisdiction over, then they're not operating as a government at that point. They're just a terrorist organization, like any other terrorist organization. They want to kidnap your legal identity and transport it to a place where they have jurisdiction over it, or they want to steal your property through theft and deceit, or they want to compromise your ability to support yourself and therefore threaten your life, because that's what terrorists do. So how are franchises undermining the Constitution? Well, franchises, when they're enforced against those domiciled outside of federal territory, replace equal protection with inequality, partiality, and unconstitutional titles of nobility. And we prove that. Requirement for equal protection and equal treatment, Form 05.033, and they constitute an act of international terrorism and an invasion in violation of Article 4, Section 4 of the United States Constitution, if implemented in a State of the Union against non-consenting parties. States of the Union are nations under the law of nations in nearly every particular. And Congress admitted that, I believe, in Bank of Augusta. And franchises also destroy the separation between what is public and what is private. See, public versus private employment. You really work for Uncle Sam if you receive federal benefits. So another way of saying that is franchises confuse and destroy the separation between what is public and private. And by doing that, they make everything public. And once everything becomes public, in effect, they're a socialist government, because that's what a socialist government is. It's a government where the government either owns everything or controls everything. And there's no difference between owning and controlling it. Even if the title of the property is held in your name, if it's held by a citizen, then and that citizen is a statutory citizen, and that statutory citizen is an office in the government, then indirectly the title of the property is held by the government, right? And you're just the custodian over it, right? Well, that's where their authority to tax it comes from, is the fact that they own it, and that title is held as an agent and trustee of the public, called a public officer. And that's what you are. If you say you're a U.S. citizen, or you're a U.S. person, or an individual, or a person, or a taxpayer, or anything else under their franchise codes, if you invoke that status, any of their statuses, anything they created in any of their courts, they're going to treat you like an employee. And in effect, they will replace the citizen-government relationship with the employer-employee relationship. And at that point, you're toast. Your property, your chattel, your cattle on the government plantation, you are wholly owned subsidiary, you're an office within the government, and at that point, the Form 1040 is just a profit and loss statement for a federal business trust. And the office is the taxpayer, and you are the trustee and the officer over the corpus of that trust. And everything in that trust is what you put on the tax return. And I can prove that, because everything on a 1040 allows for trade or business deductions. And you cannot claim a trade or business deduction without being a public officer. And if you do, you're impersonating a public officer. So, moving on, the franchises destroy the separation between the states and the federal government. And so let's go to the next page here. Franchises destroy the separation between the states and the federal government. Most states' constitutions forbid public officers of the state from simultaneously acting as public officers of the national government. Kickbacks from the illegal enforcement of income taxes through the ACTA system bribe state officials to enforce state income taxes against parties who are not subject because not domiciled on federal territory within the exterior limits of the state. For more information, see Government Conspiracy to Destroy the Separation of Powers, Form 05.023. And franchises cause judges and prosecutors to have a criminal and illegal conflict of interest between protecting private rights on the one hand and making a lucrative business out of taxing, regulating, and destroying them on the other hand. The Bible talks about this conflict of interest, and it says no man can serve two masters, God and mammon. By mammon, they mean money. And we might also put government in the category of money, because that's all they care about. So either you're going to serve the interest of justice and private rights, and the God who owns all those private rights, or you're going to serve mammon and public rights, and all the men instead of God, who claim they own those things, but don't own them. Because the Bible says that God owns the heavens and the earth. He owns everything. He owns you, he owns the land, he owns the heavens. And therefore, in effect, if the same rules applied to the government as they apply to you, then essentially God is loaning his property, which is everything, to Caesar. And he created all that, and that's why he owns it. And that's why he owns you, and that's why he owns every government that uses his land and every person who owns his land. And in that sense, you could say the earth is a franchise, and the Bible is the franchise or trust indenture. And God is entitled to charge rent for everybody that uses his property. And the rent in this case is Caesar's obedience to God's laws. And Caesar doesn't want to obey God's laws, because then he can't pretend like he owns everything or he created everything, and therefore he can steal whatever he wants. In effect, what he's doing is the same thing Satan did. Caesar, that is. Caesar is trying to rent that which is not his property, which is the earth, to you and I, who are believers, and we are not allowed by God's trust indenture, his delegation order in the Bible, we're not allowed by his trust indenture to recognize Caesar's ownership of the earth or any part of the earth, or Caesar's authority over any part of that, unless those people who are served by Caesar consent to whatever it is Caesar does. So, and by implication, you could say that when Jesus said, "Render to Caesar that which is Caesar's," under our legal system, the owner of a thing is, and the creator of a thing is the owner of a thing. So, since Caesar didn't create anything, then Caesar doesn't own anything, and there's nothing to render to Caesar. So, indirectly, Jesus, by saying, "Render to Caesar that which is Caesar's," indirectly, Jesus was admitting that render nothing to Caesar. He was just being very indirect about it. And he never bothered to define what he meant by what is Caesar's. And if he had, his head probably would have been chopped off if he had been faithful to what God's law says. It also causes conflicts of interest in the federal courts because they cannot be judges, and prosecutors cannot be taxpayers and federal benefit recipients at the same time. And yet they also hear matters that could reduce those benefits if they enforce the law as written. And an example of that is a federal tax trial where the federal prosecutor in the voir dire process selects jurors who are on federal benefit payments, like Social Security, because those are oftentimes the only people who have free time to sit as jurors without destroying their businesses. So they pick a bunch of people receiving federal Social Security check benefits that derive directly from the taxes at issue, and since the judge's compensation is paid for out of those same taxes, and he receives those same benefits, and so does the prosecutor, you got a full room full of federal benefit recipients, and you're the only sponsor in the room in the context of that procedure as an alleged, quote, taxpayer, unquote, and the prosecutor will illegally walk in front of the jury and they'll create a criminal conflict of interest by telling the jury that who is our benefit recipients and tax consumers, by telling the jury, this person, this so-called taxpayer, is living in this country and receiving the, quote, benefits, unquote, of being here. And because he doesn't want to pay his fair share, then he's going to reduce your benefits, Mr. Juror, and your benefits, Mr. Judge, and he's going to raise the cost of those benefits that you're going to have to pay to receive those benefits. Now, what do you think about that? And so you could say, whenever they do that, they're committing a crime, and if the judge doesn't immediately stop the prosecutor, he's complicit in that crime, and the crime that's being committed is a violation of 18 U.S.C. 208, 28 U.S.C. 144, and 455 in the case of the judge, and it's also a conspiracy against rights, because by not saying anything and not doing anything, the judge is also criminally liable for the crime, and if he doesn't report it and doesn't prosecute it, he's criminally liable under 18 U.S.C. 3 and 18 U.S.C. 4. He's committing misprision of felony, and he's an accessory after the fact to the crime, and he's in conspiracy to the crime if he agrees with the prosecutor. And so at that point, the whole courtroom is vacant, and there are no public officers in the courtroom because the jurors have a conflict of interest, so they're not really jurors. The judge has a conflict of interest, so he's not really a judge, and the prosecutor has a conflict of interest. So essentially what they have is just a room full of an angry lynch mob who are operating outside the law, which is exactly what happened to Jesus. When Caesar couldn't find anything, Pilate couldn't find anything wrong with Jesus, he washed his hands and he threw Jesus to the crowd. And that's exactly what a judge does if he doesn't stop the prosecutor from doing this. Or if the judge is a taxpayer or a benefit recipient, if the prosecutor is a taxpayer or a benefit recipient, or any of the jurists are, then at that point, the law is not operating in that courtroom. And the whole courtroom is just a lynch mob. And the judge is in charge of the lynch mob, and he makes sure that it turns into a lynch mob because he'll make sure that the defendant, are not allowed to talk about what the law requires. And so at that point, the only thing left is for the jurors to operate out of whim and emotion and to hang you. And when they do that, they're not acting as agents of the law. If you can't discuss the law, then you can't act as an agent of the law. And in most cases, in most federal courtrooms, not only are you're not allowed to talk about the tax laws in front of the jury, you're not even allowed to read those laws if you're a jurist. You go into the law library in any federal building and ask the law librarian for a copy of the orders to the law librarian about whether the jurors are allowed to come in and read the law on their break. And you'll find out they're not allowed. They'll be kicked out. And the reason is because the judge wants to substitute his will and his whim and the prosecutor's whim and an angry benefit consumer whims of the juries. They want to substitute political whim and emotion in place of what the law actually says. And that is anarchy. That's what anarchy is. It's a failure to be bound by what the law requires. It's complete anarchy. And to call a sovereign citizen, so to speak, an anarchist, and yet to do that sort of thing is complete hypocrisy. So we emphasize here that the above consequences gut and destroy the foundation of the federal and state constitutions, which is equal protection and the separation of powers. Okay, the separation of powers requires that all the decision makers cannot have a conflict of interest, that the judge has to be in a different branch than the prosecutor, that the laws that are being administered are fairly represented, and that you cannot be reached by those laws unless you consent to them if they're civil laws. And they never abide by any of those constraints. So in essence, we have a society of men and not law. And the men who are administering the system are the judge, the jury, and the executioner. And they're not on official business because they all have a conflict of interest. They all have waived their official judicial and sovereign immunity, and they're acting as private parties with an extreme bias. And in a sense, you could say in those circumstances, the prosecutor is using the jury and the judge as a, quote, weapon of mass destruction, unquote. And the thing they're destroying is private rights and private property, and more particularly, your private rights and your private property. And that, as we said, is an act of international terrorism because the states are nations, and the first duty of the federal government is to protect those states from invasion under Article 4, Section 4. It's the only mandate in the Constitution. And what they're trying to do is commercially invade the states by offering contracts and franchises that they're not allowed to offer in those states, and enforcing private law in those states, and bribing public officials with the revenues generated to look the other way while a foreign invader comes in and terrorizes them and steals their property. Now, would you qualify that sort of a process as protection on the part of the state governments if they accept the bribes to overlook their violations, the federal violations of your private rights? That is the most devious and dubious and evil conspiracy we've ever heard of. Moving on. So an early congressman described the abuse of franchises to undermine the Constitution. And here's how he described it. This was on June 10th, 1933, in the Congressional Record, during the debates of, guess what? The Social Security Act. And here is what this congressman said. He said, Mr. Logan, natural laws cannot be created, repealed, or modified by legislation. Congress should know there are many things which it cannot do. It is now proposed to make the federal government the guardian of its citizens. If that should be done, the nation soon must perish. There can only be a free nation when the people themselves are free and administer the government which they have set up to protect their rights. And by rights they mean here private rights, not public rights. Where the general government must provide work and incidentally food and clothing for its citizens. Freedom and individuality will be destroyed, and eventually the citizens will become serfs to the general government. And by serfs, they really mean slaves, cattle, property, chattel, and so on. Okay? If the minute that they offer franchises outside their territory to people in a foreign state and do so through an act of private contracting and ignore the domicile prerequisite and do so outside their delegated authority, and do so, in many cases, against the consent of the people they're offering the franchise to, and then presume that these people consented, and then proceed to steal all their property, we have an invasion, we have a commercial invasion, we have terrorism, we have identity theft going on because they're transporting the civil identity of these people to a foreign jurisdiction. We have also have terrorist activity because they're threatening human life, because the minute they take away your properties, the minute they take away your ability to sustain your own life, in which case they threaten your life. So it's terrorism in every respect. And here's what the Founding Fathers said about this same terrorism. They said, if men, Samuel Adams said in 1772, if men through fear, fraud, or mistake should in terms renounce or give up any natural right, the eternal law of reason and the grand end of society would absolutely vacate such renunciation. The right to freedom being a gift of Almighty God, it is not the power of man to alienate or contract away this gift and voluntarily become a slave. And George Washington, in a letter to Patrick Henry in October 9th, 1775, also said, quote, "My ardent desire is, and my aim has been, to comply strictly with our engagements, all our engagements, foreign and domestic, but to keep the United States free from political connections with every other country, to see that they may be independent of all and under the influence of none. In a word, I want an American character that the powers of Europe may be convinced we act for ourselves and not for others," as public officers, for instance. "This, in my judgment, is the only way to be respected abroad and happy at home." And when he talks about independent, he means self-supporting. He means responsible for yourself. He means not receiving government benefits. He means not having political ties to somebody who supports you or contracts to somebody to support you. And that's also what he means by political connections. He's talking about contracts. So indirectly what he's saying is you're not allowed to contract with a government, and you have to remain free and independent. You have to remain self-supporting. That's what a republic is. That's what a republic is. It's a nation of free people who have no ties, no contractual ties, no obligations whatsoever to any ruler, and whose only obligation is to prevent hurting other people. That's it. And that is exactly what George Washington is describing here. And the Bible, the Bible talks about this. It says you cannot enter contracts, agreements, or franchises with the people in the land that you're in, because they'll become a snare to you. And George Washington is recognizing exactly the same thing here in a different context, in a political context, but it's the same thing. So indirectly, he's attacking franchises. And now here is what Thomas Jefferson said in his first inaugural address on March 4th, 1801. He said, "About to enter, fellow citizens, on the exercise of duties which comprehend everything dear and valuable to you, it is proper that you should understand that what I deem the essential principles of our government, and consequently those which ought to shape its administration. I will compress them within the narrowest compass they will bear, stating the general principles, but not all of its limitations. Equal and exact justice to all men." In other words, everybody has to stay equal. And the minute you sign up for a franchise, you're unequal. So implicitly, he's saying here, you cannot participate in franchises. That's the whole purpose, is to create inequality, to create a state religion, to make the government superior and supernatural, and to make you into the worshiper and servant and participant in their church of socialism. Okay? And he's saying of whatever state or persuasion, religious or political. Now he says, peace, commerce, and honest friendship with all nations, entangling alliances, that is, contracts, treaties, and franchises, with none. So in other words, even Thomas Jefferson, like the Bible, recognizes that you cannot contract away and should not contract away rights to any government, okay, through a franchise or otherwise. And interestingly enough, he was also the author of the Declaration of Independence, and he identified those same rights, those natural rights, as unalienable. So in other words, he made sure when he wrote the Declaration of Independence that you're incapable, legally incapable, and not allowed to contract away those rights. Okay? And so this just reinforces his intent here. And here is what the Bible says about the same subject. Exodus 34:12. "Take heed to yourself, lest you make a covenant or mutual agreement, that is, contract or franchise, with the inhabitants of the land to which you go, lest it become a snare in the midst of you." Now I remind people who are believers and Christians that the Bible says that Christians are to be in the world but not of the world. And what that means is you can be physically in the world, but you can't have any contracts or franchises with the governments of the world. That's what it means, literally. And if you do, then you're, in effect, nominating a king. And 1 Samuel 17 says you're not allowed to have a king. And if you do, you're committing idolatry and you're firing God as your protector. That's what it says there. Go back and read it. 1 Samuel. Moving on, Exodus 23:32 through 33, the same thing is repeated again. "You shall make no covenant, that is, contract or franchise, with them, that is, the foreigners and pagans." And why are they foreign and pagan? Because they're under different laws than you. You're under God's laws. They're under man's laws. So they're foreign. Okay? You can be foreign because you have a foreign domicile. You can be foreign because you have different laws that you live under, or both. And that's what choosing a different domicile means. If you choose a domicile within God's jurisdiction on his land that he owns, then you're not subject to Caesar's civil jurisdiction, in which case you can't have a pagan ruler. You can't have a human ruler. In that case, you can only be ruled by God's civil laws. It says, nor with their, that is, the pagan government laws, God's laws or judges. They shall not dwell in your land, and by implication, and you shall not dwell in theirs by becoming a resident or domiciliary or citizen in the process of contracting with them, lest they make you sin against me, that is God. For if you serve their gods, that is, under contract or agreement or franchise, it will surely be a snare to you. And that snare is exactly what we described at the beginning of this presentation. It's a trap. It's a mouse trap. And it's loaded with the benefit bait. And Caesar is going to snare you with your own money. He's going to put your own money in that he stole from you, and he's going to put it on the trap and call it cheese and call it a benefit and make you fill out an application to get it back and surrender every one of your rights in the process of getting it back, and thereby making you into a slave 24/7. And we also remind the readers that Satan's original sin was the abusive commerce that enslaved people, such as the abuse of franchises. And here is what it says about that subject in Ezekiel 28:13 through 19. By the abundance of your trading, that is commerce, you became filled with violence within, and you sinned. And he's talking about Lucifer, Satan here. Therefore I cast you as a profane thing out of the mountain of God, that is the Garden of Eden, and I destroyed you, O covering cherub, from the midst of the fiery stones. Your heart was lifted up because of your beauty. Now, notice that word lifted up. In other words, he placed himself above everyone else and above the law. All law, including God's law. Okay? And that's what government does. It seeks to be a God unto itself. It seeks to be the source of all law. And it seeks to be subject only to those things that it consents to. Anyone who can claim that they have sovereign immunity like a corrupted government and exclude itself from any and every law that it wants to is lawless. And that's the essence of being satanic. That's the essence of being an anarchist, is that you're lawless. So you could say that the origin of all lawlessness is the government, if it asserts sovereign immunity. Because, as Thomas Jefferson said earlier, equal justice, meaning everybody is subject to the law and everybody has the same obligations under the law. And the extent that they don't is the extent that the state becomes a religion with supernatural or superior powers, and you become the compelled worshiper, and the civil code becomes the franchise under which you receive the, quote, benefits, unquote, of Caesar's rulership. And we know that that's not really rulership. We know it. They're just going to steal. They're going to lie. They're going to claim they own everything. They're going to put strings on everything, and they're going to make you into their pet, their cattle on their plantation called a city, on their bigger plantation called a nation. So Christians are not allowed by God to do that. And he goes on, you corrupted your wisdom for the sake of your splendor. In other words, you wanted to look good. You wanted to be better than everybody else. You want to be above everybody else. And therefore, you violated every common rule, every common sense rule, every sense of equality, which is the foundation of justice, so you could be higher than everybody else. And he says, I cast you to the ground. I laid you before kings, that they may gaze at you. You defiled your sanctuaries. And what are those sanctuaries he's talking about here? He's talking about the District of Criminals. That is a civic temple. That's what the Congress called it during the debates of the 16th Amendment. They called the District of Columbia the civic temple. So they're defiling the civic temple because the civic temple is there to worship the sovereign. The sovereign is not the government. It's not anybody in the government. It's the people as individuals who make up the collective. Okay? And the collective can have no more rights than a single individual. You cannot delegate what you don't have. And therefore, the collective cannot delegate to the government any more than a single individual has. And therefore, the government has to be equal to everybody. And the minute it ceases to be equal is the minute that it's been defiled. And because once those unequal relationships enter, then whoever it is that's above you is going to auction your rights off to the highest bidder. And that's exactly what's happening now in Washington, D.C. We would argue that's the only thing that ever happens. That's the only thing any politician ever cares about, because that's the only way they can attract donations to their reelection fund. Moving on, by the multitude of your iniquities, by the iniquity of your trading, and iniquity of trading really means here, it means inequality of trading. if you trade with somebody else and you get a better benefit out of it than they do because of your political position or the fact that you write the laws or the fact that you're not subject to some of those laws, the minute you have an unequal trading position is the minute it becomes iniquitous trading. We refer to iniquity as inequity. Okay, if you're unequal in relation to the person you're trading with, you're always going to lose. You're always going to get screwed. And you're going to dishonor the other person. You're going to abuse the other person because that's human nature. You're always going to get whatever the market allows. And that's what politicians do. They're going to put whatever they want into the law, whatever they can get away with, whatever people, are willing to tolerate because of their own legal ignorance. So God says, therefore I brought fire from your midst. I brought fire from your midst. It devoured you. And I turned you to ashes upon the earth in the sight of all who saw you. All who knew you among the peoples are astonished at you. You have become a horror and shall be no more forever. Okay? So he's really talking about Satan's original sin. And it was trading, iniquity in trading, thinking he was better than everybody else, thinking he was like God, right? Isn't that what a God is? Somebody who's superior to everybody else? Somebody has supernatural powers, meaning above the natural, meaning above your rights and rights and abilities, your natural rights, your constitutional rights. Anybody who claims to have rights above your rights is supernatural and is acting as a God, because that's what a God is. A God is anybody that's above anybody else, who has more rights and abilities under the law than anybody else, and who is the object of worship. And worship is legally defined as obedience to the laws of one's religious sovereign. And that's exactly what the civil laws do. They mandate and compel obedience to the laws of a superior power, which is a government. Okay, so there's no difference between law and religion. They're twin sisters. As a matter of fact, it is a maxim of law that the obedience is the essence of the law. And Jesus said, "If you love me, keep my commandments." So the essence of God is love, and therefore the essence of religion is obedience and worship to the laws of a different sovereign, which is God. So let's talk now about criminal provisions of franchise agreements. Some franchises have penal provisions. All such provisions, in effect, amount to contractual consent to be punished or incarcerated. And punishment absent proof of domicile or residence within the jurisdiction of the grantor is a criminal violation of rights. Why? Because, as we said, domicile is a prerequisite to every de jure franchise. And the minute they disconnect the domicile requirement and operate entirely by contract is the minute they cease to be a sovereign or a government and devolve into essentially a private for business, for-profit activity. Since all franchises are implemented with the civil law, then penal provisions of such contracts are, therefore, sometimes referred to as quasi-criminal, meaning they are falsely referred to as criminal, but actually are civil contract law. And they are enforceable in civil and not criminal court under the federal rules of civil procedure and not criminal procedure. And you could say that because all franchises are contracts or agreements that activate only upon your consent, then, in effect, if they're enforcing a penal provision within the franchise, for instance, the provisions within the Internal Revenue Code, 18 U.S.C. 26 U.S.C. 7203, failure to file, if they enforce that provision, which is a penal, not a criminal provision, against you, and the result of violating that provision is that you end up in jail, then, in effect, the franchise contract or agreement, that is the entire title, Internal Revenue Code title, effectively functions as a contract for you to become temporary state custody, temporary state property housed in a warehouse called a jail. And they're putting you in jail by your consent through contract or agreement. Okay? And the very first step in that agreement is for you to admit you're a taxpayer or not argue with people who call you a taxpayer. Keep that in mind. Because remember, all public rights attached to statuses, such as taxpayer, all private rights attached to land and not statuses, and not to the people on the land. For further details, see Government Instituted Slavery Using Franchises, Form 05.030, Section 12. So, how do you consent to franchises? There's lots of ways. Your continuing consent is what makes the franchise contract, gives the franchise contract the, quote, force of law. And here's an example from Bouvier's Maxims of Law, 1856. Consent makes the law. A contract is law between the parties which can acquire the force only by consent. In other words, you can't take somebody to court until they've consented to the contract. You can't go to court to enforce the contract until somebody consented. So the very first step in franchise enforcement, government franchise enforcement, is to insist that the government satisfies their burden proof as the moving party that you consented to the franchise and that you had the capacity to consent as a person not domiciled on their territory, and that you were above the age of consent at the time that you consented. And they can never satisfy any of those criteria, and that's why it's like pulling teeth to try and get them to even talk about that subject, because they know that they're going to dig themselves a hole and jump into it if they even talk about it. And you submit an application to participate in the franchise, such as an SS4, SS5, W7, W9, or W2. Or W4, we might add. Okay? All of these forms essentially connect you to a status that's subject to federal law. And it's illegal for you to even fill these forms out as a non-franchisee or a person who's not already lawfully engaged in a public office. You cannot elect yourself into a public office by filling out these forms. That's a crime. Nobody can be unilaterally elected to office. They have to be appointed or elected through a lawful election or a lawful presidential appointment. That's it. Otherwise, they're not public officers. And if they're not public officers, they can't use forms that are only available to public officers. And if you really are a private party, and then you own yourself, you own all your property, and you exclusively own that property, and you're the absolute owner, and you have the right to deny anyone and everyone, including any government, from the right to use, benefit from, or control the use of the property. Okay, so you can't be filling out public officer forms or letting other people fill out public officer forms and then claim you're sovereign or a taxpayer or free or a non-person or any number of other things. The walk has to match the talk. And every time somebody fills these forms out, if they had no authority to do it because you weren't in an office, then you have to file a criminal complaint against them with the government, and you have to make sure their own records reflect the fact that they're violating the law. And how you procure that evidence is up to you. But it's very important to have it. Otherwise, they're going to assume that you consented to the duties of the office, and you can't do that. And that, moving on, you do not rebut false reports by others connecting you to the consent to the franchise. See correcting erroneous information returns, Form 04.001. Otherwise private companies routinely complete and submit knowingly false information returns, such as the W-2, 1099, 1098, and so on, 1042. They're not allowed to submit any of those unless you are lawfully serving in a public office at the time, and unless they are already officers of the government. They cannot nominate themselves into being a statutory, quote, employer, unquote, because they're electing themselves into office. And only by being in office can they even fulfill any aspect of the law. The U.S. Supreme Court has said that a private citizen cannot write constitutions or laws or administer or enforce either. Okay? So you cannot claim to be an agent or officer of the law unless you've already been lawfully elected or appointed. You can't volunteer to be an enforcer, even without compensation, especially. Okay, most people who act as withholding agents and who file these false information returns are essentially filing false returns, and that's a crime. I believe that's 7201 in Title 26. It's a crime to file a false return. And information returns are false returns. And every one of those false returns must be prosecuted by the Department of Justice. And the fact that they don't do it is evidence that they're engaging in a conspiracy against rights, and that they're being bribed to overlook that conspiracy with withholdings made upon people who are not lawfully serving in public office. So they're engaged, in effect, in a protection racket. It's called racketeering. And how ironic that an agency created to protect the public has turned that into a franchise and made it into a protection racket. And a protection racket is nothing but a group of thugs with guns who steal your property, who hurt you, who threaten your life, who kidnap you by changing your identity and transporting it to the district criminals. It's just a gang of thugs who steal your property or demand property in exchange for the privilege of simply being left alone by them. And so the chief characteristic of a protection racket is you basically pay them a bribe for the privilege of them leaving you alone. But guess what? You should not have to pay for that privilege because the Supreme Court said in Olmstead that the Constitution confers that upon you, not the laws of Caesar, not the criminal laws, not the civil laws, but the Constitution itself doesn't create but recognizes your right to be left alone. Olmstead versus United States. So they cannot turn that constitutional right of being left alone from the government, they cannot turn that into a privilege and then force you to pay for it. And if they do, they're terrorists. And if you want more proof of that, look in Form 04.001. Another example is how you consent is you apply for or receive not perceived but real tangible benefits under the franchise as you define them and not the grantor defines them. So in other words, even if you do consent to a franchise, if the obligations are not mutual and the benefit is not mutual, then you really didn't engage in an act of contracting, did you? You're just engaged in extortion. That's what an extortion racket does. That's what a protection racket does. You know, you pay them a bribe and you get nothing in return except the right to be left alone. And that's not really a benefit because they don't have to do anything to deliver that benefit. They have to do nothing to deliver that benefit. So you're not getting any benefit. And the same thing would apply here. You know, you got to receive something of equal value in return, and it has to be a benefit that you determine, not the government. They cannot define something. They cannot define, for instance, racketeering as a benefit and then charge you for it, and then interfere with your right to declare that you don't regard it as a benefit. That's pure terrorism. And you can learn more about that and how to prosecute it in our form entitled The Government Benefits Scam, Form 05.040. This is a very common tactic that federal prosecutors use in tax trials that you need to be aware of. More ways on how you consent to franchises. You use the license number associated with the franchise voluntarily, or you do not rebut the use of the license numbers by others against you. This includes Social Security numbers and taxpayer identification numbers. Use the following when you aren't consensually participating in the franchises. Why it is illegal for me to request or use a taxpayer identification number, Form 04.204. So basically, you have to make sure that you create evidence proving that you didn't consent to use the number, that you cannot lawfully use it, that it cannot be used outside of federal territory, and that it cannot be used by anyone other than a public officer on official business, which you aren't. Okay? It's very important. Otherwise, you're presumed to consent to the office, in effect. Another way you consent is you claim a status described in the statutory franchise agreement, such as citizen, resident, individual, taxpayer, driver, spouse, person, etc. Or you do not oppose the use of such words by others against you. Use the following when you aren't a franchisee. Why you aren't eligible for Social Security, Form 06.001 in the case of Social Security enforcement, or tax form attachment, Form 04.201 in the case of income taxes, which are also a franchise, or affidavit of citizenship, domicile, and tax status, Form 02.001 if they're trying to enforce the obligations of the, quote, citizen, unquote, franchise. Because that too is a franchise. Everything they do is a franchise. And you have to consent to it before it obligates you to do anything. Governing maxims of law on this subject of consent. Sub silentio. Under silence, without any notice being taken, passing a thing sub silentio may be evidence of consent. So if somebody treats you as a taxpayer, if they call you a taxpayer and you don't argue with them, then sub silentio, under silence, you consented to be treated as one. That's how it works. And another maxim from Bouvier's Maxims of Law, he who is silent appears to consent. So, and there's a federal rule of civil procedure that talks about this, Rule 8b6. It says the failure to deny constitutes an admission. If somebody calls you a taxpayer and you are not a taxpayer, you have an obligation to deny. If you don't, then you consent. and you admit that you're a taxpayer. So this is how they trick you. This is how they trap you. This is how they hunt animals. The words are their weapons. The words are the trap. The words of art are the trap. And you need to understand what those definitions are. You need to argue with every label they try to pin on your back, because it's just like the label that they used in grammar school, that little sign they put on your back in grammar school that said, hit me. And people came around hitting you, and you didn't understand why it was. And the equivalent of hitting you is treating you as a taxpayer and enforcing all the obligations of the office on you. That's how it works. Tag, you're it. And the tag is the label, the status. Okay? So another way you consent is you quote the provisions of the franchise agreement in your defense in administrative correspondence or court, or you do not oppose the use of such provisions by others against you. The only thing that a non-franchisee can quote is the common law or the Constitution, and not the statutory civil law. All statutory civil law is law for government and not the private person. In other words, you know, if to use the McDonald's example, okay, if you open up a franchise, if you use the McDonald's sign, if you order their food, then you're then at that point a judge would say, well, you're walking like a duck, you're quacking like a duck, and therefore you are a duck. And a duck is a person who consents to the McDonald's franchise and therefore pay up. You know, because all the stuff you've been using is property of the McDonald's headquarters, and you can't receive that without consenting to their franchise. And they gave you notice of what those terms were, and they even noticed you when they found out that you were violating their agreement, even if you never signed it. So you're a duck, whether you want to be or not. And the only way to avoid being treated like a duck is quit acting like one. And that's the same thing they'll do in a tax trial. They'll say, oh, Mr. Taxpayer. They'll call you Mr. Taxpayer, and they'll pretend like you're one. And if you don't argue with them, or if you don't recognize, if you don't argue that what they're quoting is not law for you, or that it doesn't have the force of law, or that you're not subject to it because you don't have a domicile in their jurisdiction, if you don't argue any of those things, then you're presumed to be guilty until proven innocent. And you prove yourself innocent by arguing with them. That's how it works. For further, and we prove that the statutory civil law is law for government and not private persons in Form 05.037 on our website. Very interesting form. You might want to read it. And it also distinguishes between the public and the private rights. For further details, see the requirement for consent, Form 05.003. So we talk about all the ways you consent. There's only two ways, explicit or implicit. Okay? Explicit means you sign something. Implicit means you basically, through acquiescence or silence or through action, demonstrate evidence of consent. An example is, an example of implied consent is you walk into a store and you walk in with an empty shopping cart and you throw something in the cart. The minute you threw it in the cart is the minute you consented to buy it. Okay? And now at that point, if you consented to buy it and then you walk out the door without going through the register, then you didn't pay the consideration, and even though you consented to buy it. At that point, you're a thief. So you implicitly consented to reimburse the store and buy this thing that you put in the cart, whether you actually paid for it or not. Okay, that's implied consent. And the minute you walk out the store without paying for it is the minute you violated your contract. The contract was you got to pay for it. There has to be equal exchange of benefit to both parties. And if there isn't, you're a thief. It's the same way the government does all the franchises. If you receive the benefits and you don't pay for them, then you're a thief. On the other hand, if you withdraw your consent to participate, if at every point you indicate there's duress, and every attempt by others to connect you to the franchise or your property to the franchise is met with a criminal complaint and an affidavit of duress, at that point they cannot enforce the obligations of their so-called benefit upon you. So how do corrupt governments evade the requirement to provide real consideration? American Jurisprudence Legal Encyclopedia hints at this. It is generally considered that the obligation resting upon the grantee, that is the recipient of the government property loaned to you, to comply with the terms and conditions of the grant constitutes sufficient consideration. So in other words, if you receive the benefit, then you're presumed to consent. And the benefit you received is the consideration under the contract. And you don't have to say anything. All you have to do is put your hand out and have them put something in it, and you consented, buddy. It's just like that shopping cart. And moving on, it says, as expressed by some authorities, the benefit of the community may constitute the sole consideration for the grant of a franchise by a state. Okay? But there's a distortion going on here, because that is who gets to define the benefit. Okay? What if living in a community is not a benefit? What if you don't want any of the so-called benefits? What if you don't want any Social Security or Medicare or Medicaid? What if you don't want to go in a public park? What if you don't want to use something or avail yourself of the benefits, privileges, and protections of their civil laws? At that point, you'd become a transient foreigner. You have every right to be one, and they cannot call what they're giving you consideration. At that point, it's a gift. If they give you a benefit and you told them you don't want a benefit and you don't want them to provide it, and they give it to you anyway, at that point, there's no obligation. It's just like if you go into a store and they put it in the cart and you don't, and then you walk out with it, you could say, well, they gifted it to me. I didn't stick it in there, and therefore I never consented to it, so I just assumed they were giving it to me. So what the government therefore does is identify something as a benefit to the public, even if those who are alleged to benefit actually regard it as an injury, and then they write a franchise agreement to provide the benefit, and then they obey the franchise agreement and call observing said agreement sufficient consideration so as to make the civil franchise enforceable against you. So in other words, they'll just say, oh, you're eligible to receive the benefit, and therefore, even if you didn't get anything, you still got consideration, and therefore you got to obey the doggone franchise. That's fraud, isn't it? Remember, however, that equal protection and equal treatment mandated by the Constitution requires that they must enforce the same method of obtaining rights against them under your own franchise agreement. Fight fire with fire. Whatever they can do, that authority was delegated from you, we the people, so you must have it too. And we prove that in Requirement for Equal Protection and Equal Treatment, Form 05.033. And what we're referring to here is an anti-franchise franchise. If they want to say, oh, well, you're receiving the benefits of our little franchise, and therefore you're obligated under our franchise, I can say, well, no, wait a minute. I've got this private property, and I warned you ahead of time. I gave you reasonable notice that if you make requests of my services or make claims upon my property, and that it was private property that was exclusively owned, and you didn't disagree, therefore you agreed. And therefore, you agree to my franchise just the same way as you're trying to do to me. And the cost of the benefits of my franchise is twice what you're trying to charge me. So let's just deduct the difference, and you pay me what you're trying to collect, and we'll call it a deal. All right. So, and if they say you can't do that, then they're violating the requirement for equal protection and equal treatment. Because what did Obama say in his inauguration speech? All are equal and all are free. You are equal to the government, and whatever they can do, you can do. And if they can't, and if that isn't so, then we're not talking about government anymore. We're talking about a religion, and they have supernatural powers above you, the natural, and they're asking you to worship them, and you're now a slave, and you're chattel, and you're property, and you own nothing, and everything you do needs permission of the government. So which is it? You know, you're only free if you're equal. And you should always insist on being equal. And any jury will understand that, just like any kid will understand in a family when he's being treated unequally by his parents. So what are the legal remedies against franchises? There is no remedy for franchises that you consented to, and therefore you have no basis to complain for being the target of enforcement. And here's an example from the Supreme Court and some maxims of law. Ashwander versus Tennessee Valley Authority. The principle is invoked that one who accepts the benefit, that is consents, of a statute cannot be heard to question its constitutionality. So, if you put your hand out and you let the government put that food in there, or that Social Security check, or that driver's license, or that Social Security number, and then you use that number in connection with an activity, then you got to pay the kickback to Uncle. And we call it the public officer kickback program because that's what it is. You got to pay rent on the property they lent you. They're in the property rental business, and you're the renter, okay? And in many cases, you're renting your own, what used to be your own property, because the minute you associate that formerly private property with a number by making a deposit into a financial account and putting a number on that account, That's the minute now you are the custodian over the government's property, and you got to make an accounting over the use of that property. It's no longer yours anymore. You decided to share it. You decided to surrender your absolute ownership over it, your exclusive ownership, and to donate a portion of the interest in the property to the government, and now they control it, and you need permission to do anything and everything with it. That's how it works. Consent removes or obviates a mistake, so you cannot complain of an injury, and even if you make a mistake in the process of complying with the franchise terms, because you acted like you consented, then you cannot sue the government for that. Another maxim of law: it is better to suffer every wrong or ill than to consent to it. So you should always demonstrate evidence of consent, evidence of duress, and every time you interact with any government or any agent of government, because the only thing you should ever want out of any government is to be left alone. And it costs the government nothing to leave you alone. So they can't charge you for that, now can they? And the Constitution gives you the right to be left alone, so they can't charge you for that either, because they cannot turn a right in the Constitution into a privilege and then charge for it. It's repugnant to the Constitution, as the Supreme Court held. And the last maxim of law: one cannot complain of having been deceived when he knew the fact and gave his consent. And if you're a citizen, if you claim to be a citizen, you're presumed to know the law, and therefore you had notice, and therefore you couldn't be deceived. And if you were deceived because you didn't read the law, shame on you. It's not the government's fault. So, how do corrupt governments compel participation? That's another important question. Here are some examples. Federal courts and agencies willfully try to avoid and undermine the limitations imposed by law of not being able to offer franchises within states of the Union. And they do it by all the following means. Here are all the ways that they get away with offering franchises outside their territory and outside the authority of law in a legislatively foreign state. Here's all the ways they do it. They make a false presumption about what your status is, and that presumption goes unchallenged. In other words, they call you a taxpayer and you don't argue with them. And we cover that in Presumption, Chief Weapon for Unlawfully Enlarging Federal Jurisdiction, Form 05.017. There are lots of ways to undermine this presumption. One of those ways is to send them a legal notice before you do anything, and that's a requirement of being a member. So we nip that one in the bud right off the bat when you join us. The next one is they abuse the word includes to expand the statutory meaning of terms and thereby violate the Constitution and steal from those they are supposed to be protecting. So in other words, they'll add things to the definition of things. Like they'll add to the definition of person because it uses the word includes, and they'll say, oh yeah, a person includes a human being, even though it's not in there. That's not allowed. They're not allowed to do that. And we prove that in the meaning of words, of the words includes and including, Form 05.014. It's fraud when they do that. Includes is a term of limitation, and it only becomes a term of expansion when all of the things that are added are expressed somewhere in the statutes. They cannot add that which is not expressly limited or expressly appearing in a specific statute somewhere. If they claim that a human being is in the definition of person, for instance, in section 6671B or 7343 in the Internal Revenue Code, if they want to claim that's included in the definition, then they have the obligation of proving that you are lawfully serving in a public office and therefore satisfy that definition of being an officer or employee of a corporation or partnership, or they have to prove that a statute somewhere expands that definition and adds the term human to the definition. Those are the only two options they have. They cannot add things that do not expressly appear, because it's a maxim of law that if it doesn't appear in the statute, it can be safely presumed that it does not exist and that it does not apply. Moving on, other ways they compel agencies to violate their limitations and offer franchises where they're not allowed. They deliberately confuse constitutional and statutory geographical terms. They use the following form to avoid such abuses. Rules of Presumption and Statutory Interpretation, Litigation Tool 01.006. An example is they will assume that the word state in the Constitution and state in federal statutes, such as 4 U.S.C. 110D, they will assume that those two things are the same. They are not. They are mutually exclusive, in fact. Congress can only write laws for federal territory, not the states, and yet the Constitution only applies to the states. Completely different context. So they'll try to switch the statutory and the constitutional context to extend the jurisdiction illegally over of them to enforce outside of federal territory and into states of the Union, and that is in effect how they conduct their international terrorism, their international commercial terrorism, from their haven for financial terrorism called the District of Columbia, or which Mark Twain calls the District of Criminals. They will also confuse the terms citizenship with domicile, or use the term citizenship rather than nationality to describe one's status. So in other words, they'll try to impute a domicile on federal territory by playing sleight of hand with words of art. They'll use the word citizenship, and they won't define whether they mean nationality or domicile, but they can't mean both. It's one or the other. And you ought to insist on knowing which one it is. And you ought to define in advance what it means if they don't define it. And you ought to define it as somebody who is born or naturalized in the country and who is not subject to the civil laws of the federal government or the national government anywhere. And that way they're not free to make their presumption anymore, and they have to, and the burden of proof remains on them to prove that you do have that domicile, and they can't. If they can't, at the point when you say you don't have it and they don't disagree, then they agree under Federal Rule of Civil Procedure 8b6. They will also refuse to define which U.S. they mean in the term U.S. citizen, as used on government forms and in legal pleading. Now, we saw this particular behavior on the part of the Department of Justice when they attempted to enjoin this website. The U.S. attorney asked the deposed party, the respondent, he asked the respondent, "Are you a U.S. citizen?" And the response from that party was, "Which of the 4 U.S. citizens or citizen statuses do you mean in Title 8 of the U.S. Code? And which U.S., United States, do you mean within that meaning? Do you mean federal territory, or do you mean states of the Union?" And the U.S. attorney evasively responded by saying, "You don't know whether you're a U.S. citizen." In other words, he pushed the pride button. He tried to push your button and get you pissed off because by indirectly accusing you of being ignorant, so he could compel an answer and compel a presumption in the process. And the response was, "This has nothing to do with what I believe. This is a legal proceeding. And the only thing we can talk about here are legal definitions and statutes that make those definitions and use those definitions. And you are the moving party here, and you are using a word, and I am required to have reasonable notice of what you mean by that word. And if you won't define what that word means, then you're trying to conduct a fraud. And the fact that you won't define it is evidence that you're trying to conceal that fraud." And as soon as that response was given, he immediately stopped that line of questioning, which was very interesting. So that is one of the games they play. Another game they play is they'll refuse to address the separation of powers issues raised by litigants domiciled outside of the statutory United States and within states of the Union. So in other words, they'll confuse a statutory state with a constitutional state. They'll confuse a common law person with a statutory person. They'll confuse a citizen, franchisee, with a citizen under the common law, which is a private citizen, and so on. Okay? So, and by doing that, they'll destroy the separation between the public and the private and confuse you with the public office so they can steal your property. Because that's all they ever want to do, steal and lie and cheat and not deliver the only thing they were created to deliver, which is the protection of private property and private rights. Other ways that governments compel participation. Government compels participation in franchises or deceives people into participation who do not qualify. And they do it by lying to the public with impunity about what the law requires or allows. See Reasonable Belief About Income Tax Liability, Form 05.007. They can lie in their publications. They can lie in everything they tell you and not be accountable for it. And under the concept of equal protection and equal treatment, we ought to be equally non-liable for everything we put on a tax return. But they enforce an unequal standard. And that is why, the only reason they can even enforce anything in states is because they have imputed to themselves a title of nobility. And that title of nobility is insured from ever being prosecuted for anything. And that title of nobility is unconstitutional if it's enforced in a state of the Union, as required by the Constitution. I believe it's Article 1, Section 10. The other document we talk about this in is flawed tax arguments to avoid, Form 08.004, Section 6. And we talk about it in rebutted versions of the IRS's The Truth About Frivolous Tax Arguments, Form 08.005. So they always lie. Just expect it. They'll lie even about their name. They don't even use their real name. They'll use a pseudonym, and then they won't tell you. And unless you know to ask about it, they'll get off scot-free without even identifying who they really are, their legal birth name. And if you did that, you'd be thrown in jail for committing fraud, because everything you have to give to them is under penalty of perjury. Another way that they compel participation is they'll provide no forms to terminate participation in the franchise and or terrorizing those who demand the right to terminate or participation. We talk about that in the case of Social Security in the following form: Resignation of Compelled Social Security Trustee, Form 06.002. There's a Social Security form that allows you to terminate, but they don't put it on their website. They won't talk about it in the office, if you go in there. And they'll actually call the guard on you if you walk into a Social Security office and insist on terminating your participation. Like you're some kind of terrorist or something, because you don't want their services. Duh! And we know who the real terrorists are. It's them. They will refuse to protect or even recognize the existence of those who are not franchisees, such as those who are non-taxpayers. You can't go into a Social Security office and ask for services if you didn't sign up, now can you? That wouldn't be such a problem, but the other thing they do that with is citizen in general. If you're not a statutory citizen under federal law or national law, and they're injuring you and you need to be protected from them, you cannot invoke any of their civil laws to protect you, and they will not help you. And if you're an idiot if you even fill out a federal tort claim form, because that form is only available to people who are statutory citizens and residents. None of that law can apply to or help a non-resident. And we talk about this in Who Are Taxpayers and Who Needs a Taxpayer Identification Number, Form 05.013. And they will also compel participation by not providing forms or procedures or remedies to those who are not franchisees. For instance, there is no IRS form for non-taxpayers, and the only publication dealing with rights deals with taxpayers. See Your Rights as a Taxpayer, IRS Publication 1, and the equivalent on our site, Your Rights as a Non-Taxpayer, IRS Publication 1A. And that's found in Liberty University Section 6.8. Another way they compel participation is they compel unlawful and fraudulent use of government identifying numbers, providing nothing to use for those who are not taxpayers, and no way to change the status of the number to that held by a non-taxpayer. See why it is illegal for me to request or use a taxpayer identification number, Form 04.205. They will also compel participation by ignoring correspondence sent by non-taxpayers that rebuts or challenges their presumptions that they are not franchisees. They will force you to be a resident or citizen franchisee for all purposes. A citizen or resident is just a customer for government services. And being a customer for all purposes forces you into an all-or-nothing relationship with the government. You either have everything they want to force upon you, or you have nothing. No other business can run that way, so why should the government be able to do it? An example, if retail stores ran the way the government, would be the following. You walk into a store, and they will hand you literally a semi-truck as a shopping cart, and they'll tell you that you cannot leave the store without buying everything in the store, because that's how they run all their franchises. If you sign up for a driver's license, they'll force you to have a Social Security number and be a Social Security franchisee, and then that hooks you into the tax system, and that also hooks you into child support enforcement and all the family codes and withholding and reporting and everything else. So no matter where you touch them, no matter what you try to interact with them on, they will literally behave like the Matrix. You touch one part of that Matrix and you get sucked into it, and you're totally surrounded by everything they want to do to you. And you're just a slave at that point. So what they're really required to do, if they want to respect and protect your exclusive right and control over your property, is to allow you to declare yourself a citizen for some purposes and a non-resident for other purposes. For instance, You could be a citizen for the purposes of let's say, a driving license, and be a non-citizen and a transient foreigner and a non-person or and a non-individual for every other purpose. There's absolutely nothing wrong with doing that, but they don't want to allow that because they want, essentially, they want every interaction with them to turn into a blank check where they can put any amount on the check they want and take as much as they want. And they want to even be able to steal your whole bank account just by virtue of you even asking them for anything, because that's how they work. They're just thieves and liars and everything else. The other way they force you to be a resident or citizen franchisee, as we said, is you ought to be able to decide to buy only those services that you want and call yourself a resident or citizen in the context of that service and no others. By forcing you into being a customer for everything they offer, you are deprived of choice and competition. They are alleviated from having to procure your express consent in each case, and they are no longer accountable to you for being efficient in delivering the service, and they are not required to compete equally in the marketplace, and a monopoly and adhesion contract results, which is a threat to your commercial existence, and they can charge whatever they want collectively for all of their services. No other business can do that, so why should the government be able to do it? If we really are all equal, then why can the government be the only company in the world that is allowed to offer you a service and charge whatever they want for it and put you in jail if you don't pay? Sounds like terrorism, not protection to me. So, when you want to sue the government, you must produce evidence of consent in each specific case. Why shouldn't they have the same requirement as a result of the constitutional requirement for equal protection and equal treatment? See requirement for equal protection and equal treatment, form 05.033. So those are the ways that they kind of compel you into consenting. In short, the government directly or indirectly compels you to choose a civil status described within the franchise agreement, and then illegally sanctions and penalizes you for truthfully and accurately describing yourself as other than franchisee, and compels you to commit fraud and perjury on government forms and describe yourself as that which you aren't in order to bribe them to simply leave you alone. And they're compelling you by compelling you to declare yourself a taxpayer or only making taxpayer forms. They're forcing you to commit a crime of impersonating a public officer, because that's what all taxpayers are. And that's how they destroy the separation between public and private, and thereby claim ownership over everything and assume that everything is public. What most people think of as government is really just a private corporate monopoly and protection racket disguised to look like a lawful de jure government. Other ways that corrupt governments compel participation. The Constitution incidentally says the right to be left alone by government is free and shouldn't cost you anything, including any kind of protection money called taxes. And here's what they said, as we said earlier in Olmsted. Quote, "The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, and their emotions, and their sensations. They conferred as against the government the right, not the privilege, but the right, to be let alone, the most comprehensive of rights, and the right most valued by civilized men." And this is an indirect reference to the very definition of justice itself. Justice is the right to be left alone, and therefore the purpose of the Constitution is justice, and therefore the purpose of the Constitution is to protect your right to be left alone without costing you anything. Because everything in the Constitution is a right and not a privilege. So they cannot charge for a right. They cannot interfere with the exercise of a right. They cannot penalize you for exercising the right. And therefore they cannot punish you with a sanction or a penalty or a tax for demanding the right to be left alone by government. And another way of saying that is they cannot charge you protection money for the right to be protected by government, because from the government, I might add. I mean, they might be able to charge you for the privilege of being protected from other people, but they cannot charge you for the privilege of, they cannot charge you to protect you from them or their own abuses, because that's what governments are created for. So how do franchises affect your standing in court? Participation in franchises cause a surrender of sovereign immunity. See 28 U.S.C. 1605A2. Federal Rule of Civil Procedure 17B2, covered earlier, is the authority for jurisdiction over franchise participants. And here it is. For a corporation by the law under which it was organized. So, and we refer to that as an indirect domicile because the corporation is domiciled in that of its parent is the government is domiciled in the capital of that state or nation, and therefore the domicile of the corporation is the domicile of the government that authorized that corporation and no other government. And under federal rule, under 4 U.S.C. section 72, the domicile of United States government is the District of Columbia and only the District of Columbia. So everybody who avails themselves of the privilege of a corporation franchise is by definition imputed to have a effective domicile in the District of Columbia, no matter where they physically are. And the same thing would apply to officers of a corporation under that rule. Because a person who acts as an officer of the corporation is representing the corporation, and they have the effective domicile of the corporation they represent, which in turn is the District of Columbia. And that would include U.S. Inc. as a federal corporation, because it has officers as well, called public officers. So moving on, how then do franchises affect your standing in court? Warning, participation in franchises can cause a complete surrender of all right to litigate in a true constitutional court and a deprivation of all remedies. Okay, and here's the reason identified by the Supreme Court in United States versus Babcock in 1919. They said these rules, general rules, are well settled. That the United States, when it creates rights, what they really mean here is privileges or franchise rights, in individuals against itself, meaning a public right, which is a euphemism for a franchise to help disguise the nature of the transaction, they are under no obligation to provide a remedy through the courts. So if you take the franchise benefit bait, if you bite that bait, if you hold your hand out, if you accept the Social Security check, if you accept the license and you use it, if you accept the handout or the welfare handout or whatever else, or if you use that number in connection with an otherwise private transaction, then you have accepted a public right and what they call here a right that Congress created against itself. And at that point, you have surrendered your right to even any kind of a remedy in a real constitutional court, because that's what they really mean here by remedy through the courts. Because that court they're talking about here is a constitutional court. It's not a franchise court. Okay, they don't have to let you get a remedy. They don't have to give you a remedy in a franchise court, but they can. An example of franchise courts, as we said, is traffic court, tax court, family court, and so on. And so they can create a franchise court and they can give you a remedy in that court, but they don't have to. And if they don't give you a remedy, then you can't go into a constitutional court to argue about it. Why? Because you consented to the franchise. And we already said that he who consents to a thing cannot complain of an injury. So you're not allowed to complain of an injury, and you can't even go into a real court without an injury. So you're toast. You can't do anything. You're screwed. And another one of these rules is that where a statute creates a right, meaning a public right, meaning a franchise right, and provides a special remedy, that remedy is exclusive. And what they're talking about there is a franchise court in the executive branch. If the tax code, notice I didn't say law, but the tax code, which is a franchise, mandates that if you want an administrative remedy, you have to go to tax court, and tax court is in Article 4, or actually in Article 1 court, under Section 7441 of the Code. If that's an Article 1 court and it's in the executive branch, at that point they have provided what this calls here a special remedy, and that remedy is exclusive. If you take advantage of that remedy, you can't go anywhere else other than that place to perfect the remedy, and that remedy also dictates the choice of law beyond that point. So if you don't like the tax court decision, the rules even specify that you're not allowed to go to the district court to get a real remedy in a constitutional court. Instead, they force you to go to the appeal court instead. So, and the appeal court doesn't have a jury either. So you didn't get a jury in the tax court, and you didn't get a jury in the appeal court, and everybody who touched that case had a conflict of interest, a criminal conflict of interest in this case. Then justice is impossible at that point. And due process is also impossible because there are no impartial decision makers. The only way that due process could be preserved is if everybody who judged the matter had no financial interest in the outcome and received no benefits by virtue of the money at issue in the case. So no federal benefit recipients could be jurists. No judge could be a taxpayer or a tax collector or a dependent of the government under any circumstance. So since none of the decision makers are impartial, then there is no due process. And you will never get justice in any franchise court. And so that's why you should never sign up for a franchise, is they can take away all the remedies under the Constitution and force you to be their good little whore. Because that's what you are. You're just a good little whore for uncle. Put on the knee pads and get out the KY jelly and jump as high as they tell you to jump and lick whatever they tell you to lick, because that's what's going to happen. And it says, still the fact that the right and the remedy are thus intertwined might not, if the provision stood alone, require us to hold that the remedy expressly given excludes a right of review by the Court of Claims, where the decision of the special tribunal involved no disputed questions of fact and the denial of compensation was rested wholly upon the construction of the act. Moving on, how franchises affect your standing in court. The United States is a federal and not state corporation. See 28 U.S.C. 3002-15A. And all those who participate in franchises are officers of that corporation and public officers of a federal corporation acting in a representative capacity. The franchise agreement is part of the, quote, law under which it, that is the U.S. Inc. federal corporation, was organized. See, for instance, 26 U.S.C. 6671B and 26 U.S.C. 7343, as we indicated earlier, which specifically refers to a statutory, quote, person, unquote, under the IRC as an employee or officer of the corporation, and nowhere defines it to include private parties and cannot lawfully define it that way without violating the USA Constitution. Why? Because the ability to regulate private rights and private conduct is repugnant to the Constitution. And since you can't give away a constitutional right, then you can never even consent to a franchise lawfully and have it enforced against you. The District of Columbia is not only the seat of government, pursuant to 4 U.S.C. Section 71, but it also is the domicile of U.S. Inc., the federal corporation. All those representing said federal corporation as public officers therefore take on the character of the corporation they represent and adopt an effective domicile of the District of Columbia while serving on official duty. For proof, see 26 U.S.C. 7701A39, 26 U.S.C. 7408D, 4 U.S.C. 110D, and 7701A9 and A10. So whether or not your domicile does not matter as long as you're acting in a representative capacity. If you're representing an entity that is domiciled somewhere else, then your effective domicile while you're in court acting on behalf of that entity is the domicile of that entity and not your own domicile. And that is how they reach everybody in a constitutional state, is they presume that you're in effect exercising the functions of a public office as an officer in the government with an effective domicile in the District of Columbia, which Mark Twain called, as we said, the District of Criminals. Okay, so if you want to hang out with criminals and bend over for every John that wants your services, go ahead. So let's talk about legislative franchise courts. We said that tax court, family court, traffic court are all legislative franchise courts in the executive branch, and that they can only be used, their services can only be invoked lawfully by public officers on official business in the executive branch and not any of the other branches. That's what we said. And here is what the Supreme Court said about that subject. The grantor of the franchise typically creates special courts to hear disputes under the franchise contract or agreement. And here's what they said. Although Crowell and Radatz do not explicitly distinguish between rights created by Congress, meaning public rights, and other rights, such a distinction underlies, and the other rights they're talking about can only mean private rights. There's only two kinds of rights, public and private. Such a distinction underlies in part Crowell's and Radatz's recognition of a critical difference between rights created by federal statute, meaning Congress, meaning public rights, and rights recognized by the Constitution, meaning private rights. Moreover, such a distinction seems to us to be necessary in light of the delicate accommodations required by the principle of separation of powers reflected in Article 3. The constitutional system of checks and balances is designed to guard against encroachment or aggrandizement by Congress at the expense of the other branches of government. See Buckley versus Vallejo. But when Congress creates a statutory right, meaning in this case a privilege or a public right in this case, such as a trade or business, it clearly has the discretion in defining the right to create presumptions. And by the way, the act of defining is the essence of what it means to create something. If you define something, then you have created it. If they can write the definitions, it's theirs and they own it. And if they own it, you can't use it unless you want to be their slave. That's how it works. Because they're going to loan it to you, or if you use it in connection with something, they're going to say that you're accepting a benefit, and then they're going to charge you for it in the form of a tax. It says, in defining that right to create presumptions, meaning presumptions are lawful if you're dealing with franchises. They're unlawful or public rights, but they're unlawful when you're dealing with private rights. So the first question out of your mouth is always, in any enforcement proceeding, is a public right or a private right being vindicated? And if it's a public right, I'm not the subject of it. It must be you got the wrong guy, okay? Because I'm private and I'm free, and I'm equal to you, the government. And you have the burden of proving that I consent it to be unequal before you can enforce this franchise on me. And that burden has to be demonstrated with written evidence and my signature and somebody from the government signing it as well, just like any other contract or agreement. It also has the power, or it says, or assign burdens of proof or prescribe remedies. It may also provide that persons seeking to vindicate that right, that public right or franchise right, must do so before particularized tribunals, such as tax court, created to perform the specialized adjudicative task related to that right. Such provisions do, in a sense, effect the exercise of judicial power, but they are also incidental to Congress's power to define the right that is created. No comparable justification exists, however, when the right being adjudicated is not of congressional creation. In other words, it's a private right or a constitutional right. Because as we said, there's only two kinds of rights, public and private. In such a situation, meaning the private rights, substantial inroads into functions that have traditionally been performed by the judiciary cannot be characterized merely as incidental extensions of Congress's power to define rights that it has created. Rather, such inroads suggest unwarranted encroachments upon the judicial power of the United States, which are constitutional reserves for Article 3 courts. Okay, so what did they just admit here? They admitted that specialized tribunals like traffic court and tax court and family court, which are Article 1 or Article 4 courts, those courts are franchise courts. They're in the executive branch. They are not a judicial function, although they exercise functions similar to judicial power. They are merely arbitration boards, and that the only place you can go to vindicate a private right, meaning a constitutional right, is an Article 3 constitutional court that is not a franchise court. It's one or the other. The franchise courts are used to vindicate public rights and defend public rights that are owned by the government, and the constitutional courts defend only private rights that are owned by you and God, and not the government, in which you have exclusive use and control over. So that's the first question. Every time you want to litigate is, what kind of a right are you vindicating, and under what is the authority for possessing and owning that right? If it's a statute, a franchise statute, or a civil statute, then it's a public right. And you should not be quoting any franchise agreement or trying to pursue any public right or franchise right if you want to be free, or if you want to be left alone by the government. You're an idiot if you do. You're contradicting your own words. With your own actions. You can't walk into a franchise court and then claim to be private and protected by the Constitution. It's just ridiculous. It's one or the other. You can't be half pregnant. You can't be half free. You can't be half private and half public. You're either all public or all private. Which is it? The legal definition of a franchise court from Black's Law Dictionary proves this. Franchise court, a privately held, meaning non-governmental court, that usually exists by virtue of a royal grant, meaning a privilege. And notice that word privately held. Privately means non-governmental by definition. Okay, it also means that it's an arbitration board. Okay, if you want to submit your disputes to binding arbitration where all the decision makers have a financial conflict of interest and want to steal your money, you're an idiot. Okay? But they say here, the court that usually exists by virtue of a royal grant of privilege with jurisdiction over a variety of matters, depending on the grant and whatever powers the court acquires over time. In 1274, Edward I abolished many of these feudal courts by forcing the nobility to demonstrate by what authority, that is, quo warranto, they held court. If a lord could not produce a charter reflecting the franchise, the court was abolished, also termed courts of the franchise. And they don't call, the judges in these franchise courts, like traffic court, family court, and tax court, they won't admit that it's a franchise court, but it is, because if they are vindicating a public right granted by the king, and the king is the government, and you're the servant and the subject, if you sign up for that franchise, that's what a privilege is. It's a privilege in the hands of a subject. That's what a franchise is. It's privilege in the hands of the subject. If you accept that privilege from uncle, then you got to deliver just compensation for the receipt of the privilege and the use of the privilege. It says dispensing justice was profitable, meaning, in other words, they turn the noble ministry ordained by God of protecting private rights into a profitable whorehouse, and where they're auctioning off rights. That's why it's profitable. If they own everything you own because you're a citizen and the citizen is in office and you hold title to the land or property in the name of a citizen, then they own everything that you own. And they can auction it off to the highest bidder. And they can demand anything they want out of you at that point. And that's why it's profitable, because people who want things or want to get things back that the government stole will pay any amount of money to do it. And that's why it's profitable. But if everybody started out equal and the government had the burden of proving that you donated it to a public use, they could never get that far, could they? So that's kind of one of the cornerstones of defending yourself against franchises, is to insist on a separation between public and private, and the presumption that everything you own started out as private, and that they have the burden of proving that you knowingly, intentionally donated it to a public use, and that you had the ability to do that because you are not on land protected by the Constitution. And they can never do that, so they're screwed. Anyway, it says, much revenue could come from these fees and dues, fines and amercements. This explains the growth of the second class of feudal courts, the franchise courts. They too were private courts held by feudal lords, and we would argue that tax court is such a court, and the feudal lord is the judge of the tax court. And he's not really even a judge. He's just an administrator, and he's usually from the IRS, and his retirement benefits are threatened if he doesn't make you pay up. So he's always gonna side with the government, and there's no jury to overrule him. So you're never going to get justice. And anything he officiates over in that capacity is done so with a criminal conflict of interest, and there will never be justice. The Supreme Court said in Yickwo versus Hopkins that to submit your life or your means of living to the mere will of another is the very essence of slavery itself. And that's exactly what you do when you go into any kind of a franchise court, including tax court, family court, traffic court, whatever. Okay. This explains, they too were private courts held by feudal lords. Sometimes their claim to jurisdiction was based on old pre-conquest grants, but many of them were in reality only wrongful usurpations of private jurisdiction by powerful lords. These were put down after the famous Quo Warranto inquiry in the reign of Edward I. And that's Black's Law Dictionary, 7th edition, page 668. The fact that franchise courts are privately held is the reason why the IRS is not only isn't part of the de jure government, but has no legislative authority to even exist. And you can prove that for yourself by reading the form on the memorandum of law on our website entitled Origins and Authority of the Internal Revenue Service, Form 05.005. They are also the reason why the de facto officers running the scam franchise have the authority to even contract away otherwise inalienable rights to begin with. They are not de jure government officers, but private usurpers operating a sham trust for personal profit instead of to protect your private rights. The money changers have hijacked the public trust. So let me just point out even further what's going on here. If the IRS is not anywhere within Title 31 of the U.S. Code, and therefore is not authorized to even exist, and there is no act of Congress that ever authorized it to exist, and that the only thing Congress ever authorized was the commissioner, and the commissioner created this huge apparatus underneath him without any authority and funded it with funds that were stolen from people. And this apparatus is essentially a private corporation owned by Uncle because it cannot function as a government entity. It cannot function as a government entity because government cannot make a business out of alienating that which is supposed to be unalienable, right? I mean, to give you an example, you can contract away any of your rights to a private other party who's equal to you by signing a contract. So it's perfectly lawful to alienate a right to a private party. On the other hand, in relation to a government, if we replace that private party with a government, you can't alienate it. So what they had to do was make the IRS not part of the government so they could allow your right to be alienated. And then they had to fool you into thinking that it was part of the government, so you'd think they had authority. But it's all just a conspiracy to violate rights under the color of law, and it's all being protected with what they call plausible deniability and compartmentalization. You know, they never tell any of their employees what's going on, and when they finally find out the fraud of what's going on, they get fired. And that applied to, Sherry Jackson and John Turner and a lot of other people that figured this out that worked inside the IRS. Once they figured out and they are no longer useful as useful idiots, they get fired because they can't let on what's going on, because at that point they no longer have a plausible deniability defense and they become personally liable because they willfully violated the law and violated people's rights. So that's how they do it. They compartmentalize everything, they classify it so nobody can find out what's going on, even though there's no reason to classify it, and that way they prevent the spread of the spread of knowledge about this fraud, because that's what it is. So that's why the IRS has to be privately held. And the franchise courts that vindicate the rights also have to be privately held, just as they describe here. So, legislative franchise courts, moving on, all so-called franchise courts are in the executive or legislative branch and not the judicial branch. Examples of franchise courts include federal district and circuit courts. And we prove this in What Happened to Justice, Forum 06.012, available on our website in our bookstore. The U.S. Tax Court, 26 U.S.C. 7441, identifies it as an Article I court in the executive branch, not the judicial branch. And Traffic Court and Family Court, as we said. So those are all legislative franchise courts. And they vindicate public rights, franchise rights, that can only be exercised lawfully by public officers on official business. And as we said, you cannot lawfully elect yourself or unilaterally elect yourself into public office. So even if you do fill out for a franchise form, it wouldn't make you a public officer and therefore a franchisee if you're protected by the Constitution and your rights really are unalienable. So they have to do it with sleight of hand. Franchise courts are limited to those voluntarily and lawfully participating in franchises. For instance, you must be a statutory franchisee called a taxpayer as legally defined in 26 U.S.C. 7701A14 in order to petition the U.S. Tax Court pursuant to Tax Court Rule 13A. And franchise courts do not have juries, as we said earlier, and they are presided over by Constitution Article 1 or Article 4 franchise administrators in the executive branch and not Constitutional Article 3 justices, so to speak. And they cause a waiver of the right to sue in a real Article 3 court. For instance, those litigating in tax court waive their right to appeal to the U.S. District Court or to ever hear their case in front of a jury. They can appeal only to a circuit court. And there are no juries in a circuit court, so you're screwed. And as we said, you never get due process. And they have to do it that way or they couldn't steal from you and get away with it with impunity. So, how do we avoid government franchises and licenses? Government is created to protect your right to contract or not contract with the government. Every right in the Bill of Rights, for instance, implies the opposite right. If you have the First Amendment right to speak, then you also have the First Amendment right to not speak. If you have the First Amendment right to associate, you also have the First Amendment right to not associate. So every right implies the opposite right. And therefore, If all franchises or contracts or agreements, and you have a right to contract, then by definition you also have a right to not contract with anyone and everyone. And if you don't, or if there's a certain entity like a government, for instance, that you're compelled to contract or enter agreements into with, then you're a slave. And that party has supernatural powers, and you're engaging in a religion and not real law at that point, because there is no equality. And that's the foundation of all real law, is equality of rights of all. That's what Obama said in his inauguration speech, and he was right. Resources for lawfully avoiding participation in franchises. Resignation of compelled Social Security trustee, Form 06.002 allows you to quit Social Security. Liberty University Section 4, avoiding government franchises and licenses. We have lots of forms there at the link provided. Government instituted slavery using franchises, Form 05.030, Section 18, avoiding government franchises and licenses. We go into exhaustive details about, in that form, 5.030, about every minute little detail about franchises, how to quit, how you get illegally roped in, the fog of propaganda that protects the criminal and illegal enforcement of the franchises in the places unauthorized by the franchise, and on and on and on. So it's a really important document to download and read. It's a vastly expanded version of this presentation. We also have another form, legal notice of change in domicile / citizenship and divorce from the United States, Form 10.001, and that allows you to lawfully terminate presumed domicile on federal territory in the United States and statutory but not constitutional U.S. citizen status and all commercial relations with the national government. And we also have the SCDM forms, restoring and defending your sovereignty, for members only. So how do we attack franchises in court? All franchises are contracts between the grantor and the grantee, or agreements. A compact is an example of such an agreement or contract. And that's what they refer to all civil law as a compact. That's what we read earlier from the Supreme Court. And so here's what Amgir says on franchises, Section 4. As a rule, franchises spring from contracts between the sovereign power and the private citizens, made upon valuable consideration for purposes of individual advantage as well as public benefit, and thus a franchise partakes of a double nature and character. So far as it affects and concerns the public, it is publicity juris and is subject to governmental control. The legislature may prescribe the manner of granting it, to whom it may be granted, the conditions and terms upon which it may be held, and the duty of the grantee to the public in exercising it, and also may provide for its forfeiture upon the failure of the grantee to perform that duty. But when granted, it becomes the private property of the grantee, and it is private right, subject only to the governmental control growing out of its nature as a publicity juris. So it's a contract. And if you have a right to contract, then, and a right to not contract, more importantly, with anyone and everyone, because you own yourself, then you can challenge the enforcement of franchises just like you challenged the enforcement of any other contract or the illegal enforcement. They must meet, that is franchises, must meet all the same requirements as contracts or agreements, namely an offer by the government, a voluntary acceptance, and duress may not be present, and there may not be no penalty for failure to participate by the offering party. And as we said earlier, that duress can take the form of them not protecting your right to unvolunteer or your right to not volunteer. So they can't call it voluntary and then not protect your right to volunteer. And they can't call it voluntary if they can volunteer you for it without your consent. Consent must always be involved. And to be valid, a contract must have mutual consideration and mutual obligation. If they're the only ones who benefit, and you don't benefit by your definition of benefit, then there is no mutual obligation. Doesn't matter how they define it. The two parties must independently be able to define what they mean by benefit. And if they get to define what it means, and they define an injury as a benefit, you're always screwed. And you always lose. And that's what they want. They want you to always lose because they want you to worship them as a pagan deity with supernatural rights. Parties must be of legal age and thereby have the capacity to contract. As we said, if your parents signed you up for Social Security, then they didn't really obligate you to do anything. And when you reach lawful age, if you didn't use that property in connection with anything and you didn't consent to use it, or you're forced to use it, then you never really became a lawful franchisee. And even if you did consent, if you weren't lawfully engaged in a public office before you used it, and in connection with otherwise governmental activities, then you're unlawfully using public property for a private purpose and you're a criminal. So you cannot use the number in connection with anything that was not already government property. And if you did, you're committing a fraud on the government. The U.S. Supreme Court has held that the Social Security franchise does not obligate the government to provide any financial consideration, and hence there is no consideration and therefore no reciprocal duty on your part to pay them anything or do anything for them. If they don't have to do anything for you, or they don't have to provide the most important thing that you regard as a benefit, which is the money, then you don't have any obligation either. Because why? Because all contracts to be enforceable must involve mutual and equal obligation and consideration. You didn't get anything out of it that you really wanted, that is. And here's the proof from the Supreme Court. Fleming versus Nestor, 1960. We must conclude that a person covered by the Act has not such a right in benefit payments. And by right, they really mean here privilege. Because it's not a constitutional right. The Constitution doesn't mention anything about Social Security or payments from the government. So they're really referring to here as a privilege. And they're trying to deceive you into thinking that a public right is a private right so they can rope you into their little scam, their little trap, their little franchise trap. So you can become their pet and their animal and their cattle on their plantation called a city or a nation. This is not to say, however, that Congress may exercise its power to modify the statutory scheme free of all constitutional restraint. Very important here. First of all, they call it a statutory scheme because it is a scheme. They're trying to scheme you out of your private property. That's the whole purpose of it. And when they do it, they're free of all constitutional restraint. And why is that? Because you consented to it. You had to consent to it to join. Okay? And anything that you consent to cannot form the basis for an injury. Okay? So the question for the listener. So why, pray tell, do U.S. attorneys criminally prosecuting tax offenses always tell the jury that the defendant received the benefits of living here and refused to pay for them? Well, as we said, the government isn't obligated to provide those benefits, so how could you receive any benefits to begin with? It's just a rhetorical question. So the answer is because they are hypocrites. They never allow people who overpaid for the benefits they received to use the same argument against the government. They're hypocrites. All they want to do is enforce an unequal relationship because that's where they can cash in on everything. Inequality, supernatural powers, where they own everything, where they're like God. God owns the earth, and they pretend like they own the earth and that you work for them and everything is a loan to them and you need permission to do everything. That would be the ideal planet if they had their way. But this is a violation of equal protection and equal treatment that is a foundation of the Constitution. If all men are created equal according to the Declaration of Independence, which says in one stat, the statutes at large is law, okay? If the Declaration of Independence, which is law, says that all men are created equal, and if the rights of those men are inalienable or unalienable, meaning they can't bargain them away and they can't give them away through a franchise or any other method, then they can never be unequal, now can they? And therefore, the constitutional requirement for equal protection and equal treatment has been violated when they try to do this. That's how they do it. And here's what we just talked about. All contracts require mutual consideration and mutual obligation. And here's the authority for it. And here's the question we asked, and here's the answer. So what are some other methods that we can use to attack franchises? All tax payments to the government are legally classified as gifts. Hence, by principles of equity, all payments from the government must also be classified as gifts. And that can and does create no obligation on your part. And here's the proof. 31 U.S.C. 321, General Authority of the Secretary. It says, for the purposes of the federal income tax, estate, and gift taxes, property accepted under paragraph 1 shall be considered as a gift or bequest to or for the use of the United States government. So you're gifting them property. So let's get this straight. Everything they give you is a loan, but everything you give them is a gift. That violates the requirement for equal protection, doesn't it? Because if everything they give you is a loan, then you always work for them, but you cannot place the same constraint on everything you give them. But remember, this statute is the default status of things you contribute to the government. You can change that status. You could say make an attachment to your tax return saying, regardless of what 31 U.S.C. 321 says, this is not a federal tax, this is a compelled donation, and it is a loan to uncle, and the interest on the loan is 10 times for any period of time what was provided to uncle. And it must be returned upon request, just like the Social Security card. If they can do it, you can do it. And that's the only way you'll ever be free, is if you're equal to them and you do all the same things to them that they do to you, right? Other ways to attack franchises. Examples of taxes as gifts. Tax withholdings are classified by the IRS as tax class 5, which means gift and estate taxes. So they're not really even taxes, they're just donations by the IRS's own internal classifications. Tax class 5, as we said, is estate and gift taxes, and since you aren't dead, then the withholdings must be gifts, right? Estate taxes are only for dead people. You're not dead, so it must be a gift, right? Duh. So the question is, how do tax class 5 gifts turn into tax class 2 individual income tax liability? You ever asked that question? The answer is by attaching them to an IRS Form 1040 self-assessment and voluntarily connecting them with a specific liability that you and only you can create by signing the tax form. That tax form, in turn, is usually fraudulent because the submitter must be a public officer, and if he isn't, he is criminally impersonating a public officer in violation of 18 U.S.C. 912. The withholdings, in turn, are a criminal bribe, 18 U.S.C. 210, to get uncle to treat you illegally as if you are a public officer entitled to, quote, benefits, unquote. Why? Because the Supreme Court ruled in Loan Association versus Topeka that the government cannot use tax money to pay to private individuals. In other words, it cannot use tax money to redistribute wealth to private people. So by definition, if they pay you anything, then you must be a public officer. And if you aren't, then you are criminalizing the government. And you're making them act as if they're not government. So, in effect, if you weren't a public officer and you paid them protection money in the form of withholdings, and they in turn treated you as a taxpayer and acted like you were a taxpayer and gave you all the same deductions and entitlements as a taxpayer, then in effect you bribed them to allow you to impersonate a public officer and receive those benefits. And under federal law, at that point, you have a basis for a cui tam action against the government because the government is being defrauded into treating you as a public officer and paying you benefits as if you're a public officer when you really aren't. That's a crime. And it's also, and you can prosecute that action. Uncle doesn't have to. And you should. Don't believe us? Read Why the Government Can't Lawfully Assess Human Beings with an Income Tax Liability Without Their Consent, Form 05.011. They cannot assess you. You have to assess yourself. That's why the Supreme Court called this a self-assessment system, because they can't do it. They'll pretend like they can do it, but they can't do it to a human being. They can do it to a public corporation that is a federal corporation only by virtue of owning that corporation. But they can't do it to you because they didn't create you and they didn't create your rights. And they can't take away rights that they didn't create. Now, can they? The creator of a thing is always the owner of a thing. And if they didn't create your rights, they didn't create the earth, they didn't create your body, then they don't own any of it. They can't tax it. They can't regulate it. And you have to volunteer for an office before they can regulate it. And you're an idiot if you volunteer. But have at it. So how else do you attack franchises? Federal courts and federal judges are forbidden by the Declaratory Judgments Act, 28 U.S.C. 2201A, from declaring you to be a franchisee taxpayer. You are the only one who can become or consent to become a franchisee. And here's the proof from a district court. Specifically, Rowan seeks a declaratory judgment against the United States of America with respect to whether or not the plaintiff is a taxpayer pursuant to and or under 26 U.S.C. 7708A14. This court lacks jurisdiction to issue a declaratory judgment with respect to federal taxes other than actions brought under Section 7428 of the Internal Revenue Code of 1986, a code section that is not at issue in the instant action. See 28 U.S.C. 2201. See also Hughes versus United States, affirming dismissal of claim for declaratory relief under 2201 where claim concerned question of tax liability. Accordingly, defendant's motion to dismiss is hereby granted and the instant action is hereby dismissed. So The courts cannot, if you declare yourself to be a non-taxpayer, not even the courts can make you one. And if they can't do it directly, then they can't do it indirectly by acting like you're one or treating you like you're one either. Now, can they? Otherwise, their actions would contradict their words. If they can't declare you a taxpayer, then they can't treat you like one either. Period. And if they can't treat you like one, then every action against you must be dismissed as far as enforcement of the Internal Revenue Code. Courts and judges cannot lawfully do indirectly what they cannot do directly. Hence, they also cannot prejudicially presume that you're a taxpayer without violating due process of law. And due process of law does apply to those who are not taxpayer and who are protected by the Constitution. So all you have to do is invoke the protections of the Constitution and prove that you have a domicile on land protected by the Constitution and invoke those protections. And the Constitution is self-executing, and therefore you don't need a statute to invoke its protections. That's what the Supreme Court said. Why? Because you are the patron for government protection, and the patron is always right. How else do you attack franchises? All franchises or franchisees are public officers, but no tax form or government form can or does create any new public offices in the government. Nowhere do franchise statutes expressly identify new offices being created or expressly authorize their exercise anywhere as mandated by 4 U.S.C. Section 72. You must lawfully occupy a constitutionally created, elected, or appointed office in the government before you can elect or participate in any franchise. So like domicile, like the domicile prerequisite, you must also lawfully occupy an office before you can sign up for additional franchises like Social Security or Medicare or Obamacare or anything else. So even if you did have a domicile on federal territory, if you didn't occupy an office, you cannot sign up for or receive the benefits of Social Security. And if you did, you're defrauding the government and you're impersonating a public officer. It is a crime to unilaterally elect yourself into a public office. See 18 U.S.C. 912, 18 U.S.C. 210, and 18 U.S.C. 211. And those involve bribery for people to treat you like you're a public officer. The Internal Revenue Code attempts to create the illusion of an opportunity to circumvent the above by calling any opportunity for a choice on your part as a, quote, election, unquote. You can elect to treat a spouse, a non-resident spouse, as a resident on a 1040 return, for instance, under Section 60 14G, okay, or 6013G, okay. That sort of election really amounts to what we would call an election to public office. But that non-resident alien spouse technically must also be an officer in the government. Otherwise, they wouldn't be an individual because, as we said, all civil statutory law is law for government and not private persons. Because the very definition of private means beyond the control of government. And the civil statutes regulate and control, and therefore it could not possibly be private. And you get to choose what's private and what isn't private by virtue of what you consent to. It's always been that way, always will be that way. And any other method is just a devious way to steal from you. So for further information on this subject, see Flawed Tax Arguments, Form 08.004, Section 4. How else do we attack franchises? All franchise statutes are not positive law, and therefore are not admissible legal evidence of a liability on your specific part. They only acquire the, quote, force of law, unquote, by the consent of those already lawfully occupying a public office, as we just said. See 1 U.S.C. 204 for a list of titles of the U.S. Code that are not positive law. And those titles include Title 26, the Internal Revenue Code, the Social Security Act, Title 42, and the Military Draft, Title 50. All of those are franchises. And they attach to the status of being a statutory but not constitutional citizen under the franchise. Why? Because Congress can only legislate for people on its territory, and that territory is federal territory under the exclusive jurisdiction of the Congress and not a state government. Other ways to attack franchises. Here is the relevant content of 1 U.S.C. 204. Codes and supplements as evidence of the laws of the United States and the District of Columbia, citation of codes and supplements. in all courts, tribunals, and public offices of the United States, at home or abroad, of the District of Columbia, and of each state, territory, or insular possession. And that state they're talking about there is a federal territory or possession. They're not talking about constitutional state there. United States Code. The matter set forth in the edition of the Code of Laws of the United States, current at any time, shall be, together with the then current supplement, if any, establish prima facie the laws of the United States. Prima facie means presumed. In other words, the presumption of what the laws are, a representation. Technically, it's not the laws directly because the statutes at large are the only real law. And the U.S. Code is a codification of that law organized by subject. Okay, so technically it's not the real law. You have to go back to the statutes at large to see the real law. So it's just a presumed to be law is all. And it says, general and permanent in nature, in force on the day preceding the commencement of the session following the last session, the legislation of which is included. Provided, however, that whenever titles of such code shall have been enacted into positive law, the text thereof shall be legal evidence of the laws therein contained in all of the courts of the United States, the several states, and in the territories and insular possessions. So, in other words, it's not legal evidence of an obligation unless it's positive law. They can't use it in court. They can't quote it in court. And that's why the judge in federal tax trials will not allow anybody to invoke the franchise provisions of the Internal Revenue Code, Title 26, because it's not positive law. And we're not suggesting that it doesn't have the force of law for somebody, but that somebody does not include anybody in a state unless they're serving in a public office before they became a taxpayer. Prima facie means presumed. All presumption which prejudices constitutional rights is a violation of due process of law among those protected by the Constitution. And here's the definition from Blacks. Prima facie. At first sight, on first appearance, on the face of it, so far as can be judged from the first disclosure, presumably, a fact presumed to be true unless disproved by some evidence to the contrary. Okay, and we know all presumption is a violation of due process if it prejudices constitutional rights, and therefore it's not allowed. So anything that's prima facie cannot serve as evidence in a court unless you consent to it. Because you consent to everything. You can consent to everything. But you're an idiot if you do. You're an idiot if you consent to anything the government wants to do, because everything they do will always be about money, and they'll always want to steal from you, and they'll always want to make you a slave, and they'll never do what they're really created to do, which is protect private rights and simply leave you alone. That's all. And here's another authority on the subject, Black's Law Dictionary, 6th edition, page 500, under due process. If any question of fact or liability be conclusively presumed, rather than proven against him, this is not due process of law. In other words, it's the opposite of due process. If they presume anything, they're not only not giving you due process, they're giving you the opposite of due process. And the purpose of due process under the Fifth Amendment is to protect your right to not be stole from. So in effect, any case where there's not due process is an act of a theft or attempted theft on the part of a government actor. And that theft is always an act of a private individual for the purposes of personal gain. And it's not a government act at that point. And it's not protected by sovereign immunity at any level. Or at least shouldn't be. And here's another example from the American Jurisprudence 2D Legal Encyclopedia under Evidence, Section 181. A presumption is neither evidence nor a substitute for evidence. Properly used, the term presumption is a rule of law directing that if a party proves certain facts, that is, basic facts at a trial or hearing, the fact finder must also accept an additional fact, the presumed fact, as proven unless sufficient evidence is introduced tending to rebut the presumed fact. In a sense, therefore, a presumption is an inference which is a mandatory unless rebutted. Okay, so presumptions are only used to guide discovery. They do not act as evidence. They're not legal evidence of anything, and therefore anything that is not positive law is not evidence and creates no obligation on your part. That doesn't mean it couldn't have the force of law, but the only way it could acquire that force is with your consent. In the case of the Internal Revenue Code or most franchises, that consent comes in the form of lawfully being elected or appointed to a public office in the government, and through no other method. Why? Because as we said, in the case of Osborne Bank versus United States, the Supreme Court said that all the powers of the government, including the civil powers, are carried into operation by individual agency, either through the medium of public officers or through contracts made with private individuals. So, They can't reach you unless they can prove you have a contract with them, or they can prove that you're an officer of the government, which indirectly is also a contract because it's an employment contract. So either way, they need a contract or an agreement or consent in some form. Otherwise, they're engaging in a tort if they enforce anything against you, and especially if that thing they're enforcing is not positive law and is just simply a presumption. Because the Supreme Court said the ability to make presumptions is not a means of escape from constitutional restrictions, as we pointed out earlier. So what are your legal remedies? The following resources are available as legal remedies to protect you from unlawful franchise implementation and enforcement. Our litigation tools page on SEDM. We also have legal remedies that protect private rights course, Form 12.019. We have civil court remedies for sovereigns, taxation, litigation tool 10.002, available through our bookstore. We have federal jurisdiction, Form 05.018, and you can use this to challenge illegal enforcement actions outside of federal territory or outside the statutory United States. We have federal enforcement authority within states of the Union, Form 05.032, which does the same thing as a federal jurisdiction but has very detailed analysis. We have the Tax Fraud Prevention Manual, Form 06.008, as another form of legal remedy. So, in conclusion to this whole long presentation, we're sorry it was so long, but there was a lot of stuff to cover. We want to state the following and emphasize the following facts. Franchises destroy and undermine the two main foundations of the Constitution. They destroy equal protection and make the government a parens patriae. They replace rights that are equal with privileges that are unequal. And they destroy the separation of powers by making state officers into federal officers in violation of most state constitutions. See Government Conspiracy to Destroy the Separation of Powers, Form 05.023. Franchises are the main method used by government to unlawfully destroy and undermine private rights that they were created instead to protect. You can't protect something that you're trying to destroy or make a profit out of destroying. Now can you? Hello? And a government created to protect private rights that also makes a very profitable private de facto business corporation out of destroying, taxing, and regulating their exercise and converting them to public rights and privileges in the same geographic place has a criminal conflict of interest in violation of 18 U.S.C. 208, 28 U.S.C. 144, 28 U.S.C. 455, and many other federal statutes. And it is violating the legislative intent of the Constitution to protect private rights and leave you alone, as we said earlier. And is engaged in a conspiracy against your rights in criminal violation of 18 U.S.C. 241. And it is violating the separation of powers doctrine by enforcing outside of their own territory. They can't do that. That's international terrorism. That's a violation of Article 4, Section 4 of the Constitution to protect the states from invasion. How ironic it is that a national government that was created to protect the states from invasion has become its worst violators and its worst invaders. It's time they were fired. More conclusions. Most of what is wrong with America today can be traced to the illegal implementation of franchises within states of the Union by the federal government. Government-issued ID, such as driver's licenses, is the main method for illegally removing you from the protections of the Constitution and placing your legal domicile or your effective domicile on federal territory. How does it do that? It recruits you as a public officer of the government. The legal status required to procure it imposes duties upon the office you occupy and makes you surety for said office. Otherwise, the 13th Amendment made involuntary servitude prohibited everywhere, including federal territory. So they're holding a carrot in front of you, and if you bite the carrot, then you volunteered for the office. Even though you can't alienate that right, they're pretending like you are, and they're pretending like your right to contract is unlimited, including your right to contract a real government out of existence and make them into your employer, in the case of everybody. It's the government-issued ID is also the main method for illegally removing you from the protections of the Constitution because it kidnaps your legal identity and places it on federal territory instead of within the de jure constitutional but not statutory state. And it makes you a statutory but not constitutional U.S. citizen devoid of rights. and it compels the use of government identification numbers by those illegally eligible in order to procure the ID. You know, if you go into many DMV offices, they'll insist that you have to present a Social Security number to get the ID. Well, if you aren't eligible to either have or use the Social Security number because you're not a public officer, indirectly they're trying to engage you in a conspiracy to impersonate a public officer and to bribe them to treat you like one. You can't allow that. For details, see why domicile and becoming taxpayer require your consent. Form 05.002, Section 12. We prove all that as far as the government ID and how they kidnap you with it. Now, if you want to dig a little deeper, we have lots of resources. We have the Forms and Publications page, Section 6, talks about avoiding government franchises on our website. We have Government Institute of Slavery using franchises, Form 05.030, which is an exhaustive memorandum of law that is prepared to present even in a court of law to explain your position, and it explains how government abuses franchises to enslave and oppress those they are supposed to be protecting. It's a wonderful piece of evidence you can use in a court of law, and it contains evidence right out of the government's own mouth that they can't argue with. And if they argue with it, indirectly, they're calling themselves a liar. We also have an older book entitled A Treatise on Franchises, Form 06.033, and that's an exhaustive legal analysis of franchises. It contains 1,200 pages. Bookmarks are added, and text has been OCR'd to make it useful in your own litigation, so you can cut and paste from it. We also have Corporatization and Privatization of the Government, Form 05.024, and it contains proof, exhaustive proof, that what used to be government has become a private, for-profit corporation and not a real de jure government. Why? Because they don't even recognize private rights. They don't recognize a private citizen. And the only thing that they'll deal with, the only people they'll talk to, the only people they'll protect are people who sign up for an employee position called citizen and who consent to their franchises. And if you consent to one, you consent to them all, so you're just a whore. You know, take whatever you want. You know, you own everything. If I signed up for your goodies, that's how they treat you, is they own everything, and you're just property at that point. And your property, and once you become property, everything you own is property, because it's just held in the title of your name, but your name is property of the government, so they own it. Another thing you can use to prove for yourself what's here is the de facto government scam, Form 05.043. We show that there is no government left. If they won't recognize private rights, and that's the only reason they were even created, was to not only recognize but to protect those rights, we don't even have a government anymore. All we have is a big terrorist enterprise that's a corporation, in which basically, goes around the world stealing from people and lying to them with propaganda and not being accountable for those lies and pretending like they own everything. They're terrorists if they do that. On the other hand, if they recognize and protect private rights and enforce the requirement to prove that you converted those rights to public rights before they can steal or enforce obligations on you, then, and only then, are they acting like a real government. But they never do that. So they're not a government, because they don't do what governments are created to do, protect private rights only. They're actually what we call an anti-government, because they do the opposite. They destroy private rights instead of protect private rights, and they destroy them by converting them to public rights. And we said earlier that a private right and a constitutional right are created by God, and so God owns those rights. And indirectly, if they steal those private rights, indirectly they're stealing from God. They're stealing God's property. And they're not only stealing God's property, they're renting it out, because the charge to participate in the franchise is the rent on that property that they stole and that they're misrepresenting as their own property. And we also have Resignation of Compelled Social Security Trustee, Form 06.002, where we talk about how to lawfully quit the socialism franchise, Social Security. We also have Why Your Government is Either a Thief or You Are a Public Officer for Income Tax Purposes, Form 05.008. We prove that a taxpayer really is a public office in the government, and that's the only thing that it could be, and that there's no other rational conclusion about that. And that's just an offshoot of the other document we described earlier, entitled Why Statutory Civil Law is Law for Government and Not Private Persons, because Form 05.037. And so if all civil statutory law is law for government, and the tax laws are a type of civil statutory law, then the implication is that they too are only for public officers. And in fact, that's exactly how the code works. A trade or business is a public office. The tax is on the activity and the functions of the office and all property lawfully connected to the office. And it's a franchise or an excise tax on the activity and the revenue generated from the activity by the office, and so on. And lastly, we have proof that there is a straw man, Form 05.042. And that memorandum of law proves that franchises are the main vehicle by which the straw man is created, and it provides court admissible evidence of the existence of the straw man. And that straw man is, in fact and indeed, a public office in the government. And that straw man was created by civil statutory law by Uncle. And since it created the straw man, it owns the straw man and all who exercise the functions of the straw man, which they call a trade or business. On and on and on. All the dots connect. So if you want to get connected, here's some more resources. Family Guardian website is a sister site. We don't run that. We're not responsible for it, but there's lots of useful research information on there. And we have our website, sedm.org. You can also connect to We the People Foundation for Constitutional Education at givemeliberty.org. They have a lot of useful educational and political activism materials. You can also go to the following freedom websites, which in this list is by no means all-inclusive. USA the Republic, Show Me the Law, National Organization to Stop Socialism Now, no SSN. And we have legal research sources on our site as well. It's actually on the sister site, but we point to them. Legal research sources, this is a compilation of all local, municipal, state, federal, international law and reference materials. It's very complete, very useful. It's organized by source, so you can go to the various sources if you happen to have accounts on those sources. We also have the legal research DVD. If you want a very complete legal reference library on one DVD, includes all titles of the U.S. Code, regulations, organic documents, etc. You can order that through our bookstore. Cornell University Legal Information Institute has a really good library of all the U.S. Code. We use it all the time. It's free. The Electronic Code of Federal Regulations also has all the most current CFRs, Code of Federal Regulations. They don't have too many historical ones, though. Versus Law, which is case research and statute research, they are very low cost and affordable for people that are just starting out who don't practice law all the time. And Find Law, which is also free, but they flood you with a lot of advertisements. So what about us? What about Sovereignty, Education, and Defense Ministry? We were founded in 2003. We are a nonprofit Christian religious ministry. Our mission statement is found on the upper right corner of our opening page at sedm.org by clicking on About Us or About. You can read the whole story. Our Articles of Mission, Form 01.004, is available on our website. You can read all about what our goals and our missions are and our political positions on anything. We are managed by a board of ordained ministers. Our ministry offerings are completely consistent with materials found on the Family Guardian website. Educational and course materials are available only to members who must be non-residents and non-taxpayers, not engaged in the trade or business excise taxable franchise, and who believe in God. All educational materials are obtained online only, and a signed member agreement is required to join or obtain any ministry offerings through the bookstore. And we are based out of, but not domiciled or resident within, Canada. And we are outside the jurisdiction of the United States government, the civil jurisdiction. And we focus exclusively on human beings and not businesses. And you can visit our About Us page for further details on our ministry. And you can read our Frequently Asked Questions page, which answers most questions to or about us. So please go over that page carefully, because chances are whatever question you have has already been answered. We are not anti-government, but pro-self-government under the authority of God's laws. We are not anti-ruler, because we do insist on the rule of law, but that rule of law must be confined to the criminal laws, because God says we are not allowed to consent to the civil laws of any government, and therefore we can only be protected by the common law and the Constitution. And hence, for the purposes of civil enforcement, we have sovereign immunity. But we are not lawless, because we insist on the enforcement of the criminal laws. Not the quasi-criminal laws like the penal provisions of franchises, but real criminal laws. Like murder and assault and battery and all that other stuff. We're totally behind all that. So we're not lawless. And we're not anarchists even, because an anarchist is against all law. We're not against all law. We're just against corrupt rulers who would enforce the law for their own benefit. And all that conflict of interest is embodied in the civil laws themselves, which is why we won't consent to those, and why we don't have to consent to those, and why God says we're not allowed to choose a domicile and be protected by those civil laws. We are not tax protesters, tax deniers, or tax defiers, but rather a legal education and law enforcement ministry. And we enforce real law, not statutes or codes that are franchises, and which those franchises only acquire the force of law with consent. So we don't enforce those. And as a matter of fact, some people have tried to approach us and say, well, I need to know how to maximize my benefits under Social Security. And we'll tell them flat out, no, you don't want to be free. You want to serve another master. You want to fire God as your protector. And you want to receive handouts from Caesar. And you want to be owned by Caesar. So go worship your false god and leave us alone. That's what we'll tell them. You can't worship two masters. You can't worship God and Mammon, or God and Caesar, or God and money. You can't do it. It's one or the other. And if you worship God, then you cannot put God's law second. It has to be first, and it has to come before man's law. Or any invention or creation of man, including the civil law, especially. We do not offer any kind of investment or tax shelter or engage in any kind of commerce within the jurisdiction of the United States national government. We provide legal advice or representation. We do not provide legal advice or representation, but we do provide assistance of counsel. We do not allow our materials or services to be used for any unlawful or injurious purpose. We do not make legal determinations about your status. We do not market, advertise, or promote anything or pursue any commercial purpose. Our goals are exclusively moral and spiritual and not financial. We do not advertise. Once again, we do not interact directly with the IRS on your behalf as a enrolled agent or a representative of any kind, and especially not on an IRS power of attorney form, because at that point we're an agent of a public officer, and therefore we become an agent of a public officer. And once again, we can't contract with Caesar, and we can't exercise agency of Caesar, because that's what God's first commandment says in the Ten Commandments. You shall serve no other gods. And if you're a public officer for Caesar, then you're serving another god, because if Caesar has supernatural or powers above yours, he's another god. That's prohibited by the first commandment. And we do not offer asset protection, trusts, or corporation souls. We do not make promises or assurances about the effectiveness of our materials or information. We do not represent anyone using IRS 2848 power of attorney forms. We do not prepare or advise in the preparation of tax returns for others. Why? Because we're not a commercial ministry. We don't have an economic goal here. We only have spiritual goals. And if we had an economic goal, then we would be serving God and Mammon, and we would have a conflict of interest, and we probably wouldn't be telling you the truth, now would we? And you came here for the truth, so the only way you're going to get it is if you don't force us into commercial considerations or entice us to worship Caesar. We do not allow our materials or services to be used to interact with the government or legal profession on behalf of taxpayers, U.S. citizens, U.S. persons, U.S. residents, or any instrumentality of the federal government, including especially public officers. And we do not connect ourselves with a trade or business in the United States or any government franchise. We do not engage in factual or actionable speech. All of our offerings constitute religious beliefs and opinions that are not admissible as evidence, pursuant to the Federal Rules of Evidence, 610. Only you can make them admissible as evidence by signing them under penalty of perjury as part of an affidavit. And we do not advocate or endorse any of the flawed arguments identified by the courts in the following document, Flawed Tax Arguments to Avoid, Form 08.004. For rebutted false arguments against this ministry, see Policy Document, Rebutted False Arguments Against this website, Form 08.011. We go into exhaustive details rebutting any and every false, fraudulent, self-serving accusation of every scamster out there that works for the government and is receiving plunder from the government. There's lots of them because there's lots of plunder to distribute. But we rebut all of those false allegations. And if you, as the reader of this document or this website, do not rebut those rebuttals, then you agree with every one of them, because under Federal Rule of Civil Procedure 8b6, a failure to deny is an admission. And if you file a lawsuit and use any of the materials on this site and thereby subject yourself to the disclaimer in the process, because everything on the site is our property on loan to you and is protected by a franchise, if you use any of the content of this site against us, then you consent to all the franchise provisions in our disclaimer and our member agreement, and you consent to admit everything on our site into legal evidence, and you, under Federal Rule 31, Civil Rule 31, and you consent to identify all of it as truthful, accurate, and consistent with prevailing law, and the only thing you can argue with is that which you have individually proven with under penalty of perjury on the record with evidence, just like you'd force us to do. If you want to argue with our stuff, you simply have to prove it. And if you don't prove it with evidence and not presumption, then we are correct. SEDM educational curricula. We provide response letters, which are automated responses to common state and IRS tax collection notices. They require Microsoft Word to edit and assemble. See Federal Response Letters, Form 07.301. State Tax Response Letters, Form 07.201. We also have several electronic books. Tax Fraud Prevention Manual, Form 06.008, which describes how to protect your status as a non-taxpayer. We have a Non-Taxpayer's Audit Defense Manual, Form 06.011, how to deal with a tax audit as a non-taxpayer and a member. We don't recommend using any of our materials as a non-member or a taxpayer. Okay. We also have Sovereign Christian Marriage, Form 06.009, how to get married without a state license. Secrets of the Legal Industry, critical details on how to litigate in court for neophytes by Richard Cornforth. We have IRS Document 6209, how to decode your IRS tax records. We have the Social Security Policy Manual, Form 06.013, how to live without an SSN. We have Defending Your Right to Travel, Form 06.010, which is how to drive without state-issued license and without becoming a resident of the corporate state. And What Happened to Justice, Form 06.012, shows the corruption of our federal court system and how to destroy any civil or criminal prosecution by the government. We also have member subscriptions, which is a subscription service with premium content and services for those who are members. An annual subscription is recommended, and you can learn about that at that link. We also have several CD-ROMs, Liberty Library, which is a collection of free materials off the Family Guardian website for those who have slow dial-up internet connections. We have the Tax Deposition CD, Form 11.301, which contains questions to ask an IRS at the deposition. It includes extensive supporting evidence. And we have Highlights of the American Legal and Political History CD, Form 11.202, which is exhaustive history of the systematic corruption of our government and the legal systems from the foundation of this country. We have What Happened to Justice, Form 06.012, shows the corruption of our federal court system and how to destroy any civil or criminal prosecution by the government. We have DVD-ROMs, Legal Research DVD, Form 11.201, which is a very complete legal reference library on one DVD, includes all titles of the U.S. Code, regulations, organic documents, etc. We have the Family Guardian website in its entirety, Form 11.103, and that's really useful, very large too. We have the Sovereignty Research DVD, which is the entire SEDM website contents, including items available through, excluding items available through the Ministry Bookstore, plus IRS DVD from Family Guardian website. So we don't provide, once again, we emphasize, we do not provide any bookstore content or member subscription content on the Sovereignty Research DVD. You have to obtain that separately, okay? A lot of people ask us about that. We have DVD movies, How to Keep 100% of Your Earnings by Mark Lucas, Breaking the Invisible Shackles by Sherry Peel Jackson. We have legal pleadings that you can use in various situations. We also have individual master file, IMF decoding and rebuttal. We have the master file decoder standard, which decodes your IRS electronic records and finds illegal manipulations by the IRS. We have the professional version that not only decodes but provides supporting evidence and a reference library that goes with it. We have a full service IMF decoding for a single person and a married couple. We have Liberty University free curricula to teach you about law and freedom. There are several movies. There's federal and state tax withholding options for private employers, which shows you how to deal with withholding as a non-taxpayer. We have what to do when the IRS comes knocking, Form 09.002, how to handle a government tax investigation, audit, or raid, and much, much more. So what is our approach? There is much to know in order to effectively combat illegal activity of all kinds by the government, including illegal enforcement of the tax laws by the IRS. SEDM exists to provide educational materials that will help you get educated. And we won't fight the battle for you, but we provide tools to help you in your own fight to defend your rights as a non-taxpayer and a sovereign American national. We can only educate and equip people who consent to our member agreement and who are non-taxpayers and who are not U.S. citizens, U.S. persons, or U.S. residents, and who have no income connected to a trade or business in the District of Columbia, and who are domiciled outside of the federal United States or federal zone, and who have committed themselves to getting educated so the IRS can't exploit their ignorance to victimize them, and who do not have any contracts or employment with the federal government. Getting educated and being vigilant in defending your legal rights is the key to staying free and staying sovereign. We want to help you get educated, be self-governing, separate yourself from the government matrix. We as believers are the church, and everyone else is the state. And we seek separation of church and state. This concludes our presentation. If you have further questions, you're welcome to join our free member forums and become a basic member, which is also free, and to post your questions in the forums. But please, as we said before, post all your questions. First, read our frequently asked questions page in detail, and also the section in our member forums that talks about frequently asked questions before you submit yet another question or a duplicate question of that which has already been asked. Thank you so much for joining us and patiently listening to this very long presentation. We're sorry it's so long, but this is a very detailed subject. And we want to make sure you get a thorough treatment that is as simple and short as we could possibly make it. If you want to learn more about this subject, then please read a detailed memorandum of law on the same subject entitled Government Instituted Slavery Using Franchises, Form 05.030. Thank you, and God bless you all.